Distinguished guests, welcome to the SALGA's 4th Annual Local Government Labour Law Seminar. This year we meet under the banner of Sustaining an Effective Municipal Labour Relations System Beyond the COVID-19 Pandemic. This seminar builds on the issues emerging from our 2021 engagement, which saw delegates and stakeholders engaging with emerging trends, connecting with peers, discussing persistent challenges and aspects of labour law within the context of COVID-19. This year's themes touch on municipal perspectives and case law precedents relating to COVID-19 induced experiences, the evolving paradigm of SALGA support in the municipal labour relations environment, case law update and reflections, the emerging new normal in labour relations practice and practical experiences during local government salary and wage negotiations. So lean forward and clear all distractions. Your learning at SALGA's 4th Annual Local Government Labour Law Seminar is about to begin.
Good morning, ladies and gentlemen. It's an honor and a privilege to be here this morning. Welcome to the 4th Annual Local Government Labour Law Seminar. It's a great privilege, and we're going to have a great time today and tomorrow. So at this point in time, please allow me to welcome on stage our Chief Officer, Mr. Rio Noluchungu, please. So this is going to be an interesting day. We're going to be unpacking different issues, and it's just an honor to have a plethora of great speakers who will be sharing this podium. But I just want to say all of us must enjoy, even those who are joining us online. Please just have a great time, take your notes. Whatever question you note, please make sure that you forward it. We're going to have a great time. It's going to be interesting because for everyone, it's a good thing to come together and just go through different ideas and make sure that we make our municipalities sustainable. But not only that, but we become those type of people who are at the cutting edge of delivery. Thank you so much, ladies and gentlemen. Our CE is coming.
Let me start off by greeting all the delegates attending this important occasion from municipalities. It is indeed our honor and privilege to be once again presenting this very important program for the sector, and doing so at about the time we are busy managing the transition from the 2021 local government elections, which ushered into the local government systems the 5th local government administration. We are just concluding more or less 3 months of the new term of municipal councils. I think it would be amiss of me, as I welcome you delegates, not to give you a sense of the context under which this seminar is being convened, being the 4th iteration. The timing of the seminar is important because we usher in a new administration. For many of the councillors joining us for the next 2 days, who I'm sure are part of this important occasion, together with many municipal officials. This is one of the many learning and development engagements that are core to the support that SALGA offers municipalities, and it will be part of the ongoing engagements we will be having with you over the course of the next 5 years. Obviously, the same cannot be said of municipal officials who are obviously part of the system on a much more continuous basis compared to councillors who are elected for a period of 5 years. But having said that, we are also mindful of the fact that the councillors have a particular responsibility to fulfill in all of our municipalities, working closely with officials at the level of the administrations and working with them at also different levels. Some of the officials are in senior management, playing a much more closer working relationship with councillors, and some of the officials, very many in the sector, fulfill responsibilities that are in the domain of operational management, be it finance, be it infrastructure management, be it service delivery, be it water, and the list goes on and on. One thing is certain though, that for municipalities to work and work effectively, there has to be an ongoing working relationship that is maintained between elected officials and appointed officials. It is our collective responsibility as SALGA during this transition to ensure business continuity and seamless integration of new political leadership into their roles and across the structures of operation. We are very aware that out of the 9,473 newly elected councillors, the greater majority of those councillors are first-time councillors. So as we begin to usher in the new administration, we must also bring to bear instruments of support and capacity building on the part of that cohort, as I indicated, working very closely with the administration. As we know, the system of local government is very complex. It's a system where you find 257 municipal administrations who are in themselves individual employers, not similar to what you see at a national and provincial level, where the state is an employer. And this complexity also talks to how the labor relations environment is structured in our particular sector. But before I speak about those matters that are close to the subject matter of the seminar, allow me to take you through some of the elements of inheritance that the new leadership, politically speaking, is inheriting as it has assumed responsibility at about the middle to the end of November last year, which was the period where most of the first council meetings were held. The current leadership inherits a system where there is a multi-year agreement that has been concluded between SALGA and the two labor parties, Samoa and Imatu, a multi-year agreement that has been concluded under the auspices of the South African Local Government Bargaining Council. The new administration is obviously inheriting the first year implementation requirements of that agreement, with the second year of those implementation requirements coming on stream from the 1st of July 2022. And one wonders why I'm mentioning this multi-year agreement. It's important because it is one of the more significant developments that shape not just the stability of the sector, but also shapes very many relationships. Our relationships from a SALGA point of view as the employer body with the two admitted parties in the bargaining council. This agreement also shapes the nature of the relationships that municipalities as individual employers have with their employees, because it is through an agreement of this nature that municipalities are directed to pay levels of increases to employees which are set out in this agreement. And obviously, as you know, payment of salaries is one of the more contentious issues in our labor relations system. It's contentious because employees, like everyone in society, are confronted with cost of living pressures. And employees look to their unions who represent them to represent their needs in terms of how municipalities must seek to provide for not just budgetary, but also commitment undertakings to meet those needs that municipalities have to mitigate the impact of cost of living adjustments. And when those commitments are not made, and very often they are not made, it must be through a system of regulated deviations. And the exemptions application is one of those instruments that are available to municipalities to be able to get the authority to determine, to deviate from what has been agreed upon in the multi-agreement. The multi-agreement is also important for us because sometimes if the commitments that municipalities must meet in terms of this agreement are not met, it often results in an environment that is undesirable. Employees, quite rightly so, tend to be unhappy and tend to mobilize through their structures to make their voices heard. And this often happens to the detriment of the continuation of service delivery. And in some instances, it gives us a picture of local government that we don't like. A picture of labor, or rather of service delivery disruptions, often accompanied by acts of intimidation, violence, etc., etc. And I'm mentioning this to emphasize that as that agreement is being implemented and the second phase of it is being undertaken, it's important that councils pay particular attention to the obligations that municipalities have over the course of that agreement. And it starts with budget processes in municipalities, which are, to a large extent, they have gotten off the ground as we speak. The new administration also inherits a groundbreaking pension fund restructuring collective agreement. This collective agreement will give us some elements of transformational change which we have not yet witnessed in our local government system. And I'll summarize what those are. It will seek to reduce the number of pension funds in the sector to a number at least reasonably commensurate to the objectives that we have around uniformity, consolidation, as well as rationalization. It will also give us a very clear dispensation that as we are a sector that is not funded through the fiscus in as far as employee costs are concerned, that those costs are for the account of ratepayers, and therefore the responsibility of municipalities in their individual capacity. It's also important that we seek to cushion and insulate municipalities from underwriting responsibilities that are often associated with defined benefit funds. Defined benefit funds are those funds that if they do not meet their investment obligations and an actuary determines that there's been a funding deficit, municipalities have to make good on those funding liabilities. And the movement into defined contribution funds will usher in a dispensation in our sector where municipalities are completely insulated from the investment performance that you see in the various pension funds. This system will also allow opportunities for employees for the first time to institutionalize the freedom of association process, an opportunity for all municipal employees to decide whether they want to stay with the pension fund that they've historically been a member of, or they would want to exercise a switch being a decision to go to another pension fund that would have met the requirements of accreditation. So those are some of the things that are before us as the new administration starts, that are beginning to shape not just the structure, but also the landscape of labor relations as we've seen them in the sector since the local government system in its current form was introduced in 2000. So, bearing in mind the screenshot or the picture I have given you as to what are the elements of the industrial relations environment in local government are as the new administration begins, it's also important that we as SALGA step up our game in the midst of these changes. It's also important that we step up our game, also mindful of a very dynamically and fast-changing world of work that we see out there, affected by mainly the advent of the COVID-19 pandemic, which is a very strong theme of this seminar. Also affected by the very many changes you see that are influenced by jurisprudence, the nature of the court decisions that are taken from time to time that tell us which decisions we ought to be taking if we have not taken them, or we ought not to take in the domain of employment relations. And also that is a very strong element of the topics of this seminar over the day or two. But also, we also have to be able to step our game in view of the fact that the fourth industrial revolution may be magnified more by the COVID pandemic is also gaining in momentum. We also need to try and keep pace with those changes. We hear of concepts like remote working, which create different challenges to what we have seen before. And that is, how does a line manager or supervisor manage the productivity of an employee who is not in the workplace? As we know, traditionally, in the scheme of employment relations, you've always had an employer. You've always had an employee. You have always had work, meaning the task or the job that must be done. And you've always had a workplace, meaning the site at which the work must be done. And the fourth industrial revolution and the COVID pandemic has started to completely change the landscape of the workplace, because the workplace does not always materially to be a physical setting. The workplace is also a workplace in the context of your ability to work remotely and work through available systems and platforms for delivering outputs and productivity. And that is the virtual world, where a lot of technology that is cloud-based is being deployed. So this asks questions of us as, how can you make sure you can get the best out of employees as a supervisor, your employees that report to you, when those employees are physically not present in front of you. So in other words, the concept of managing results, the concept of managing outputs, the concept of managing outcomes without requiring employees to be physically next to you. Because in the old way of doing things, a lot of the focus in line manager-subordinate relationship was whether you are at work at 8 o'clock, why did you come at 8:30, why did you come at 11 o'clock when your starting time is 8 o'clock? So the world is suddenly saying, yes, that may be important in terms of protecting the integrity of discipline and operations in the organization. But when you do so, you must also create and effect a balance between presence of an employee, especially those whose jobs cannot be performed remotely, like refuse removal, and the requirements for those jobs that can be performed remotely for you to be able to manage outcomes and not manage presence. And I hope the delegates are starting to get familiar with the delineation between those concepts, managing productivity and managing presence or managing attendance. And even the domain of attendance and presence is also starting to take on a new meaning now, because presence may also mean being present at the point of connectivity when you're fulfilling your responsibility. So those are some of the questions that we are going to be grappling with during the course of the 2 days of the seminar. We will continue to place priority on locally based labor relations management improvements. We believe, rightly or wrongly, from a point of view of SALGA, that we've started improving the level of relationship between ourselves and union parties at a national level. But we want to see the same happening at a local level. And therefore, it is incumbent upon us to work with local leaders to be able to realize these objectives, especially in relation to an important instrument of employee relations that we created in the Bargaining Council through a collective agreement. And this animal is called the Local Labor Forum. We are seeing different signs of functionality in municipalities about the efficacy of the system, and we have to get to a point where we confront the elephant in the room. Are local labor forums working for us? Are they taking forward the ethos and ideals of the labor relations system that we want in the sector, as was espoused or as espoused in the white paper for local government? We also have to deal with disputes, because disputes are both a matter of process, they are both a matter of substance, but they are also a matter of relationships between employers and employees. Just as much as we have to deal with matters that continue to haunt us every day and every now and then when we begin starting a new term, task job evaluation, equal pay for equal work done. I think we need to start settling those things once and for all. As always, if I take the subject now to the seminar front, we have an amazing lineup of speakers, moderators, and panelists who will touch on an array of topics such as the repurposed labor relations support framework, which is for the benefit of municipalities, emerging jurisprudence, the impact of COVID-19 on labor relations, including vexing questions such as, is there space for mandatory vaccination, or is there space for an alternative dispensation? If so, what kind of dispensation would that be? Business continuity. We say we may be out of COVID, but the more you wake up every day in the morning, the more you see signs that COVID is ultimately not ultimately gone. And therefore, we need to work in an environment of business continuity that can tolerate the existence of the pandemic alongside us doing our work. We also have to deal with the welfare of employees. The employees in local government have also been negatively affected in many ways, not just by COVID, by a lot of uncertainties that have confronted them. Working with technology, and there's even more. Importantly, our partners from organized labor, Samoa and Imatu, with whom we continue to engage and collaborate on a range of matters before and outside the South African Local Government Bargaining Council. We also need to pay attention to that relationship and that partnership, as to not do so may take us back in respect of our aspirations going forward, especially when regard has to be had of the many changes and disruptions that are confronting us in our individual capacity as employers and employees, and also in respect of the footprint and landscape of labor relations as we become accustomed to for all of the years. And therefore, we must be mindful of these changes, and we must forge ahead with those partnerships, clear in our mind that ours is not only to protect the integrity of the local government industrial relations system, but to also help it respond to the emerging changes, which are being forced upon us, which we have no choice but to apply our minds as to the applicable approaches and interventions that we put in place. And it is therefore no coincidence that, as you see in the program today, we will have some messages of support from both SAMU and IMAT. On that note, delegates, I would like to welcome you once more to this seminar. Please make an effort, despite your disruptions at home, your disruptions at work, from wherever you may be connected, to stay the course of the seminar over the next 2 days. I hope you'll find it very exciting, beneficial, valuable, as well as instrumental in making you better fulfill your roles on the ground. Whether you are operating at the level of oversight and leadership, or whether you operate at the level of implementers as practitioners or as specialists. Program Director, I think it's time to hand over to you. And on the note I hand over to you, I'm quite confident that this is an amazing program that we'll offer to you from now on up until tomorrow. And once more, I welcome you, and the seminar is declared open. Thank you very much.
Thank you so much, Chief. At this point in time, ladies and gentlemen, allow me to go through the ground rules in terms of the 2 days. Please remember to complete the learner take-on form for CPD points through LG CETA. For Menti polls, a link will be posted in the chat. Seminar program is available in the chat. Presentations will be uploaded on SALGA app. To download the app, please scan this QR code now, or search for SALGA annual seminars in your app store on Android or iOS devices, please. Ladies and gentlemen, allow me at this point in time to introduce our next speaker. Advocate Cameron Silo Murajana. Advocate is a director of CCMA and a professor of practice at the UJ, and he is an advocate of High Court and is registered as a practicing advocate with Legal Practice Council, which is LPC. Advocate Murajana is an accomplished and seasoned executive leader with an extensive experience in corporate law, labor law, dispute resolution, dispute management and prevention, public sector, and organizational management. He holds B.Juris, LLB, LLM at UNISA, and AFSA diploma in ADR cum laude, postgraduate diploma in corporate law at UJ, and is currently pursuing his doctoral of law degree, which is LLD at UJ. Ladies and gentlemen, he's got a very rich profile. I won't be able to exhaust it, but please, let's put our hands together. Help me welcome Advocate Cameron Murajana, please.
Thank you, Rio. Good morning, everyone. I must acknowledge the Chief Executive Officer of SALGA, Mr. Kolele George. Must also acknowledge the chairperson of the working group, Ola Pagati, mayors, and delegates who've joined us online. This is a very interesting presentation that I have been invited to talk to. The good thing about this topic, that is the kind of topic which, in the main, is not based on research, is to tell you the experiences live on what we are dealing with when it comes to issues relating to COVID-19. So much has been read in the media about a number of aspects. And those aspects we want to give you the practical implication of those issues. I've noted that some of our speakers that will be coming and the topic that will be covered, I had to make an adjustment so that I don't steal their thunder. But one of the issues I will talk to briefly, even some of the cases that I was dealing with relating to COVID-19, particularly on this important question of mandatory vaccinations. This is not a lecture, neither is it a training session. We are being practical. I will raise very complex questions also along the process, which I think if I provoke them, it is the type of questions that I think the speakers that are coming, and as we deliberate throughout the conference, those are the matters that I believe you need to deal with, because they come from the trenches of practice. And over and above that, there are some elements of research which I will touch on where it is necessary. But I will give you enough scarf team to discuss, to move forward. And it is pleasing that the South African Local Government Bargaining Council is one of our accredited bargaining council. Therefore, the questions that I'll be dealing with and raising will be of critical importance. Just as we do so, you will see the aspects that I wish to cover. I will deal with the background. I will deal with the critical part, which I think is the most important part of this presentation, the CCMA approach to matters. I was really tempted to go into statutory interpretation to discuss some of the critical portions that comes from the instruments that we use to interpret and come to decisions. But I realized if I did that, then I will be having a conference, just me speaking. So I decided not to do so and resist the temptation. Once we've done that, then it gets to the turning point of my presentation, which is the challenges and experiences that we've had. These are the experiences that are not only experienced by me, sitting at the pinnacle of the organization as the director, but also those experiences which I've experienced in my capacity as an arbitrator and a conciliator, and also sharing some of those that some of my team members have experienced for you to munch on. And those questions that I'll be dealing with are going to be quite serious ones, because they are important for purposes of those that will be appearing in our institutions, to be appearing also at the bargaining councils, and those will be appearing on the labor court, because there are some of those questions that I'll be raising in the discussion. And then we'll discuss the future, how we see it as matters stand, for us to progress forward when it comes to this key question of mandatory vaccination and COVID-19 in general. Then we shall close. Now, I am quite mindful of the time that we're at when making this presentation, where there is this deceptive numbers that we see that suggests that the pandemic is over. Let's just have one matter, agree on, common cause issue. The pandemic is alive and it continues to infect. Therefore, the decision we make must not lose sight of that. So that is the background, and a starting point that I want to talk to. Now, the issue is about dispute resolution in this presentation, and I will focus my presentation to that. The critical point, which is important as we deal with the overview relating to mandatory vaccination, my mandate will be strictly to the mandatory vaccination and the cases relating to that and things that we've experienced beyond the cases. Now, I've dealt with the issues of the standards that we've set, and then let's go to the key issues. Firstly, what you see on the slide, it's actually, this is the broad legal framework within which we're operating in. One of the debates that we experienced was that when we're talking about the regulation of COVID-19, one important principle we must accept is that it is legislatively regulated. Legislatively regulated. Therefore, the decisions that we make, it must be decisions that are within the context and this broad framework within which we must see it. It will be clear as I proceed why this broad framework. One of the debates that we've seen, which was a key debate, but sometimes this type of debates, it's not just an exclusive preserve of lawyers, but also practitioners who are non-lawyers to understand these important principles that are involved. One of the things that has become a problem in resolving dispute relating COVID-19, it is because of the multiplicity of legislations that apply. Multiplicity of legislations. And it's not only about the issue of the multiplicity of legislations that apply, it is also about the different types of legislation that are involved. And let me give an example. In law, we talk about original legislations and subordinate legislations. Original legislations will be like your Disaster Management Act that applies to your Employment Equity Act, the basic conditions, and all of those. Those are important pieces of legislation. But when you look at the basic conditions, the Labor Relations Act, the Employment Equity Act, it'll give you a definition of what constitutes employment law. Therefore, when you're dealing with dispute resolution, our province of operation will be employment law. But as you will see in the presentation as we progress, that the way things have happened, it is not limited to employment law. It branched into Disaster Management Act. It branched into the regulations that were issued. And a new debate arose, which is part of the problem, that when you are finding yourself in a situation where there's multiplicity of legislation, therefore, in resolving dispute, there has to be a serious exercise of statutory interpretation. So the first challenge that I experienced in my cases, and some of our arbitrators faced, was number one, when representatives will come and argue a matter, you will find somebody coming to argue purely on the Labor Relations Act. That is completely incomplete, because you will never cover the subject of resolving a particular dispute if your province of operation is limited to employment law, because it's not. When you're dealing with Disaster Management Act, that's not an employment law legislation, it's outside that. So the type of exercise we had to employ is to understand how Disaster Management Act operates. Even the regulations that are issued in terms of it, in terms of Section 27, subsection 2, it is issued in terms of that. That is why, as you see in my slide, you'll find a portion that talks about subordinate legislation. It is because the operation in the form of regulations and the directions that were issued are quite critical to resolve the dispute. If you want to understand how to make a policy relation to mandatory vaccination, you will not necessarily find that in the Disaster Management Act. You will find it in the directions that are issued in terms of a regulation, which is a subordinate legislation of Disaster Management Act, which is the original legislation. So you see that the spectrum, the conspectus of statutory laws you need to understand to be able to effectively argue that it is that package. It is disconcerting if you find a representative that comes and wants to argue about whether mandatory vaccination was done correctly or incorrectly, but they only argue on the basis of Labor Relations Act. It's a shortcoming. It's incomplete. Therefore, the submission I'm making in this slide, you will see the impact of this package in the points I'm going to present and the shortcomings it created and how it influences the decisions that we make as arbitrators. It's quite important. So in short, one, it's a multiplicity of legislations. Two, it's not limited to employment law. Three, it's original and subordinate legislation. That is the package that you need to get and have whenever you appear in front of a commissioner to argue these matters. That is important. You will see what the impact of that is in the points that we're going to discuss. This is an important introductory portion also of this discussion. If you look at the roadmap, what transpired when this dispute of COVID-19 started, one of the first things that we did, that each and every case that is referred to the CCMA, which has to do with COVID-19 and mandatory vaccination, it had to be centralized in the office of the director. We called it redlining a case. Redlining a case. Redlining because there were serious legal and constitutional questions that had to be determined for us to resolve that dispute. So we redlined them. Each and every one, as and when they came, wherever in the province the matter is presented, it was elevated to be redlined. Redlining also means that we choose exactly who must preside on the case, because it's based on experience, in terms of all those kind of skills, to make sure that when we sit in these cases, we make sure that we resolve it. Part of the reason why we redline them, it is because it is not just domestic questions that relates to COVID-19. It is issues of national and international problem. Therefore, you had to get the best possible expertise to deal with those matters. That's why these cases were redlined. That's what redlining means in that context. Now, over and above that, we established a task team that will deal with all these vexed and complex questions in us guiding our commissioners on how to deal with COVID-19 relating cases. You will see that the problems that we have are not only issues that are limited to mandatory vaccinations, they expand beyond that. It's not just about mandatory vaccination. It is also the confusion that has arisen because of certain terminologies that were borrowed between the different processes, which created additional problems, which I will deal with later. So that task team was there to deal with those issues that are important. Additional to that, it was a matter of consultations and engagement. That is a very important issue. As you can see that we're mentioning Professor Gray there, because one of the things which I will deal with in the presentation is that when you're dealing with the issue of COVID-19 and its impact, especially when you're talking about that important process of risk assessment, you do need assistance from the experts to guide you about which approach to take and what decisions to make at workplace level. You cannot be able to resolve effectively or rush to a COVID-19 mandatory policy without a properly executed risk assessment report or done in the workplace, because that tells you what your staff is like. That tells you the wellness in your staff. In my discussions with Professor Gray, one of the critical things that she emphasized was that it is very important these days, in this time of COVID-19, that you must understand your workplace. You must understand the state of wellness of your staff. There's two items that she mentioned which are critical, which creates, in terms of the direction, what you call the vulnerable employees. TB and HIV, she said. That if you've got staff where these two illnesses are high, and those two vulnerable employees contract COVID-19, they are most likely to die of COVID-19 because they are compromised. So when you conduct your risk assessment, as part of that process is to identify through proper statistics about the wellness or the state of wellness of your staff. So my purpose of that consultation was to have an understanding of those, that you cannot have an effective risk assessment report that does not give you that specific component. You can talk about the classification of the functions in your workplace. You can talk about the workflow or the floor plans that you have. You can talk about ventilation. You can talk about all of those things, sanitization. You can talk about all of those things. But if your report does not contain a proper wellness report that tells you about how your staff is doing in terms of wellness, you are missing the point. It's incomplete because it influences the decisions you must make. Part of the intention why I engaged Professor Gray and other experts, it's because when you're dealing with a COVID-19 case, You've got to understand the impact of COVID and in how it works and how it behaves. And also to understand that it's important because there are many theories, social media, and things that are shared on WhatsApps about COVID-19 is an experiment. COVID-19, they inject in you some metal which detects you, whereas they got tracers. All those theories are operating in our environment. Therefore, you need an expert to tell you that when you are talking about COVID-19 and its impact, this is what it means. One of the things that you see in our awards, which is the cases that I was doing, that I was chasing, is to find a good case and have experts testifying in a case through evidence on oath and tell us about what the COVID-19 is and what COVID-19 is about. One of the things that I've identified in that process of discussing with Professor Gray and other experts is that even those that appear before us, when you ask them, what is a COVID-19 vaccine? Some even struggle to tell you what it is, but they can tell you how bad it is, but they don't know exactly what it is. When you go to the directions, it defines it. It defines what COVID-19 vaccine is. And in the process, therefore, of your engagement and debating the case, you've got to carry that definitions through because it helps you how you argue in favor or against. We have at the CCMA what we call a case law monitor. A case law monitor is a session where we share the latest cases that are decided. And one of which that we held recently was the one relating to mandatory vaccination and COVID-19 related cases, so that we can discuss these key legal principles on how the commissioner should approach and understand in dealing with COVID-19 related cases. So we conducted that. Over and above that is the issue of monitoring the cases as and when they happen and reporting about its referrals and the statistics. And I'm sure that Dr. Kohlrabi, when she presents, she'll probably touch on that. I don't want to deal with that. Yes, it is correct that as matters stand, now we have 4 arbitration awards that have been issued, which I will touch on in passing, but Dr. Kohlrabi will be presenting, so she will give you the details in as far as that matter is concerned. So generally, these are the statistics that you see of the cases we're dealing with. You will see that on mandatory vaccination, as from last week, we were sitting at 327 cases just on mandatory vaccinations. It's not about the rest of the cases, just on mandates. This is the number of cases that we're dealing with. Some of the outcomes that have become a problem, I will touch on as part of my presentation. Now, I've touched on this, and I will expand on it as I proceed. These are the cases, some of them, and I will not go into the detail because Dr. Kohlrabi, I saw in the program, she'll be dealing with that, so I won't. But I want to share some of the things in the case that I did, which is partly of the case that I was involved in, and I'm sure you've seen that in the news, the Duncan Kohlrabi case. Just to share some of the sentiments, not about the outcomes and what happened. I think that is of public knowledge. And some of you may have seen that with the award that we've issued in this case, Duncan has gone into the media saying CCMA is corrupt and I'm not happy with the outcome and all of those kinds of things. There are very complex questions that arose in this case. And I will touch on them and raise the questions in my presentation. When this case was referred, Duncan Kohlrabi, who is an article clerk or a candidate attorney in that law firm, he was one of the 9, I think, employees who are in that workplace, and it's a law firm. The principal of that case had a very dangerous disease called the Addison's disease. And it was acknowledged and not disputed that if he got COVID-19, he would have died. The rest of the employees in his practice were vaccinated, except him. He refused. His refusal, through the WhatsApp communications that they had, he ended up being dismissed. And when he dismissed, then he referred the case to us and said, this is unfair dismissal. What was interesting in this referral, he referred it in terms of section 187 of the LRA, which is the automatically unfair dismissal. Effectively what that meant is that if after consultation we could not deal with the case because it is a labor court matter, because that's where it must be dealt with. But during the engagements you can tell, which is some of the aspects I'll deal with, that it was not so much about the refusal, it is because of the relationship issue that has arisen. Part of the complex question that arose is that if I enter into a contract of articles and it is meant to be for 5 years, and I do the law school, which effectively should make you do 1 year of articles, he claimed damages for the entire 5 years. That I want to be, in fact, damage must be paid because my contract was terminated as contracted by the Legal Practice Council. In the engagements, he raised interesting constitutional questions. When you read the directions, you will see that one of the things that we're expected to do as an employer, when an employee raises constitutional defenses, they say you must deal with them. But what is missing from that question is how to deal with constitutional defenses. And he raised them. The right to custom, the right to religion, freedom of expression, and in relation to the bodily integrity. He raised those questions. But interestingly, which I will talk about, Section 141, we had to agree that, look, if you want to proceed with your damages claim, the CCMA on Labor Relations Act matters. We don't have jurisdiction to deal with damages. We can only talk damages if it is within the purview of the Employment Equity Act. A lot of time was spent in trying to convince him to understand that, because we were driven by this Sakau judgment that says to us, it is wrong for us as arbitrators, when an issue is raised, which on the face of it excludes our jurisdiction, we must not be quick to kick the matter for touch because we think we don't have jurisdiction. There's a judgment to that effect. That says we must spend time and ensure that we deal with the dispute and resolve it because we're a dispute resolution institution. So we explained the different aspects of unfair dismissal versus unlawful dismissals, the issue of automatically unfair versus the issue of unfair dismissals. After some time, Mr. Kohlrabi decided that, look, I want this matter finished. So I'm going to agree and consent to your jurisdiction, which is now in terms of Section 141, which we did, right? Now, because of the toxic relationship and the way things have been unfolding and the way it was done, the case up to the point of dismissal, Mr. Kohlrabi finally said, no, I'm withdrawing my consent. Now we got stuck. How do we move with the matter? Because we can't move forward without consent of both parties if the matter is beyond our jurisdiction. But eventually, fortunately, the applicant decided to pursue unfair dismissals. So we had jurisdiction to deal with the matter. But the problem that we experienced there is the complex question that arose, which makes it difficult to resolve the dispute. Because the CCMA cannot declare anything to be unconstitutional because that's the terrain of the Constitutional Court and the High Court. So it got that complicated. The emotions were very high. In fact, the way the matter was referred, that he submitted his statement of case even before the matter started, it adopted a very litigious approach in dealing with the matter. But eventually, when we made the finding that the dismissal is fair on substantive grounds, but it was unfair on procedural ground, and then I'm sure you saw an article that he sent to the media saying that the CCMA is corrupt, therefore is going to attack or challenge us on the basis of that. That's okay. But I'll deal with the other aspect, the constitutional issue, at the later stage, which arose in that case. Now, here's what is critical arising out of that and other cases. Number one, most of the cases that we dealt with, I think I dealt about 5 cases or so, Asanda. All of them were settled. And this is the challenge that is faced by other commissioners as well, that matters get settled. Now, the question I'm asking myself is, why? If the issue of mandates and the issue relating to dismissal is such a serious issue, how does it happen that the majority of the cases we deal with get settled? You may be surprised why you have 327 cases but you only have 4 awards. It's because we run into those issues. Some of the aspects that I will share with you on relationship and other things, some of the challenges, I'll expand more on that. But I want you to note for the purpose of this presentation that most of the cases that we dealt with are matters that are settled. And in that settlement, it is largely on financial terms. It's rare, 1 or 2 cases you find in that settlement that it's based on reinstatement or re-employment. And part of the reason, which I will talk about later, It's because as at the time the parties get to the arbitration, the relationships are broken. And you will also note in some of the points I will make that as you do that, and the relationship that the parties had before the mandatory vaccination issue, it was a brilliant relationship. As far as the cases that I did, the relationship were very well. Until a policy on mandate is done, then the daggers are thrown. They can hardly even sit in the same room. And that's why you find somebody saying, you know what, I've had it. Just given a settlement, I just don't want to be with him anymore, I'm done. And some of the things which I can't share, which I hear when you sit on a separate caucus to understand what motivates it, some of which are very sad, some of which has to do with mental wellness, which I think is a good thing, because I saw in the program that one of the subjects dealing about the issues of mental wellness, it's very, very critical in that conversation. Mental wellness issue. I'll expand on that later. But the important point on this slide is that settlements are leading at the moment. One of the arguments is that once settlement is made, it means that's another dismissal. That's the end of another employment. When you see the statistics that we're talking about of unemployment, it's contributed also by that. But you can't do anything else if parties say, this is the settlement, it has to do with money. Related to what I just said, it is the issue of relationship. There's a case I dealt with which had to do with an oral hygienist. Oral hygienist, by its very nature, it is about hygiene. It's about health, it's about safety, it's about all of those kinds of things. This person is the person that stands in front of you, open your mouth, let me deal with issues of hygiene in general. So when you introduce the subject of occupational health and safety, it's critical. But the problem with this one is it was not so much about the dismissal of the oral hygienist, it is how she was treated towards the dismissal. I have really no serious issue with dismissal. It's how I was treated when this issue was conducted. It is common cause, colleagues, that if you want to have a mandatory policy, it's just a few steps that we have to do. You know, I was sitting at a restaurant, I won't mention the name. Next to me, there was two gentlemen who I was having a discussion about the very same issue. It's nice when people don't know who you are, but they can just speak, right? So I'm sitting there and they're saying, okay, you know this thing about mandatory vaccinations. If you want to get rid of your employees, it's very easy. You just formally follow the steps that are contained in the directions you are done, which means conduct your risk assessment. Once you've done so, conduct consultations and do your mandatory policy. Once you've done so, engage on it, called consultation. Once they raise objections, note them. If they raise constitution, note them. If they bring medical reports, challenge them and take them to another doctor for you to get your own medical report, depending on your outcome. Once you've done so, then instruct that they must vaccinate, by instruction, not a proper engagement. If they refuse, fire them. And when you fire them, you've met the requirements of law. That's how bad it has gotten. I'm sitting there, I lost concentration in what I was doing because, there's no cover to the ears. I'm sitting there itching if I can engage into the conversation, because that is a completely unconstitutional attitude that we must never have. That is offending the values of our Constitution. That approach is very offensive to the very foundation of our Labor Relations Act in terms of this important principle of social justice. That you can spend time and energy to find a way how to easily dismiss based on this important issue of vaccination and COVID-19. That is a problem. I decided to walk from the restaurant. I could not handle the conversation because that is not the conversation we should be having. You see, I'll deal with the issue of accommodation, which is in the direction, because what it requires in all the efforts, in all the decisions that we must make, we must find a way to accommodate. Accommodation is the critical principle. If we miss that and adopt that type of bellicose attitude, which is unconstitutional, that's why we're having this mounting number of cases that we're dealing with. The other alternative, which now people are adopting, is if he doesn't agree, retrench him, because then it's an operational requirement issue. It's no longer an issue of instruction, because there's that issue of conflation. I'll talk about it in terms of the principles. Retrenching, because you see, when it comes to operational requirements, the employer has power. Because all you need to do is to issue a notice in terms of Section 189.3, and then you engage and you look at mitigation or ways to, and then the process is done, and then you dismiss, and that's it. That's it. You can retrench one employee. It doesn't have to be a group. Now, those strategies are adopted as a way to deal with it. That's not the way we should be doing. You see, there's a Constitutional Court judgment of Nehau versus University of Cape Town. The Constitutional Court in that case confirmed that the foundation of the Labour Relations Act is job security. Job security. That's the foundation of the LRA. Why would we then take decisions that offend that important principle? Is the question. Now, here's what is important. And then a very good example is the very issue of the Section 189 I spoke about. Some of you know that the issue of procedural fairness, and in COVID-19 case, is critical, but there's two parts there. It's the procedure you follow to do risk assessment, to do your mandatory policy, to deal with the objections that are raised. It's all procedural issues, right? But there's an additional arm to that procedure. Once you've made your policy and there's no compliance with it, or there's an instruction issued in terms of that policy, there is a specific procedure you must follow if the instruction is not followed, or if the instruction is not carried out, or if there is a non-compliance with the policy. That is an additional element to the broader procedural requirements. But here's what is always misunderstood, and especially on COVID-19 cases, that if you frustrate procedure, it will eat on substantive fairness. If you frustrate procedure, it eats on substantive fairness. I'll give an example. If in the dealing of retrenchment, for example, and it requires that you must consult, Section 189, subsection 3, you consult on alternatives, you consult on ways to avoid retrenchment, you consult on how to mitigate on retrenchment in case you can't avoid it. If that procedure is not followed, it means the engagement that we ought to have had about how to avoid retrenchment, the engagement we would have had to avoid the substantive unfairness happens because you've missed the contribution you get from procedural fairness. That's the problem. The same principle applies when you deal with COVID-19 cases. We've got to find a way to accommodate that in that equation. It's very important. So one of the biggest fights we've had and have been having in the course of that conversation is that the employer did not follow the correct procedure in engaging with me in as far as the risk assessment is concerned, the mandatory policy is concerned, and also the discipline part of the process. That's the experience that we've had in that conversation. In addition to that, it's also the conflation of issues. Here's an interesting question. So some of the cases, when I sat there in the case and this person says, well, Commissioner, I'm not sure exactly I'm here. Is it because I violated the occupational health and safety, or did I violate the mandatory policy, or did I commit a misconduct? You need to have a clear delineation of what the actual issue is before you. So if there's an instruction which was issued that says you will vaccinate and you don't, you are charged with insubordination, which becomes a misconduct case. But others are arguing misconduct. Then I wonder, how is it a misconduct? An issue of incapacity. The policies in the main that we find also that people are arguing and debating about, they're undocumented. Somebody said, well, I do have a policy, so where is it? No, we've discussed it, and they produce emails in different parts of the emails. This is the policy. It becomes difficult when you have to debate and argue about a policy which is undocumented. I've touched on the issue of consultation, which is important. And critical for this conversation, consultation shall mean that consultation on the policy, consultation on the issue relating to the policy itself, the risk assessment, and part of the squabbles that we've had where you spend most of the time is not on the substance, but that there was no consultation that was conducted in delivering that. I don't have time to talk about the case in Solidarity, but one of the issues that worries me about the issue of Solidarity case, that the way it is being discussed as if the court decided on the issue of mandatory vaccination. It didn't. If you look at paragraph 48 of the judgment, you'll see that the court clarifies it. This is not about the mandatory vaccination policy, or not even about reasonableness and fairness about it. It is about admission policy and debating about unlawfulness. It does not resolve the issue. Yes, in passing it's being discussed, but it does not resolve the principal issue. I'm not sure why it was so much on WhatsApp, people discussing about it, that there's a key judgment on mandatory vaccine. I don't know why. It's a good case, yes, but for me, if you look at the value of the judgment, it camouflages actually the mandatory vaccination, because it requires that you must have the certificate, you must also show the results, and therefore if you not, then you get dismissed or get excluded. But the finding is not there. That is a dictum issue in my view. I've spoken about the issue of the interpretation. In the entire spectrum of what we have, really boils down to the interpretation of the legal instruments, because that's what it boils down to in the end. Yes, it is true. Part of the problem I've had in the cases I've dealt with is parties coming unprepared. You can't come on such an important subject and come unprepared. It's just uncalled for. Some don't even know that directions exist. And how can you even argue about its content if you don't even know it exists? Yes, the parties are deeply aggrieved. I've touched on that issue, that the relationship and the wellness issue is central to that. I want to explain this important principle, because somebody said, yeah, I see that the CCMA issues different awards or conflicting awards. There's nothing wrong with that in law. We can, as a commission, or with different commissioners sitting on the same issue, coming to different conclusions. A commissioner is not bound by the award done by another commissioner. It's not. We are bound to follow the Labour Court, the Labour Appeal Court, and also the Constitutional Court on what is decided. But you can have two different outcomes coming from the CCMA, from two different awards of the commissioner. It is important. I don't have time to debate this issue, but I wanted to raise very serious constitutional issues here on the jurisdictional debate, because during the arbitration process, you find parties raising questions of jurisdiction in as far as the constitutional defenses that are raised by parties. You see, the directions talk about that you must deal with the, constitutional questions that are raised. The question, what does dealing mean? For me, if there's no engagement on the important part of the Constitution, Section 36, Section 39, and the exercise to test whether the limitations of the human rights of the person before you, it is justified, it is a constitutional process. But you can't just note that you've raised a constitutional defense and move on as if it was never raised. Then there's no point even of raising it, because it is of no effect. It's not executed. Why raise it if you can't engage in it? The role of expert witness, in the case I'll be doing, I will be having an expert witness, like I said, so that we can deal with this part of perception as defined also in the directions. I think that will be very helpful. I'm trying to rush. I think I have 5 minutes to finish. Now, the whole exercise of mandate, I wanted to expand on this question. At the end of the day, it's not about who's wrong and who's right. That's not the issue. It's not even about the law. It's about health and safety. One of the challenges we faced when you've got aggrieved parties and people who are gripped by fear of dismissal, fear of death through COVID, is the balancing of interest of the employer and the employee. It's not an exercise that is easy to do, especially when parties are angry with the manner in which the process was conducted. This I want to say with passion. Whenever there's issue with regards to COVID and mandatory vaccination cases and COVID-19 in general, when we make decisions, we should not be trigger happy. We shouldn't be trigger happy that I've complied formally, therefore you're dismissed. Let's not do that. Accommodation, that's the spirit that is promoted by the directions and the regulations. That's the approach we must adopt. It will make our job easier. Now, the issue of accommodation, I've spoken about that. This is where we should be spending more time, more than anything else. How to accommodate the objections and issues, health and safety issues that arise in that conversation. The characterization I spoke about. The legislative interplay, I've touched on it. I don't have time to go into the detail. When it comes to enforcement of what we're talking about, it's not just the issue of the CCMA. We've got the Department of Labor, we've got Department of Health, the Department of Employment and Labor. These are different departments that are enforcing. Sometimes parties get confused on if there's no compliance. Is it an issue on enforcement through the department? Is it an issue that I must refer a case on? Is it an issue of employment equity? This is another confusion that you assist and educate parties during the time when you're discussing those issues. So what is the future? In short, one, at all times when we're dealing with the case relating to COVID, understand at what state of the COVID are we at, because context is important. How many people are dying? How many people are infected per day? Are we in a particular wave? At what adjusted level are we at? Then you can understand, including the international context. So that's very important. Secondly, as the Commission for Conciliation, Mediation and Arbitration, and as a mediator at heart, I strongly recommend, instead of litigation, let's mediate this type of disputes. Let's try to find one another instead of fighting about it and finding who's right and who's wrong, who's winning and who's not. That's not the issue. That's not what it's about. The real mischief of the entire conspectus of legislation, it's about health and safety. So we've got to find a way to do that. In the end, in what I've just said, as the CCMA, we've got a product that we call workplace mediation. Is what we're going to strongly advocate, because that's the best way to resolve the type of problem that we have. But in the end, it's about that. It's about the prevention and the combating of the spread of COVID-19. That's what it's about. It's not about anything else. Thank you very much. Did I finish on time?
Thank you so much. I thought that was very refreshing and very important, just to ensure that we are all aware about these changes that are taking place. Ladies and gentlemen, allow me to welcome on stage the message of support from organized labor. Allow me to welcome Mr. Tumsan Makakula, who's the General Secretary of Samoa.
Good morning, everyone. I'm not used to standing up without a song. and it's for two reasons. In my two worlds where I operate, whenever I have to stand, there will be a song, Yomzabalazo in the trade union, and a song of praise in the church. Okay. So here it's all silent. I believe you are singing in your heart, I take it. Thank you for the opportunity, and on behalf of SAMU, I understand that the presentation is not necessarily going to be flighted, which gives me leeway to start wherever I want to and to speak from my heart. We appreciate the invitation from SALGA, and we bring from SAMU appreciation because we see that our relationship is growing and deepening, and we know that it is for a good purpose, because we stand at all times at a juncture where we need a balance between our conflicting interests as the employer and employees. And I must say special greetings to the colleagues who sit with us, more especially at the negotiation table, in the form of Comrade Rio. Don't worry when I call him Comrade Rio. He's not captured. Very difficult to capture that one. Very difficult. You have a hard negotiator there. And Comrade Zwe, Comrade Johan, and all the other colleagues, we appreciate. We have been asked to give our input on how we view the relationship with SALGA in order to contribute towards labor peace in the local government. Maybe before I proceed, I will not ignore that Johan is also here from Imadu. Me and Johan play in the same team, but we play different positions. And sometimes we fight for the same position. And how we view our relationship with SALGA, I will start right at the end and answer the question in this manner. We view the relationship with SALGA with high importance, and we believe that as employer body, SALGA should continue to play a vital role in striking the balance between our conflicting interests by promoting collective bargaining. And we believe that SALGA should also impress it upon municipalities, because SALGA organizes municipalities and represents and lobbies within the municipalities, that it is necessary for SALGA to impress upon municipalities this very important view that trade unions are equal partners in leading to viable municipalities and improving service delivery. So that's how we view SALGA, a very important partner in the struggle. Not only struggle for benefits to employees and for rights of employees, but in the struggle to make municipalities viable, to make the workplace viable, and to improve service delivery. There is one word which troubled us in preparation that says toward labor peace. It's a very difficult concept to unravel, but we have looked at it in this manner. Maybe we would prefer to call it good labor relations. We are not too sure about labor peace because the harmony that we want is not only amongst labor, but it's harmony between the employer and the employees. That's why we would prefer to call it good labor relations. Conflict in the workplace is inherent, and this we see by the number of disputes at the labor court, the setting up of dispute resolution bodies like the CCMA, which are established exclusively for litigation and for labor matters. And this bears testament that conflict in the workplace is inherent between the employers and the employees. However, we would want to see good labor relations. And good labor relations is essential to achieve labor peace or workplace harmony, and entails the balancing between the different competing interests. There will always be continuous views on why we all find ourselves at a workplace. The employer could be that they want business viability and productivity, but at the end of the day, it is also for the same reasons that employees are there. But what will come to the fore for the employees is my salary, my benefits, my material interests. But good labor relations would ensure that there is business viability and continuous productivity, and in our case in the local government, continuous service delivery to the communities. While on the other hand, bad labor relations could result in a situation where there are perpetual conflicts and disputes between the employer and the employees, and mark perpetual, because at times we may believe that we have come to a situation where there are no matters, but it could just be that there are no matters at a national level, but in one municipality at a certain corner of the country, there could be disputes raging, and there could be matters of strikes. In fact, in the 2 years that I've been in the national office of SAMU, there isn't a week where there is no strike within municipalities. Strikes might only be localized at municipalities. They might be localized within some units in the municipalities. There might be strikes at the provincial level and strikes at national level. But there is no point where all these conflicts usually lead to labor unrest. And this will always result in lost hours, loss of production, poor service delivery to our communities. And in extreme cases, which is something that we always need to impress upon the employer, in extreme cases, this results and leads to infiltration, it leads to sabotage, damage to property, and sometimes even human casualties. And more so in our sector, the local government, which is a highly contested terrain. Maybe something that in confidence we need to share with the employer at a forum like this is that during protracted actions and strikes, there's a lot of things that are not in control of union leadership, because our strikes take place within communities where there are already strifes and interests to infiltrate and interests to sabotage. And it is very necessary that we block that opportunity from the level of good collective bargaining and from the level of engagement. So what is necessary is to always strike the balance. And this is inevitable, that we strike the balance between our competing interests and ensure that the local government sector is viable and there is labor peace or workplace harmony. It's very important to safeguard the sector, more especially giving thought and serious consideration to the fact that labor is a powerful component and has the potential to alter the course of national politics. I'm sure that you have seen the results or the outcomes of the local government elections. And in our own analysis, in all the municipalities where there's been mass dismissals, politics changed in that municipality. Those municipalities are no longer led by the same political party because of mass dismissals, because of worker-related issues. And if we are not taking care of that space, it will come to where there is instability and, of course, the nature and the outlook of local government will be changed. So, together with SALGA, we have to promote collective bargaining. Both the employer and the employees need to respect the workers' forums, the local labor forum, the bargaining at the divisional councils, and the bargaining at the central council. And all of these are established by the Labor Relations Act. And these forums provide communication, they provide engagement, and they also provide means for collective bargaining between employees and employers. We have a role together. Besides collective bargaining, we have a role of governance over dispute resolution. And through the established bargaining council, and in our case, the South African Local Government Bargaining Council, both trade union and employer play a governance role over dispute resolution. An emphasis being on the trade unions and the employer. I think the attitude, everyone's attitude has to change around what the bargaining council is. The team that sits in the bargaining council is well aware of what the bargaining council is, but you find municipalities that think that the bargaining council is SALGA. In their correspondences, whenever they want to refer to the SALGPC, they go for the shorter route and the most convenient SALGA. And usually, Zwe would say, no, this isn't speaking to the bargaining council. We need to correct. But I think this has to be highlighted to say the bargaining council is a component of both labor and employer. And in that component, we deal with collective bargaining, and we also deal with governing. We don't determine and resolve disputes, but we govern the system for dispute resolution. And towards the end, we have also established, which highlights the important role of collaboration. We have also established a means to deal with matters that are beyond normal. And we take the case, for example, of COVID-19. When we first heard about the pandemic, none of us knew where this is going. None of us knew what it meant. But together with SALGA, we were able to go out and bring the awareness to employees, both the employer and the employees, the trade unions, going out to employees and making them aware of what COVID-19 is, what are the regulations, and how to keep safe during that difficult time. But with the interest at the back to make sure that service delivery does not stop even during the period of the COVID-19. And lastly, to repeat the first point, we view SALGA's role as a vital role in striking the balance between our conflicting interests and promoting collective bargaining, and that it is important for SALGA to impress upon municipalities that trade unions are equal partners in leading to a viable municipality and improving service delivery. Thank you very much.
Thank you so much, Makakula. We just didn't want you to sabotage your other comrade. So, Comrade Johan, please come to represent Imatu. Thank you so much. Let's give a round of applause to Johan as well, please.
Thank you, Program Director. Dumisani, just as you were stepping off the podium, there was a very, very quiet shout from Zwe's side to say, Amandla. So, but Amandla. Zwe talking about being captured. Program Director, thank you for the opportunity to address the conference. Let me observe protocol by also thanking the Executive Officer of SALGA, Mr. Rio Nolanchungu, the Director of the CCMA. Cameron, good to see you again. I haven't seen you for a while. You look well, you look fit, you're still in the gym every day, so you really look well. My good friend from Samoa, Comrade Dumisani. And you know, having to follow Dumisani is quite difficult, so I'm glad that my presentation is going to go into a slightly different direction than Dumisani's, because it's very, very difficult to follow what he said, and I want to echo everything that Dumisani has said. And then all the delegates and distinguished guests that are watching us virtually, those that are here in the room, thank you for the opportunity to address you. As Dumi has said, we've only been given 10 minutes, and I worked through the night to prepare a slideshow, only to hear that my slideshow will not be presented. So there will be a bill for some overtime, Rio, at some point. Colleagues, I've been requested to focus on the relationship between Imatu and SALGA in how that establishes labor peace in the sector. And perhaps to explain why we haven't had a national strike since 2010. And let me say, I'm going to deal with this matter from a national perspective. Dumisani did enter into what happens at branch or municipal level, at provincial level. But my experience I'm going to share with you of what happens at a national perspective. And as I said, we haven't had a national strike in this sector since 2010. And unfortunately, that has been preceded by what I call the very, very stormy years. And in a period from around about 2007, 2008, right to 2011, we went through a very, very stormy period in this sector. The relationship was built, was characterized by absolute distrust. It bordered on dishonesty. It was very acrimonious, and everything that we dealt with was dealt with in a hostile way. We had strikes almost every year leading up to that period in 2010. And all our relationships and all our positions that we were taken at that stage as unions and as the employer can be characterized as positional bargaining. You had the traditional way of the unions entering negotiations with wage demands of 15, 18% that we all knew was never going to be achievable. But you had an employer coming in saying, well, I can't afford increases, I'm offering you 1 or 2%. And traditionally what would happen is parties couldn't get even close to one another. There would be a strike. Those strikes very often turned very nasty. I mean, you all saw the hostility in those days. And ultimately, the unions would ask for some political interference. A politician of SALGA would come and address us, and hopefully there would be a settlement. And I think Cameron referred to it as well, Dumisani referred to it, is that if it wasn't a strike, it was litigation. And I think from a union perspective, you'll all recall the wage curve negotiations of 2010 that ultimately led to a court case that cost both unions millions and millions of rands. It also cost SALGA millions and millions of rands. We were in trial for 10, 12 days. Ultimately, the matter was adjudicated by the Labour Appeal Court, and everybody was cross with everybody. That litigation totally destroyed the relationship between the employer and the two unions. And as I said, total breakdown of the relationships. So as an organization, we sat down in 2012 and we said, well, one of two things have to happen. It's either there has to be a changing of the guard, or we have to change our attitudes. Fortunately, changing of the guard, I assume everybody can interpret that in a way that they want to, but we saw it as putting the right people in the right places. We did change the way that our bargaining committee was constituted, and even on the employer side, there was, as I said, a bit of a changing of the guard that helped us to overcome this very, very bad situation that we found ourselves in. So since 2012, we've been working towards stability and labor peace in the sector, and how did we achieve that? We have adopted approach, what we call a mutual gain approach. And the first one that you would have seen where this mutual gain approach actually reared its head was the introduction of multi-year wage agreements. In the past, we had negotiations on a year-to-year basis, and as I said, it was the traditional way of positional bargaining, and we had strikes almost every year. So for the unions, it was a difficult concept to initially accept, because you do have to take a leap of faith for years 2 and year 3 of a wage agreement. But both unions took that leap of faith, and the establishment of these multi-year agreements brought a lot of peace for years 2 and year 3. It allowed all three organizations to focus on a few other issues and not be engaged in wage negotiations every year. Other examples of the mutual gain approaches is we've recently signed a pension fund restructuring agreement. And if you ever want to look at a model or a case study in local government where the total negotiation process was purely built on a mutual gains approach, that would be it. You had unions both demanding freedom of association for members to move between funds, but also accepting the employer's approach that we want uniformity in our sector and we want all employees in the sector to have an equitable access to benefits. So I'm proud to say that there hasn't been a national strike since 2010, and that says a lot about the sector. You can think about the reputational damage that everybody who's involved in the sector had to bear the brunt of. I'm a listener to Radio 702, and I would cringe in the mornings driving to the office, listening in those days to John Robbie, castigating both unions about how the streaks looked during a strike. And that didn't fill me with a sense of pride. Not to say that we will never strike again. Obviously, that will always be the last option if negotiations fail. But I'm proud to say that I think there's been a lot of growth in all three parties, and that's why we've had this relative labour peace since 2010. I'm going to be naughty. Cameron said that he was not going to lecture because then he'll be on stage all day. And similarly, since Rio's only given us 10 minutes, it's going to be hard not to lecture for the last 2 minutes. And I can say that once I leave Imatu, I've decided I'm going to lecture labour law, and I'm going to do it for free, and it doesn't matter where. So I'm putting my hands up now for to be a speaker at your conference after that, Rio. All right, so what are the lessons that I can convey? And as I said initially, my perspective is more from a national level. But I do feel that some of the lessons that I've learned, that my organization has learned, if you can apply that at municipal level, and if you can apply that in your LLFs and in the provincial divisions of the Bargaining Council, I think you'll go a long way in securing labour peace in the sector. First and foremost, relationships are built on trust and respect. You cannot work with another person if you don't respect him and if you don't trust him. You've seen these mafia movies where it's on the shake of a hand. And I'm almost at the point where I say that negotiations at a national level is at that point where we will meet the lead negotiators of all three parties. We'll stand in a small circle of 4 people and we'll say, this is where the deal is. And we shake on it. So the relationship has evolved to that level of trust where you can actually shake a person's hand. And again, maybe it would be the wrong example to use the mafia and drug cartels. But you've seen in all these mafia movies where they say that it doesn't help you killing the leader of the mafia because somebody else is just going to take over from him. And very often it doesn't help your relationship in a municipality where an employer doesn't like who represents the unions and tries to work them out of the system because another union leader is simply going to take over. It's important that you rather work and build the trust and build the respect of that person. The ability to resolve problems. And my good friend Gerard Greveling is also here, and Gerard taught us some good lessons when we negotiated the disciplinary code collective agreement. And as with all negotiation sessions, there's an employer position, there's a union position, and there were 2 very, very difficult clauses that we just could not get over. The one was the pre-suspension clause, the pre-hearing before suspension clause, and of course then the appointment of presiding and presenting officers. And both sides of the table, the unions and the employers, are very clever people, and for 2 days we quoted court case after court case trying to persuade each other what the law is, and we got absolutely nowhere. And ultimately, in a side chat with Gerard, my DGS legal and I said to him, but what is your problem, Gerard? And he said, guys, it's actually quite simple. When you're in a situation where somebody has just burned down a building, it is imperative that we get him off the premises and suspended immediately. And we said, well, why didn't you say that? Similarly with the appointment of presenting officers. The unions take the approach that it has to be an employee of the municipality. The employer says, well, I would need somebody from outside to lead the charges. Again, Gerard, what is your problem there? And he says, you know, I come from KwaZulu-Natal, and if you understand the level of intimidation that is there against presenting officers, you will understand why we want an external person. But having understood what Gerard actually said to us at that point, allowed us to go back into the bargaining committee and craft clauses that actually caters for the employer's position and caters for the union's position. Expectations during negotiations must always be realistic. And I'm proud to say, if you know, with both unions going into the 2021 wage negotiations, for the first time, the opening demand was below double digits. I think both unions realized from the outset that where the country is due to the pandemic, we would have been laughing stock having entered into an opening demand with double digits. So make sure that your expectations for negotiations are realistic. Communicate clearly and listen carefully. Always test the proposition that the other person is giving you. Again, I'm referring back to specific instances that we had with the disciplinary code collective agreement. If we didn't listen, we probably still wouldn't have had an agreement by now. And always prepare well. You know, it sometimes, I say to my constituency, I wish members and municipalities at local level can see the preparation that is done by both the employer and the two unions entering into national negotiations. We, in the past agreement, or the past set of negotiations that commenced in 2021, the position papers of both parties were in excess of 40, 50 pages. Well researched, economists' opinions were in there. So always prepare well. Program Director, so I'm going to conclude on that point. I did prepare a slideshow. Hopefully these points are made in that slideshow so that it's there for easy reference. Finally, I would just say, Rio, I hope that the conference really goes well. I hope that it's well attended, and good luck and Godspeed, and thank you for the opportunity to address you. Thank you.
Thank you so much, Johan. And thank you for availing your notes. That slide, please, Dumsane as well, if you can avail it so that we are able to have it as a... thank you so much, Pratums. Thank you. Ladies and gentlemen, it's a great honor and a privilege that at this point in time to unpack the collective bargaining challenges in relation to the recent Constitutional Court judgment on the PSCBC dispute. Please help me welcome on stage Mr. Sandile July, who's the Director of Werksman's Attorneys. Ladies and gentlemen, please let's put our hands together.
What's that? Is it me? Good morning to everyone. My task is to unpack the Constitutional Court decision, which was recently decided as, I think it's a decision which was decided not long ago by the Constitutional Court. This decision involves the bargaining, the public service.
As you are aware, there are a number of trade unions in the public service. I didn't know until I read this judgment that the parties, the trade unions that were involved in this matter, there were about 11 of them. 11 trade unions, and the employer being represented by the Department of Public Service and Administration. What happened is in June 2018, the trade unions on the one hand and the public service or the government on the other hand entered into an agreement. And this agreement was about the salary adjustment and the improving of conditions at the public service. So this agreement was for a period of 3 years. And it was going to cover the year 2018, 2019, 2020, 2021, 2019, 2020, 2021, 2022. If this is my slide, there is a disjuncture between what I'm saying and the slide. I'm not following the slide. Oh, okay. So this agreement was staggered in three years, which is 2018, 2019, 2019, 2020, 2021. Now, what happened with, as I said, in May, the collective agreement was entered into. Now, what is important is what happened before May 2018. Somewhere in October 2017, the Department of Public Service and Administration was mandated by government to negotiate on behalf of government in relation to the salary increases. Shortly after October 2017, there was a medium-term policy statement which was made. And that medium-term policy statement by Treasury was, Minister of Finance, was that the budget available was 100 and... I'm not going to use this slide. The budget was 128 billion for the salary increase for the 3 years. So this is announced in October. In December, the offer that was made by government was rejected by collective labor. In January, the negotiators on behalf of government, they go to negotiations and make an offer. And it turns out this offer was more than what was budgeted for. And it exceeded by 30 billion. Now, it exceeded by 30 billion, but for some strange reason, they go and ask the negotiators, go and ask for 15 billion, and not for 30. And in the case, the judges are also surprised. Why would the negotiators go and ask for 15 billion instead of the 30 billion? Because the budget was exceeded by 30 billion. So there was no mandate for this 30 billion, which was exceeded. But the contract, the agreement, of course, then they went back to the Committee of Ministers and present this offer. Now, the offer has already been signed. The parties have already agreed. Now, what do they do? Because they did this without a mandate. There were three issues that they were supposed to do, that they could do. One was to withdraw the offer that they've already made, and that would be negotiating in bad faith, or to continue with the offer as is. And the other one was to also to renegotiate that offer. But the final decision that was taken was that the agreement is going to be signed. And it was indeed signed. But in 2020, the Department of Finance, Minister of Finance, suggests that there's no way that they can afford. They've already complied with clause 3.1 of 2018 and 2019, and they've complied with clause 3.2, which covers 2019 and 2020 year. Now they have to comply with 2021. Then the department says there is no money. We don't have money to do this. A lot has to happen, even if it involved the retrenchment of employees. Now, that is when the problem started. Then the government wanted to renegotiate the contract and negotiate it down and not to pay what they have agreed. And the matter was referred to the Bargaining Council in April, and there was a conciliation in April of 2020, and that conciliation didn't go anywhere in the sense that no resolution was reached in 2020, in April. Then the matter was referred to arbitration, but before the matter could even be heard at the arbitration, Nehau referred the matter to the Labour Court. And it was referred to the Labour Court for the Labour Court to determine. But they've agreed, although it's referred to the Labour Court, that the Labour Appeal Court must sit as a court of first instance and hear the matter. Now, you have a collective agreement entered into between the parties, and the other party is unable to fulfill its obligations. And the trade union goes to court to want to enforce that collective agreement. What then the government did, made a counter application. And the counter application was to say, we can't comply with this collective agreement. At least the third portion of the collective agreement, simply because this collective agreement was invalid. And why is it invalid? It's because it did not comply with the Regulation 78 and Regulation 79 of the Public Service Act. So what does Regulation 78 and 79 say? Regulation 78 is very simple. It says it gives the powers or mandate to the minister or any department to go and negotiate or participate in the collective agreement on behalf of government. And that department or that minister is the Minister of Public Service and Administration. But 79 then says for the minister to participate in that collective agreement, you must make sure, that is now, it takes you to 79. And 79 says you must make sure that there's realistic cost calculation of the cost in the current and the future financial year. So if you don't do those calculations, it would mean that if you don't comply with that, then the collective agreement would not be valid. The second was that the collective agreement must not be in breach of Treasury regulations. The third one, under Section 79, is that when you reach the collective agreement, the cost of that collective agreement must come from the budget of that department, which is in this case Public Service and Administration, with the written consent of the Minister of Finance. Or if it's going to come from other departments as well, it must come with the consent of Treasury, the Minister of Finance. Now, all of that did not happen. I'm not sure about the calculation of the cost, whether there was a real calculation of the cost, but what we do know did not happen is that there was no budget agreed upon by the Minister of Finance, by the department with the consent of the Minister of Finance. Now Labour says, no. The Minister of Finance is part of the Committee of Ministers. And this decision to enter into this agreement was taken to cabinet, and the cabinet approved. And therefore, the Public Service Administration Department, when it entered into this agreement, it entered into an agreement having been mandated by government. So the number of issues that were raised that the Constitutional Court had to deal with. What the Labour Appeal Court did found that the collective agreement was irregular, was invalid. Invalid simply because it did not comply with Section 78 and Section 79. There were Regulation 78 and 79. There were other issues, of course, that are of importance that were raised during the hearing, was whether the government can, at this last hour, last moment, raise an issue of invalidity of the collective agreement that they have already complied with in the past 2 years. Then the court came to the conclusion that that delay can be overlooked in the interest of prejudice, because what the court did looked at the current financial situation that the country finds itself in and said, why would we allow the collective agreement, which is invalid, to be implemented when the government does not have money? Labour, on the other side, argues that no. But these employees cannot be blamed because the government has agreed, and the government agreed to this collective agreement, and they've even implemented the collective agreement. So these employees are just bystanders. So they had to compare the prejudice between the two, and they came to the conclusion that that was too much of money, which is 30 billion, to be paid, given that we were on COVID and also the issues of service delivery. So this issue then went after the Labour Appeal Court made a ruling. It was then taken, now the Labour Appeal Court found in favor of government that the collective agreement is invalid. It went to the Constitutional Court. Constitutional Court had to deal with a number of issues, but because at the time when the matter come before the Constitutional Court, so many things have happened. One, that year, which was covered 2019 and 2020 and 2021 had already lapsed, that period. Now the question was the mootness of the matter before the Constitutional Court. The other issue was the jurisdiction, whether the Constitutional Court has a jurisdiction to hear the matter. Of course, the Constitutional Court found that they've got a jurisdiction. They first deal with Section 23 of the Constitution and says because the collective agreement or collective bargaining happens in the for it to happen is because of Section 23 of the Constitution, which enshrines the rights of the employees and, of course, of the employer. Then it also said it is in the interest of the public that this matter be resolved. And why it was also argued on behalf of the employer, of the trade union, that if that collective agreement is not implemented, it will have far-reaching consequences for the employers, for the collective bargaining at the workplace. And of course, Constitutional Court did deal with the issue, and it came to the conclusion that one, the matter is not moot, because the rights that accrued to you before you came to court, even if that contract or that period came to an end, your rights will still have, you can still approach the court to enforce those rights. So there was no mootness issue, and therefore the court found that it can still deal with the matter. It was not an academic matter to deal with, and the court came to the same conclusion that the Constitutional Court came into, to which the Labour Appeal Court came to, that the non-compliance or the contravention of the Constitutional Court take it even further and said there was a contravention of Section 213, 215, and 216 of the Constitution. What Section 213 of the Constitution talks about? It says there must be an appropriation of budget, and that budget must be appropriated in terms of the Act, or the Act of Parliament, or it must be appropriated in terms of the Constitution. And therefore, in this case, because there was no budget for the 30 billion, therefore, there was no compliance. There was a contravention of Section 213 of the Constitution. And insofar as Section 215, it talks about there must be, of course, a budget from that department for it to be able to implement. Then Section 216, all what Section 216 does, it gives the Minister of Finance or Treasury a right to not to transfer monies to a department which is in contravention of Treasury regulations. So in this case, there was non-compliance with Treasury Regulation 78 and 79. Now, if I were to link this to the local government, of course I would imagine if Salga, Imatu, and Samoa enter into a collective agreement, they have to be mindful. They have to be mindful of the regulations that are applicable, of course, not 78 and 79. I'm not aware of the regulations that apply, but the Constitution, which is Section 213, and they have to be mindful of Section 215, they have to be mindful of Section 216. Otherwise, that collective agreement, if you enter into a collective agreement which there is no money appropriated for it, then that collective agreement will be declared invalid. I know for the fact that in the municipal sector, there has to be voting for any budget. So you vote for the budget. I would imagine if then you want to spend money which was not voted for, or you entered into an agreement which is more than what the parties, what was budgeted for, it would mean in light of this decision that that collective agreement will be invalid, and all those negotiations would have been a futile exercise. So it is very important, therefore, that the parties, when they enter into this agreement, they are aware of what instruments, legal instruments, or sections in the Act, whether in the Municipal Systems Act or Municipal Finance Management Act, that they need to comply with. That is my presentation.
Thank you so much. You think I'm off? Thank you so much, Babu July. I think you and I are relatives. My wife was born in July, and I was born in August. And you are owning July, so you must be my brother-in-law, something like that. We've got some time, ladies and gentlemen, to take a few questions for Mr. Sandile July, as well as Advocate Cameron is still here. So please, if there are any questions, let's take them so that we are able to close the gaps if there are any. And Mr. Sandile's July's presentation would be available on the app as well. He just decided not to follow the presentation. You see, when you know your stuff, sometimes you intentionally avoid to show us your slides because, you know. So any questions, colleagues? Let's check on the chats as well if we have any questions that we need to deal with. Okay. I think maybe then in the absence of questions, we will take our leg stretch for 10 minutes, and then the time is now 10 to 11. We're coming back exactly at 11 o'clock, please, ladies and gentlemen. Thank you so much. much.
Guys, we're getting going. We're a minute over, 2 minutes over.
Thank you so much, ladies and gentlemen. At this point in time, please allow me to introduce our next speaker, who will be dealing with the subject, the right of an employee to refuse to vaccinate and possible consequences. This would be Dr. Hba Regulations, Senior Commissioner at SALGBC. Please, let's allow her. Her presentation will be virtual. Thank you so much.
national state of disaster was declared on 20 March 2020 in terms of Section 27(2) of the Disaster Management Act. Now, what we have learned in the past 733 days is that, as I said earlier, COVID-19 is a notifiable disease, and the important point is that it is a notifiable disease under the Notifiable Medical Conditions Regulations. And we also know that it's been officially recognized as a new hazard at the workplace. And the important point here is that the Occupational Health and Safety Act does not only apply to the employees and the employer, but also to any person who visits the premises. If we could go to slide 3, please. The reason why I'm emphasizing these issues is because a new code of good practice was published approximately 14 days ago on the 15th of March. And the purpose of that new code is that it will eventually replace the state of emergency. Now, there have been many calls to end the national state of disaster. And so our state president, President Cyril Ramaphosa, said on 22 March this month that the state of disaster would be lifted when the public comments on the draft regulations, and that's the key, on the draft regulations released under the National Health Act closed on 16 April, as these would become the new legal instrument in terms of which the pandemic will be managed. So as we sit here, within the next 17, 18 days, things might change dramatically. And I would like to quickly take you through some of these envisaged changes, because by then what we have at the moment might be old history and no longer good law. Now, the president warned that the end of the state of disaster would not mean, and this is important, that there is an end to the pandemic. Now, if the code of good practice is adopted on or about 16 April, it will take the place and it will then be the legal instrument which will tell us what we can and we cannot do as long as this pandemic is with us. The important point here is that all employers and employees shall be subject to the provisions of this code, and they shall be so subject in terms of Section 203, that's 203, sub 2 cap A of the Labour Relations Act. No choice, subject to. The code utilizes both the terms worker and employee, and this is so inter alia to ensure that all persons who work in a workplace are protected. And this harks back to the consolidated directions which were issued to ensure a safe return to the workplace. Slide 4, please. We must note the following. And in the slide, I referred to a particular arbitration, and I will come back to that arbitration award. Now, the minister has issued amendments to the regulations relating to the surveillance and the, if I can just find my place, control of notifiable medical conditions. Now, earlier on, I said to you, we must remember that COVID-19 is a notifiable disease. So these regulations must also be considered when we look at the code. So that's the second change that's coming. So let's look at that arbitration award. When an employee reported that her employer, a medical doctor who had a practice attached to a hospital, had shown signs of COVID-19, he dismissed her. Sliedrecht was a personal assistant to Dr. Matonzi. On her version, he telephoned that morning to say that he wasn't well, and he asked her to cancel his appointments. She reported this information to the hospital management head of COVID because Dr. Matonzi, I beg your pardon, worked with COVID patients, and because on her version, he had informed her that he was showing flu-like symptoms. Such symptoms could have indicated a COVID-19 infection. Dr. Matonzi dismissed her for allegedly having breached confidentiality, and further, because he claimed that she had defamed him. When the matter was before a commissioner, and this was heard in Pietermaritzburg, the commissioner found that this dismissal was unfair. Now, why have I taken you back to a matter that was dealt with on 4 February 2021? This matter did not specifically turn on the issue of whether the report was made because Dr. Matonzi had ostensibly contracted a notifiable disease. The reason why she reported him is that he may possibly have contracted a notifiable disease, and she said she did so in terms of the hospital protocols. So what we see here is that these protocols could only have been that notifiable diseases must be reported. So we've come all the way from February 2021 to these regulations that are now out for public comment until the 15th of April. The third instrument that we need to take note of is that the minister also issued the regulations for hazardous biological agents, known as the Hba Regulations. And these were issued on 15 March. Remember, COVID has officially been declared a hazard in the workplace, and therefore these regulations must be noted. These Hba regulations specify that a registered vaccine is available for use in South Africa. Emphasis on vaccine. And in terms of Regulation 10 sub 4G, the vaccine can be made available to control exposure to the Hba in the workplace where reasonably practicable. So what do we see? Emphasis on a vaccine, emphasis on the fact that it can control exposure to the Hba in the workplace. So where is this moving to? I believe we are moving in the direction of increased mandatory vaccination as a consequence of these three instruments, which were all announced in mid-March. We mustn't forget that employers must provide a safe working environment, which means that there will not be any risk to the health of its employees. And that we see in Section 8 of the Occupational Health and Safety Act. The new Hba regulations read together with Section 8 of the OHSA, and that act stands. It's not been changed. It's not been repealed. That will enable employers to justify either a mandatory vaccination policy or a mandatory access policy. Can we go to slide 5, please? Now, there are 4 different reasons why the noose is tightening around the necks of unvaccinated employees, and I use the word noose deliberately, because people who are not vaccinated are resisting seriously. And these 4 reasons are, firstly, we will look at the issue that mandatory vaccination policies already exist at the workplace. That, and we've seen this in a number of arbitration awards, clients have mandatory vaccination demands. In other words, your employees can't come to service our needs as per our agreement with you because we have a mandatory vaccination policy. And that means that we won't let them come onto our premises. Then there are general mandatory access policies at the workplace, and I will discuss this shortly with specific reference to a Labour Court judgment. And then fourthly, there are a number of interdicts that have been brought at both the Labour Court and the High Court to stop mandatory policies from being implemented. But so far, all of them have been struck off the roll for want of urgency. Can we go to slide 6? Mandatory vaccination policy at the workplace and the refusal to be vaccinated. That's the first one of the 4 reasons that I would like to have a look at. And I'm going to look at 2 arbitration awards. In Theresa Mulderay versus Gold Rush Group, which was rendered on the 21st of January this year, the employee, a training officer, was dismissed on grounds of incapacity, a new term for us in this context. Incapacity, as a result of her decision not to comply with the employer's mandatory vaccination policy. Her refusal or failure to vaccinate meant that she failed to take the necessary steps to ensure that she could participate in creating a safe working environment. And this refusal of an employee to participate in creating a safe working environment goes back to Section 8 of the Occupational Health and Safety Act. That is where the requirement sits. And it's repeated in the existing consolidated directions. Now, that set the cat among the pigeons, and people are still debating this particular award. But since then, a more elegantly drafted and detailed arbitration award was issued, and it was rendered on the 7th of March 2022. And that is Dale Dryden and Duncan Kohlrabi trading as Duncan Kohlrabi attorneys. The facts were simply this. The applicant was a candidate attorney in a small law firm where it was a well-known fact that the employer's health was severely compromised. If he contracted COVID-19, he would in all probability die. The employer went to extraordinary lengths over a period to inform, educate, and counsel. 3 requirements that were necessary: inform, educate, and counsel his staff as to what scientific research had shown before he sent the staff a WhatsApp. And this is what the WhatsApp said: everybody has 5 days to confirm that they are registered for the vaccine and have taken the vaccine within 10 days thereafter. Failure to do so results in the termination of your employment. At the arbitration, Dryden, who was the applicant, said there was no act of parliament that empowered the employer to dismiss employees who failed to take the vaccination. So while they have the right not to be vaccinated, he said there was no act of parliament that said they could be dismissed if they refused. He conceded that there were directives or regulations regarding mandatory vaccination, but he said those do not place a legal obligation on me to be vaccinated. Now, interestingly enough, not 1, but 2 commissioners sat and dealt with this arbitration. And they're both senior commissioners at the CCMA, and they found that the directions constituted subordinate legislation, as these are issued in terms of the Disaster Management Act, and the Disaster Management Act is an act of parliament. It's national legislation. Of particular importance is paragraph 67 of this award, where the commissioners had the following to say. Sections 8 and 9 of the Occupational Health and Safety Act places an obligation on an employer to ensure, as far as reasonably practicable, a safe and health working environment. And that is still the case, and it is repeatedly stated in the 3 instruments which were announced in mid-March. The employer referred specifically to this obligation and relied on this act in formulating a mandatory vaccination policy. And here is the other side of the coin. It is worth noting that Section 14 of the same act places duties on employees, amongst other, to take reasonable care for the health and safety of himself and of other persons who may be affected by his acts or omissions. Therefore, these employees must cooperate with the employer's efforts to implement health and safety obligations and to carry out lawful orders and obey health and safety rules and procedures laid down by the employer in the interest of health and safety in the workplace. And that's the end of that quote. So what does this arbitration award say? It means that in terms of the existing consolidated directions, an employer may introduce a mandatory vaccination policy. And when that happens, the employees are subject to that policy. Obviously, if they don't vaccinate, in certain circumstances, they are permitted to submit a PCR test result on a weekly basis at their own cost to show that they test negative. But it didn't apply in this instance because the size and the nature of the office was such that the employer could not give effect to the requirement for reasonable accommodation. Dryden had to interact with clients and other members of staff in an open plan office. He had to go to court in his capacity as a candidate attorney, and he could therefore not work from home. His refusal to vaccinate and his refusal to articulate his reasons for refusing to be vaccinated led to the unavoidable result that his services were terminated. Slide 7, please. Let's look at the second reason, where clients have a mandatory vaccination policy, which is then has a knock-on effect on the people or the businesses with whom they are in an agreement, a service agreement. Now, the first award of this nature was the one that you see on the screen, Cook versus Daca Security and Services. And the second one is Dwayne Clinton, Besaidnout and Nashwa. Very recent awards. Decisions by clients not to permit the staff of any service provider to enter their services or their premises unless they are fully vaccinated has had a profound impact on the employees of those service providers. Let's look at the matter of Daca Security and Services. The employer adopted a mandatory vaccination policy because it had a contract with SASOL, and SASOL had a mandatory vaccination policy stating that nobody would be permitted to enter its premises unless they were fully vaccinated. Now, Koch was, and he's described as a safety practitioner, was denied access to the workplace. The workplace now is SASOL until he was vaccinated. So what did he do? He did not vaccinate. He referred an unfair labor practice related to his suspension. He was denied access, he was suspended, and he went to the CCMA. And these are the facts of that award. He was not vaccinated and he refused to vaccinate. He had to perform his duties at Sasol. He was not permitted to do so because vaccination had now become an inherent requirement of the job. Earlier, we came across the term incapacity in this instance. Now we come across the next term, an inherent requirement of the job. Koch did not meet this inherent requirement, and therefore he could not perform the duties for which he was employed. He claimed that being suspended amounted to an unfair labor practice because the employer had said to him, you can only come back to work once you are vaccinated. The Commissioner analyzed the 11 June 2021 Consolidated Directions, the provisions of the Occupational Health and Safety Act, the relevant sections in the Constitution, and you'll remember that in terms of Section 12, employees have a right to their bodily integrity, but in terms of Section 36, if the individual's rights are on a collision course with those of the majority, then the majority prevails. And the Commissioner looked at those sections before concluding that there was a valid reason for excluding Koch from the workplace by suspending him until he was vaccinated. And therefore, the Commissioner said there was no unfair labor practice. In the second arbitration award, to which I want to take you very briefly, Bezuidenhout was employed by Nashua on a fixed-term contract as an ICT engineer. Shortly after entering into the 3-month fixed-term contract, the Nashua head office indicated that it was about to implement a mandatory vaccination policy for all the Nashua offices because a number of its clients had already informed Nashua that they would not allow the employees of any service provider to enter their premises unless they were fully vaccinated. So it's very similar to what we saw in the Sasol matter, where Koch was then prevented from doing his job because he refused to be vaccinated. A similar thing happened. Bezuidenhout refused to be vaccinated. Once the mandatory vaccination policy was finally implemented at all the Nashua offices, Bezuidenhout's fixed-term contract, which had been renewed on a month-to-month basis until the policy was adopted, was not renewed. And this is where the wheels fell off. He now said, when he went to the CCMA, I had an expectation of the renewal of my contract. He further said, instead of renewing my fixed-term contract, I was such a good worker, and Nashua acknowledged this, that I should have been made permanent. But instead, they dismissed me. At least they could have retrenched me. The Commissioner then found that there could not possibly have been an expectation of the renewal of a fixed-term contract because he was not vaccinated. He was the only ICT engineer, and Nashua could not provide those services to their clients because they could not send him to do the job. They could not move him to an administrative position because he was the only ICT engineer. He could not possibly have had an expectation of permanent employment because he did not have or did not meet an inherent requirement of the job to be vaccinated. And they could not have retrenched him because he was on a fixed-term contract and they had agreed the end date of that contract. Could we look at slide 8, please? And the third reason to which I referred, and that is the general mandatory access policy at the workplace. What does it mean? Now, an employer can summarily dismiss an employee for failing to provide a test that shows that that employee is negative. And there's a very old arbitration award which came out in 2021, one of the first ones, Adam and Frida Hartley shelter. Now, what happened in this matter is that the Frida Hartley shelter, which was a shelter for women who have suffered of domestic abuse and their children, found shelter at this place. And the shelter imposed its own lockdown rules. And in terms of its lockdown rules, all the staff had to remain on the premises and could only leave for medical reasons. Adam, who was a house mother, decided she was going home for Christmas despite this rule, and she went home. And shortly after she got home, she contracted the virus. She informed her employer that she had contracted the virus. And the employer then made a special concession by saying, okay, you can come back to the workplace provided you go to a reputable laboratory where you will have a PCR test, which in those days cost 840 Rand or thereabouts. And you would have to present that test to show that you are negative and you wouldn't endanger the health of the people in the shelter. She said, I can't afford it. They said, in that case, summary dismissal imposed. Now, what is interesting about this is what the commissioner said when finding that the dismissal was for a fair reason. The commissioner said at paragraph 5.7 of the award the following: the fact that the applicant was unable or unwilling to comply with the terms of her conditional right to return to work was entirely of her own making. In other words, she exercised a decision. In agreeing to allow the applicant to return to the shelter, the respondent was in fact granting an indulgence to the applicant, in that whereas there had previously been a total prohibition or blanket ban on anyone entering or leaving the shelter, in other words, there was a rule in place, there was a special allowance made for this house mother, the applicant would have been allowed to return to the shelter, and the commissioner said, subject to her complying with certain terms and conditions. The applicant failed to comply, and therefore the commissioner said she was the mistress of her own misfortune. Can we look at slide 9, please? And now we turn to the Labour Court. The most recent Labour Court decision, and the most important, was handed down on the 14th of March, 2 weeks ago. And it is that of solidarity on behalf of members, Johetta van Rensburg versus Ernest Lowe, a division of Udago Trading Pty Limited. What happened in this instance is that the Labour Court confirmed, and here's the key, that an admission policy requiring mandatory vaccination was lawful. Here are the facts. The employee, Van Rensburg, said she was not willing to be vaccinated, but she would take a weekly PCR test, here's the catch, if the employer paid for it, and the employer declined to do so. She argued that she should be exempted from taking the vaccination for medical reasons, as she suffered from cardiac arrhythmia, which is a condition where one's heartbeat is irregular. Now, in keeping with the requirements of the consolidated directions, the employer then said, we need more medical information. She then went and obtained an ECG report, but The ECG report came without a cardiologist's report. And therefore, the employer said, you haven't provided the necessary medical proof. I can't do anything with this printout. I need a cardiologist report. So you haven't justified why you should be exempted from being vaccinated. And thereafter, the employer stood by its policy. Now, what was before the court? The court was not required to determine whether the admission policy was fair or reasonable. It was not required to determine whether it impacted on Van Rensburg's constitutional or any other legal rights. It did not determine who should pay for the weekly tests, nor whether it was unreasonable to require such weekly tests. So what did the court actually have to do? The court had to determine whether the access policy was lawful. Very important term, was lawful. And why would it be lawful? It had to be lawful on the basis of one, the contract of employment that Van Rensburg entered into. That contract didn't change. There was just a new policy. Was it lawful in terms of the directions? Now, we saw earlier that it is subordinate legislation, therefore it is the law. And was it lawful in terms of the Occupational Health and Safety Act? And that's an act of parliament. So yes, it was lawful. And therefore, the court accepted that Van Rensburg was given an option to vaccinate or to provide a weekly COVID-19 test result at her own cost in terms of the admission policy, not a vaccination policy, an admission policy, which is in effect the other side of the coin of a mandatory vaccination policy at the workplace. And the court further accepted that the employer discharged its statutory duty to provide and maintain as far as reasonably practicable a safe working environment in terms of Section 8 of the Occupational Health and Safety Act. In essence, and this is the important part of this judgment, the Labour Court upheld the employer's right to require its employees to have a COVID-19 vaccination, or if they didn't have that, to provide a weekly negative test if they decide or refuse to be vaccinated. If we could go to slide 10, and let's look at the fourth reason that I identified earlier, and that is when mandatory vaccination policies are implemented at the workplace and employees say it's not lawful, we now know it is, and they run to the Labour Court or to the High Court, and they say, courts, come to our defense and tell the employer he can't do it. Now, the leading case in this instance is Solidarity on behalf of members and two others versus CISA. And as you know, that CISA is an employers organization. Now, before this matter got to court, one of the two people withdrew and said she would be vaccinated, but the other member refused. He said he would not be vaccinated. And so, after he was given the opportunity to consider, and the risk assessment had been done, and the policy had been implemented, the employee, his name was Kurtzen, he was informed on the 30th of December 2021 that because he had chosen not to be vaccinated, he would not be allowed to access the company's premises on 3 January 2022. He would not be given any further instructions to perform any work, and he would not be paid. And then, not even 2 weeks later, on the 14th of January, he was retrenched. Only at that point did he rush to the Labour Court to seek an urgent interdict. But the court said on 2 February, some 2 weeks after he was retrenched, it's no longer urgent. And his application for an urgent interdict was struck off the roll. The same thing happened to the Karo teacher who went and complained to the High Court in the Cape, no longer urgent. And she was a young teacher, she was only 26, but she'd known for some time. But by the time that she went to court, it was no longer urgent. And therefore, the High Court struck her application for an urgent interdict from the roll. And the final slide, please, slide 11. In conclusion, please remember the new code of practice, which may, and I think will in all probability become effective on or about 16 April, it is some 2 weeks away from today, is designed to replace the national state of emergency. If we carefully read this new code of good practice, which is binding on all of us in the workplace, and if we read it together with the second instrument, which is the regulations relating to the surveillance and the control of notifiable medical conditions, and COVID-19 is notifiable, as well as the hazardous biological agents regulations, and we know that COVID is recognized as a hazard at the workplace, we find the following burning question. And it is this: will mandatory vaccinations soon become a fact of life, given that so much emphasis is placed on the need to be vaccinated in these three instruments? 2 regulations, the amendments to them, and the new code of good practice. Please don't forget that our president also said on 22 March the following, and we must heed these words because they're extremely important. Further easing of the remaining restrictions will require that we increase the rate of vaccination among South Africans. And that is why I said earlier, I am of the view that we are moving in the direction of increased mandatory vaccinations at the workplace. Thank you for your attention. That is the end of my presentation.
Thank you so much to Dr. Grobler. At this point in time, please allow me to call a speaker who will be dealing with the issue of an employer's response to dealing with employees with comorbidities as well as absenteeism. Please, ladies and gentlemen, let us put our hands together for Mr. Raymond Meneses from who's an attorney and a managing director from the Meneses Simpson in Durban. Thank you.
Good morning, everybody. I want to associate myself with Mr. Magagulu, who spoke earlier, saying that usually when he stands on a stage, he starts with a song. And that happens either in terms of his work as a union official or in terms of going to church. And I'm a part-time preacher myself, so I think I'm in good company when I say I think I'm preaching to the church choir here, because everyone here really has the same goal, and that is to achieve fairness in dealings with employees, and if you are a union representative, to ensure fairness for the employees, and at the same time to optimize service delivery and meet the operational needs of each municipality. So that's the golden thread I hope that is going to run through my presentation. I'm speaking today on an employer's response to comorbidities and absenteeism. One of the features of the regulations issued in terms of the disaster management regulations is that it expressly states that unless specifically addressed, it doesn't change the existing law. And I found that many employers have kind of gone into something of a panic in relation to the regulations pertaining to COVID and have acted as if the existing law relating to incapacity, relating to performance, relating to misconduct somehow no longer applies, and that the only thing that applies are these new regulations, and that's simply not the case. Another thought that I hope is going to run through my presentation is that in fact all of the learning that we've had up until this point and all of the policies, all of the practices continue to apply, only modified to the extent necessary by the additional regulations and directions. So as we heard from Dr. Kohlrabi, the consolidated direction signed in May 2021 in effect from the 15th of June 2021 requires the conducting of a risk assessment taking into account inter alia operational requirements whether it intends to make vaccination compulsory and identifying those employees who due to their risk profile, including comorbidities, must be vaccinated. The reason that I'm raising that is that addressing comorbidities in our current contexts involves having consideration to this consolidated direction. Also, as we heard from Dr. Kohlrabi, with effect from the 15th of April, more or less, it appears that this direction may not apply anymore, and it is going to be replaced by a version of the new code. But I'm going to continue to address the consolidated direction because that's what applies today. That may well change, and certainly the way that the CCMA and the courts have approached the interpretation of this is going to, in my view, strongly influence the way that the new code is interpreted as well. So it remains relevant. In terms of the administrative measures, the employer must require its employees to disclose inter alia comorbidities and take special measures to mitigate the risk of infection for those employees. The reason I raise that now is because there have been some instances where employees have said to employers, I have comorbidities, but I'm not disclosing the nature or extent of those comorbidities because that's my own personal information. And you cannot require me to. All I'm going to say is, here's a doctor's note that says I have comorbidities and you're not entitled to inquire any further. That is not the case. You are absolutely entitled to know the nature of the comorbidities as the employer, because part of your obligation as an employer is to provide a safe working environment for this employee. And you can only do that in an intelligent fashion if you're informed as to the nature of the comorbidity. Secondly, with reference to Annexure C, that is the Annexure C to the consolidated direction dealing with mandatory vaccinations. Any employees with medical contraindications should be reasonably accommodated if necessary. Contraindications includes a comorbidity where there is a proven medical contraindication to the vaccination, either the Johnson & Johnson or the Pfizer vaccination. The number of people who have a proven contraindication in terms of any comorbidity is vanishingly small. I think it's 0.2%. Where we are now, more than 2 years into the pandemic, billions of people have been vaccinated. So this is an area of medicine where there's been a very close analysis of potential contraindications. We're no longer in the phase where people can say, well, I don't really know. One of the challenges that many employers are facing is that GPs are issuing medical certificates. I'll speak to this a little bit later. But issuing medical certificates and providing opinions saying, well, in my view, I don't think this person should be vaccinated, without any proven contraindication to the specific treatment or to the specific condition of that particular employee. So I'm going to suggest as we go along that we deal with those GP medical certificates with a degree of circumspection. The Code of Practice Managing Exposure to SARS-CoV-2 in the workplace, which should come into effect mid-April, and I suspect may be amended subject to public input, we're not sure yet, maintains the need for risk assessment and plan. I've found several employers, even now, don't have a COVID plan, which was an obligation right from the outset. The code requires that both the risk assessment, which should be conducted to inform the development of the plan, and the plan itself should be available for inspection by unions and by representatives of the Department of Labour. It may include special measures for employees at increased risk, including comorbidities. Again, the legislation is identifying that comorbidities are highly relevant in assessing risk in the workplace, because there are certain comorbidities which make individuals more susceptible to risk and of serious infection or of death if they contract the disease. If employees produce a medical certificate indicating contraindication to vaccination, and if accepted, so the employer is not bound by that, you can accept it or reject it, or refer to medical evaluation which confirms contraindication, must be accommodated. This is a small departure, I think, from the previous consolidated direction which applies now. The previous consolidated direction said that employees should be accommodated if necessary. This now says that they must be accommodated. So there's been a shift. The code does, however, say that this code may be departed from in appropriate circumstances, and those appropriate circumstances require justification. One of the justifications may be an inherent requirement of the position, which means that all of the case law Dr. Kohlrabi referred to and the approach generally of the courts to the requirements for reasonable accommodation still apply. I do think, however, that it's going to place a greater burden on an employer to demonstrate that this particular individual cannot be accommodated. So just before I proceed on that, for employer and employee, records are your friends. You need records to be kept of everything in relation to COVID-19 in writing. Because if this only goes to court in a year or two's time, the person who was involved will either not remember or will have left the organization. And that's a massive risk. So it's really important to have detailed notes of everything, and as a previous speaker has said, to have a developed risk plan that is recorded in writing, risk assessment and a plan which is recorded in writing, as well as a written record of all the interactions that relate to that. Remember that there's an obligation to engage with unions in respect of the development of the plan by way of consultation, and those engagements should also be recorded. I find it very difficult to assist employers at a later stage where this hasn't been done in writing, because you're so at risk of people's recollection, which is by no means entirely accurate and is certainly open to personal bias. It's better to have things in writing. Do you know that when you remember something, you don't remember the event? You remember your most recent recollection of that event, which is why, as time passes, your recollection of an event becomes less and less accurate. Because in each instance that you bring it to mind, you're remembering your most recent recollection of it. It's a bit like photocopying an image, then photocopying that photocopy, then photocopying that photocopy. Another reason to have everything recorded in writing. Then you don't have to rely on memory. On the subject of medical incapacity, you'll recall that I've mentioned that the same rules that apply prior to COVID still apply in respect of incapacity. And I'm just going to remind us of some of the pertinent features, because when we deal with comorbidities, which I'm going to deal with at the conclusion of this conversation, it's really important that we have in mind the approach of the courts to incapacity, medical incapacity. In ACI Explosives Limited versus Mambalu, a fairly old judgment of the LAC, Labour Appeal Court, they held that this is the test to apply. The substantive fairness of dismissal depends on the question whether the employee can be fairly expected to continue the employment relationship, bearing in mind the interests of the employee and employer and the equities of the case. Relevant factors would include, inter alia, the nature of the incapacity, the cause of the incapacity, the likelihood of recovery, improvement or recurrence, the period of its absence, and its effect on the employer's operation, the effect of the employee's disability on other employees, and the employee's work record and length of service. So each of these things is relevant when approaching how do you deal with somebody with a comorbidity who isn't coming to work. All of these are relevant. Applying this test, the LAC found on the facts of this particular case, the employee's days of sick exceeded his yearly entitlement sick leave, and on most of those days, he was sick as a result of suffering from influenza. I think we can read a little bit between the lines here. Influenza is a viral infection which is seasonal. The fact that this individual was booked off sick with influenza is likely an indication that he was malingering. He was probably taking a chance, and you'll see why I say that as we go further into the facts. The influenza was not caused by the employee's working conditions, and there was also no underlying cause for influenza. The employee, therefore, could not be treated for his influenza, and his working conditions could not be altered to avoid him contracting influenza in the future. In the circumstances, it was unlikely that his attendance at work would improve. Thirdly, the employee was unreliable. The company could not rely on him to arrive at work on any given day. Since the company never knew when he'd be off sick, it could not make alternative arrangements in advance to accommodate his absence. As a result, the company's productivity was inevitably affected, and an unfair burden was placed on his fellow employees, since someone had to do his work when he was absent. Now, each of those is relevant when you consider an incapacity dismissal, because incapacity is a no-fault dismissal. It's different to misconduct, where an employee is at fault. Incapacity is supposed to be a consideration of whether the person can be at work and why they can't be at work without allocating any blame to the employee, which makes the next point a little bit surprising from the Labour Appeal Court. The employee's work record was also bad in that he was disciplined for sleeping on duty, unsatisfactory work attendance, leaving the workplace without permission, and being absent without leave on 4 occasions. So here we see that the court was swayed in assessing the operational risk of his continued employment, not only with reference to his illness, but also in relation to the fact that he was guilty of misconduct. I'm not sure that should have been in there, but there it is. In terms of procedural fairness, the LAC prescribed these requirements. 1, there should be a fair review by the employer of the employee's attendance record and reasons for it. Again, record keeping is absolutely critical. If you have a record of somebody being off sick on medical grounds, a detailed record of what those medical grounds are is important. The employer must have given the employee appropriate warnings after the employee was given an opportunity to make representations. In other words, a hearing. The employee must be given an opportunity to improve his or her attendance, and only if there's no adequate improvement in the attendance record thereafter will the employer be justified in treating the persistent absence as sufficient reason for dismissing the employee. I'm going to address a common misunderstanding on that requirement. Generally, employers consider whether an employee's absence is longer than can be accepted with reference exclusively to their sick leave record. So they say, well, this person has exceeded their sick leave record, therefore there must be an incapacity issue. You may, as an employee, be absent from work for a period that's unnecessary or unreasonably long before your sick leave cycle is exhausted. It depends on the nature of the position. If you hold a senior position, for example, a CFO, it's just one example that springs to mind. There are certain critical elements of work that will not be able to be done in your absence. If a CFO was absent for a long period, even if it was short of the annual sick or the sick leave cycle over 3 years, it may be appropriate in those circumstances to consider an incapacity inquiry. Depends on the risk to the operation of the business. In a subsequent judgment of the Labour Appeal Court, more recent 2012, still quite old though, it was a municipal case where a senior employee was suffering from depression, and as a consequence of ongoing depression was frequently absent from work and absent for a long period. The court confirmed that an employer is not obliged to keep an employee in their employ who is not capable of performing the services for which they were engaged, provided a proper investigation into the incapacity is conducted and alternatives to dismissal are properly considered. One of the things where employers frequently go wrong when it comes to dismissal is they think of dismissal in terms of punishment. So somebody commits a misconduct, they must be punished by being dismissed. That's not the case at all. The courts have said that dismissal is a feature of the management of operational risk. Can you risk this person's continued employment? That applies both in a fault dismissal, misconduct, and in no-fault dismissals, such as medical incapacity. And one could have sympathy for someone who's suffering from depression and say, hey, it's not their fault that they're suffering from depression. That's true. But incapacity isn't a fault issue. Provided there's an investigation, provided proper alternatives are considered, and reasonable accommodation is investigated, if that's the end of the road for the employee on the grounds of incapacity, there it is. Schedule 8 of the Code of Good Practice dealing with dismissal sets out the requirements of dealing with incapacity, ill health, and injury. And I'm not going to go through it in detail, but in essence, the employer is obliged to consider whether the incapacity is permanent or temporary, and if it's temporary, is it longer than can be expected to be accommodated? And reasonable alternatives should be considered. I did a seminar up in Joburg a few years ago with an occupational health and safety nurse who worked in one of the mines, and they had a case where a miner at depth suffered a catastrophic accident involving his hands, and only one finger survived. He lost all of the rest of his digits. And they were able to accommodate him because they needed somebody who understood working underground to operate the hoister to move miners up and down the shafts. So he had all the experience and he had the finger that was required to operate the lift. That's a great example of reasonable accommodation. I'm not going to go through this in any detail because my time is almost up, but I do want to look at this. Here's an incapacity process flow which may be useful to you. Let's start on the right. The incapacity is as a result of an impairment, which is typically acute, because otherwise they wouldn't be absent from work. If it wasn't acute, they'd be at work, which is either temporary or permanent. If it's temporary, it may be for longer than the employer can be expected to put up with. That leads to incapacity. Incapacity has two routes, either rehabilitation through accommodation, through other measures, return to work, a return to capacity, and we're back where we were when we started, alternatively, down to dismissal. So that's the incapacity process flow. I'll deal with this very, very briefly. Absence from work. Is it genuine, or is it behavioral misconduct? Because employers right now, on the tail end of working from home, are experiencing massive increases in false claims of sickness. So there should be an investigation into that. Consideration given to group dynamics, what's happening to the team, consultation, engagement, and those are other factors which are relevant. Then financial considerations, absence from work has all kinds of costs, hidden costs included, medical insurance, pension and provident funds, and the accuracy of predictive models in financing and determining annual budgets. I'm not going to go into this in any detail. These are self-explanatory and will be available in my presentation. What I do want to do is I want to highlight that there's a difference in approach to an impairment which is a consequence of occupational exposure and a disease which is a consequence of social exposure. In other words, if the impairment, illness, or injury arises at work, there's a much greater burden on the employer to accommodate and to hold off on dismissal where appropriate. If it's a disease or injury which arises outside of the workspace, that burden is lessened. And the way that occupational health practitioners refer to this distinction is we refer to disablement, which is a COID issue, an impairment on work, or incapacity, ill health, and injury, which is an impairment generally that arises outside of the workplace, but may also give rise to incapacity dismissal. That's not to say a workplace injury or disease can't give rise to incapacity dismissal. It certainly can. But then there's a claim in terms of COID. That's another flow chart which is relevant. I won't have time to deal with it. I do want to dive into this. Considerations when dealing with comorbidities in medical certificates. There is a thriving cottage industry in doctors providing medical certificates on minimal information, sometimes just paid for, without medical consultation. So we should not regard medical certificates as the gospel. The first inquiry is the medical certificate genuine? I had a case where an employer received a medical certificate from a doctor and something was off. So we contacted the doctor and said, "Good day, doctor. Did Mr. Smith, I'll call him Smith, attend at your offices on such and such a date and undergo a consultation?" And the doctor said no. So we said, "Well, how could you possibly know? Don't you need to check your records?" He said, "I can confirm without any shadow of a doubt, Mr. Smith was not at my offices and did not undergo a consultation with me." So we said to him, "Well, how can you be so sure?" And he said, "Well, I'm a gynecologist." So what had happened is somebody, probably an employee of the gynecologist, had stolen a prescription pad and was selling them. Secondly, is the medical certificate consistent with the objective facts? If the person is exhibiting symptoms that are inconsistent with generally recognized criteria for the disease that they've been booked off with, well, that's an area for exploration. Is the medical certificate reasonable? So if somebody has sinusitis and they're booked off for a month, is that reasonable? Absolutely not. Does the situation warrant an independent medical evaluation? And that's again a consideration depending on operational needs. In conclusion, it is critically important to educate and upskill management to deal with incapacity. Incapacity is not an HR issue. Incapacity is a line issue. HR is there to support, assist, and guide, not to actually do the work. It's really important that management are equipped and educated so that incapacity is not something they don't deal with because they're worried about getting it wrong. No. Let's educate, assist, and guide so that they are confident to deal with incapacity as an operational question. Secondly, interrogate the evidence. Don't be afraid to dive in and ask questions. And finally, don't fear incapacity dismissals. I agree with the representative of the CCMA who said we shouldn't be trigger happy, shouldn't be looking to fire people. But when the circumstances arise where that's appropriate, dismissal is appropriate. Thank you. That's the end of my presentation.
Thank you so much. At this point in time, we'll be going through a virtual presentation which covers an employee's response to mental health wellness of its employees during the COVID-19, and that would be Dr. Serena Frank. Ladies and gentlemen, over to you, Dr. Serena.
Good morning, everybody. Can you see me? Can you hear me? Good morning. Can you hear me? Okay, can I proceed?
Yes, you may.
Okay, good morning, or is it good afternoon, and welcome to everyone. I'm so glad that you've invited me today to present on this important topic. I am the Senior Manager at eThekwini Municipality, and today I'm going to present our response to the COVID-19 pandemic. Could go to the next slide. I'm going to give you an overview of what I will be presenting on. Let me go to the next slide. Yes. So the outline of the presentation is quite interesting. We're going to look at the impact of COVID-19 on mental health. We're going to examine what is mental health and whether we think that it is a traumatic event, and some interventions that we've put in place at the eThekwini Municipality, how we've monitored our employee well-being, and how we're going to move forward in terms of adapting to COVID-19. So as an introduction, as you know, COVID-19 has impacted all of us at different levels. And as we look back on the past 2 years, we all have been affected in some way. Some of us have been socially isolated. Some of us who live alone have experienced depression. It has had an impact on our workplaces in terms of the different changes that we've experienced, in terms of the different shifts that we've had to endure, remote working, working from home, adjusting to the workplace, to the PPE regulations, major stress in terms of our workplaces. In addition, we've also had to deal with many losses of colleagues, family members, and other types of losses that we may not think about, just loss of the way we did things, the places that we went to and we enjoyed going to. All those changes have affected us in some way. We also have a fear of infection, even maybe now to a lesser extent, but in the past it was quite intense. Fear of infection, fear of dying, and the inability to seek support from family and communities has caused us major stress. So now everyone is out socializing and enjoying that in abundance, because We now can unmask, we can go to public spaces, and we can socially engage. So these multiple stresses have contributed to us in terms of the impact on our mental well-being. And the pandemic has generated interest in mental health and also shown us that we have underinvested in it. If we look at the World Health Organization global report, it's showing us that 25% increase in anxiety and depression globally has been reported. So the impact has been great on our mental health. Going forward onto the mental health continuum, thank you. Can I have the next slide? Thank you. The mental health continuum. I can't see the slide change. Sorry, can you please change the slide? Should I continue the presentation?
Please continue.
Here we go. Sorry about that. So I'd like to take you through the mental health continuum. On one end of the continuum, you have mental wellness, and the other end is mental illness. And you see where we are in terms of mild distress and moderate distress. If you look at those 2 points on the continuum, all of us experience at some point in our life mild distress or moderate distress. And in many ways, we can cope on our own with these areas of stress. We can seek social support and we can manage our stress and we move ourselves into a balance of mental well-being. Professional help and counseling is sometimes necessary when we are unable to cope, and we move ourselves back into mental wellness. So the employee wellness program is there to support all of us in terms of maintaining that balance and preventing us from going onto the extreme right of mental illness. Mental health is therefore a state of well-being where we realize our own abilities. We can cope with our normal stresses, we can work productively, and we can contribute to our communities. So I just wanted to highlight that to you and to know that to be healthy is more than just being physically healthy. It also includes our mental well-being. I'd like to ask you a question now. If I could engage with you even virtually, do you think that COVID-19 has been a traumatic experience for you? Just think about it. Has it been a traumatic experience for you? And when you're thinking about it, when we think about trauma, we're thinking about maybe being hijacked or having a serious motor vehicle accident. Or also you may think about being robbed. Right? Those are traumas that we are familiar with. But as we go to the feelings and the symptoms, I see the symptoms are not coming up on the slide, but here we go. Let me take you to the feelings and symptoms of a trauma. Feelings of being overwhelmed, isolated, afraid of your life and safety. Have you experienced those feelings? Lack of control, being emotionally hurt and helpless. Symptoms of trauma include nightmares, insomnia, appetite changes, anxiety and fear, agitation and anger, being hypervigilant, tired, sadness, and depressed. If you have experienced any of those symptoms, then you would realize that COVID-19 is a traumatic event that has affected all of us directly. And as such, we shouldn't view it lightly. Mental health is so important at this time, and it should be taken very seriously in the workplace. We have to do everything to support our employees. The impact on the workplace has been different for different employees. As you see in the slide, where you see an imbalance in the scale there, where the frontline workers were predominantly affected by having face-to-face contact with employees on the ground, and even in community health clinics, having contact with the public has caused them to be very fearful and anxious during this time. Employees with direct exposure, therefore, have a greater need to be very anxious and therefore require greater interventions and more focused interventions in the workplace. This is in comparison to our, for example, human capital support systems that are in the workplace, whereas they fear, I'm not finished with that one, whereas their fear and anxiety is not that, is still there, but the impact is not as intense, because you could be fearful of traveling in public transport, or you will be fearful when you interact with your colleagues, but the exposure is not so direct as with the emergency staff. So I wanted to convey a message that we need to adapt our employee wellness programs to deal with the different levels of skills in the workplace and adapt our programs according to the resources available, such as in a community clinic, you'll have a little resource and you may not want to go into that resource in a high-risk disaster time. Also, the sharing of a PC, the shift hours, all programs need to be adapted to provide services to different levels of skill in the workplace. Thank you. And as we proceed on to the COVID-19 transition curve, I would also like to engage with you again and ask you a question. Can you imagine the little cartoon character that you see on your screen? Let's call him Ron. Can you ask yourself whether you have experienced anything on this transition curve? Can you identify with any experiences that Ron is going through from the start of the pandemic, where he's totally complacent, moving from anxiety to happiness, maybe fear, anxiety, lots of denial, guilt, maybe depression? Do you identify with Ron? And eventually he's climbing up the curve to gradual acceptance and moving forward. So this transition curve is basically there to show us how COVID-19 has impacted us all in terms of change that we've had to undergo, and a very rapid change as well. It actually mimics the grief curve that we have, that you may know of, Kohlrabi. But it's showing the impact that we all have been faced over the past 2 years in terms of the different emotions, the different feelings, the different situations that we have encountered, which is not normal. It's something very unnatural. And we now stand at the top. Maybe some of us are still in another phase on the curve. We're still in denial, we're still afraid, but some of us are moving towards the top, where we're looking to the future and seeing how we can make the best of it going forward. Interventions in the workplace for disaster different variants that we have experienced. Because at each stage of the different variants, we have found that we've had to face different problematic issues that employees were dealing with. For example, at the onset of the pandemic, there was a lot of media, negative media around COVID, false media around COVID-19. So our first intervention was coping with COVID and giving employees the correct information on what to look out for, what we are dealing with, and the uncertainty and fear that it brought were the prime focus of our psychoeducational training. In addition, many people were not infected at that time, so there was stigma for those employees that were infected that came back into the workplace. They were stigmatized. So our psychoeducational focused on managing stigma. As the pandemic progressed, where we experienced grief and loss, we engaged with employees on this particular topic and encouraged them to cope, even to the point of managing their children. Working remotely was also a source of stress, as I've spoken about, and the balance between work and life became absolutely essential as employees were juggling, managing families, managing their work, working extended hours. And this required intervention, some knowledge, some support. When employees returned to work as well, it was a major life adjustment. As you saw on the transition curve, change again. How do we cope? How do we cope with working from home, and now how do we cope after working from home? How do we adjust to that whole scenario? In addition to all the impacts of COVID on the workforce and on all of us in general, we had to face as a country the riots and the looting, and that as well added to the impact on our mental health and well-being. We tackled the topic on the psychological coping with the aftermath of a disaster, because employees were extremely fearful. Imagine being so traumatized by COVID and then having to deal with riots and looting. Our interventions progressed further with the variant of Omicron, and at the same time with vaccines being introduced and the different myths around vaccination, the reluctance to receive vaccination, and at one point there was a scramble to receive vaccination, and that died down, and it required a lot of motivation to get employees and the public in general to receive vaccination. So we focused largely on vaccine hesitancy at that stage. And finally, we moved on to long COVID and mental health, because as the variants progressed, we found that many employees in the workplace were struggling with the symptoms of long COVID well over the period of quarantine and isolation. And this was impacting them greatly, some to a greater extent than others, and definitely influencing their mental health and well-being. So that was another intervention we implemented. Psychological first aid for managers, your first point on the board, shows that we targeted management in training them on how to deal with disasters long before the pandemic started. We were upskilling managers on how to cope with employees in a crisis situation. So these skills became imperative in a disaster environment. For emergency services, we have been upskilling them for a while on how to handle traumatic events, and this continued during the pandemic. So these are some of the disaster management, psychoeducational interventions that we found relevant and important and has been adapted to deal with the different variants during COVID. Interventions progressed to the next slide, please. To group support as well, where we adapted the normal on-site group support, which we have been conducting with regard to trauma and specific conditions, to an online support group specifically for COVID-19. At each stage of the wave, we found that employees would reach out during the highest point of the pandemic or that particular wave and required that online support, which was imperative for them to share with each other their personal experience and to support each other at that time, to know that they were not alone and the experiences were common to others. This itself is very therapeutic. During the riots and looting, we ran a specific trauma support group to help employees cope with that additional traumatic event. We also created accessibility for employees, and we, as much as we have our face-to-face on-site clinics available, we also incorporated virtual and telephonic sessions, which became very relevant during the quarantine and isolation period that employees were facing. In the initial frame of the disaster, quarantine and isolation was extremely traumatic for many people who had to be hospitalized and in crowded spaces and experience death all around them. And that critical online support was very therapeutic and relevant at that time. In the next slide, you would see we targeted a specific fatigue assessment to our healthcare workers, which required a telephonic support to them, to engage with them during their shifts and extended working hours, covering for their colleagues who they had lost. And it became a very, very difficult time for them, with extreme fatigue, burnout, and environments where they were not coping with the level of cases that were coming in. So these fatigue assessments helped to support them telephonically and further refer them further for more intensive support going forward. Further, we embarked on a monthly poster campaign where we empowered employees in coping with COVID with various posters, online posters, and engagement through our communication channels. We further engaged with teams in different clusters where we engaged with employees and management right up to the DCM level on the mental health strategy for the disaster and the SOP for disaster management, which was very relevant at that time. So when we look at our problem profile, you would see that in the 2021 and the 1920 period, stress was reported as the highest problem profile. Stress is a catch-all phrase that people call in and say, I'm stressed. And it could be COVID, it could be that they are grieving, it could be that they're having conflict in a relationship, whatever it is, there was a heightened incidence of stress in this period. Going forward, when we monitored employees, we monitored them through real-time surveys. And from the onset of the pandemic, we've been monitoring our workforce. So you'd see we've conducted 4 surveys, and I'm only going to take you through the aims of the surveys due to the period of the presentation. From April to May 2020, we did a health and well-being survey. And in the survey, it was during the lockdown period, and everyone was very stressed and fearful. So we wanted to identify what were the concerns of employees and how were they coping. And we wanted to monitor their health and well-being. and prevent any risks that were happening at that time. In the second survey, when employees returned to work in June to July 2020, the aim was to explore the different types of stresses that employees were experiencing as they returned to work. The third survey was a resilience survey. It was done towards the end of 2020, where everything seemed to have been settled and everything seemed to be stable and everyone was positive about the pandemic not coming back. So we explored employees, how they've adapted to the changes of being from lockdown to lifting up lockdown levels, and we looked at how they were coping and their resilience skills. In the fourth survey, we looked at remote working from June 2021 to July 21, and we explored the impact of remote working on employee well-being, and we looked at some of the psychological impacts on them, and also this proved to be an important real-time survey to inform on the development of policy going forward. These surveys proved to be valuable in terms of allowing employees, next slide please, to express themselves, and this has a cathartic benefit to show that we are caring and we're listening to them, even if it's on a virtual platform. It allowed us to engage with employees, to assess them, and to assess them in terms of their whereabouts, in terms of well-being, and to also draw light on what their needs were and to target interventions accordingly. It highlighted practical problems that they were facing in the workplace, and maybe they could not express that. So they were jotting them down on the survey. These included the managers that they were engaging with, their attitudes towards them, the stresses that they felt from the internal structures, the health and safety issues that they were experiencing in the workplace. These were all engaged with on the real-time surveys. It also allowed us to distinguish between essential and non-essential workers and the impacts that it had on them. So if we could just look at the last statement there by Gallup.com, I think it summarizes it quite nicely by saying that we have entered into a new era in which corporate well-being and mental health support are no longer perks or status symbols. They are simply requirements for doing good business. And that really summarizes what we've been trying to do to our interventions as eThekwini municipality. I'm coming to the end of our last few slides. What are we going to do now? Where to from here? When will COVID-19 end? This is a question on all our minds. We're talking about it. We were forced to adapt to the new normal in 2020. We were forced to work from home, work homeschooled. We've been through lockdown. We've been quarantined. We've been wearing masks forever. It's part of our uniform now. Now we've been told to unmask. We're sanitizing everything. We've isolated from families. We've adapted to change. Now regulations have changed again, and we're going to continue to change. So in reality, we have to adapt constantly as COVID-19 is here to stay. We have to live with COVID-19 going forward and take the protective measures. Vaccinating to prevent death and hospitalization is one of those protective measures. So we're shifting from the pandemic to endemic, where we've got to live with COVID-19. It involves a psychological shift for sure. It's very similar how you have to put on a seatbelt when you're on the road. So too, we have to continue to practice these safety measures. And it will become part of our lifestyles going forward. So we've got to adapt with the changes. And some final thoughts. In conclusion, our response in the workplace should be one of caring and compassion. As I spoke about long COVID, even though employees have been infected, Many have recovered. There are many that are struggling to manage COVID symptoms. And our response should always be that of compassion and care, even when we want productivity to be a priority. Employee wellness programs need to be given more visibility. They need to be strengthened and resourced adequately to cope proactively with mental health support. We need to align our workplace with the numbers of staff that your employee wellness program is dealing with and capacitate them. The third point is that there are many above the iceberg elements, not below, that present as absenteeism, conflict, and abuse. And this is remaining in the workplace. You are all engaging with this all the time. We cannot ignore this. And therefore, I am advocating for employee wellness programs to proactively target interventions to deal with these particular issues. And perhaps the hardest of all is for us to change our mind shift. We need to accept that COVID-19 is not temporary. We can't just bury it in the past and say we're moving forward. It requires us to structurally shift in how we live, requiring us to change permanently in our behaviors. And my final slide shows Tegweni Municipality. We recently won the Premier Service Excellence Award for the best multidisciplinary task team during the COVID-19 pandemic for 2021. I wanted to show you that slide to show you that it is a team effort between HR, occupational health, safety, wellness, and all the internal stakeholders in the management of COVID-19. That brings me to the end of my presentation. Thank you very much.
Thank you so much, Dr. Serena. At this point in time, ladies and gentlemen, may I kindly ask everyone who's joining us online and virtually, please make sure that you write your answers on the chat room so that we are able to deal with them. We've got a video that will be flighting now, so please write the questions while the video plays. Thank you.
On the 5th of March 2020, we recorded our first positive coronavirus case. Within a few days, we followed the rest of the world and plunged into darkness and desolation. Loneliness covered the face of our beloved nation, followed by pain, anxiety, and grief. The world is at war. We are at war with an invisible enemy.
I thought that was the end of us, the end of life.
Next door or wa tshuga o na le letswalo
lefu la teng le bohloko le o bonang batho ba kwaetswe ka diplastic hey re dula re tshuile.
Ja, ek het my broer wat net na my kom verloor in Oktober verlede jaar. Dit was 'n baie hartbrekende situasie, hartbrekende geval.
Since the pandemic started in South Africa, we witnessed the bravery, courage and resilience of municipal workers. These workers ensured that the delivery of services to South Africans is not disrupted as a result of the pandemic.
Our members and employees kept us working when the country went into lockdown 5 in March last year. This we did, risking our own lives and safety. Thank you to each and every municipal employee for your contribution in ensuring that critical services were not disrupted.
The sad reality is that the virus was spreading like wildfire, and we didn't know much about the virus.
In the beginning, we didn't even know whether it was droplet spread or whether it was spread in the water or whatever. We just knew that there was a problem.
Just like in 1961 with the H5N3 or in 2003, SARS, the first coronavirus, Just like in 2009, the H1N1 or swine flu, or another coronavirus in 2012 called MERS-CoV. There's been many. And in all of them, we looked to science for a solution.
The second phase of the vaccination resumed on Monday for South Africans above the age of 60 years and other vulnerable groups. According to the latest statistics from the Health Department, the country has vaccinated.
First, I thought I want to get this vaccine, and then the conspiracy theory started because we're all on social media. Everyone is like, they're going to track you, this is how they're going to get the 666.
666.
You cannot escape God, not even with the mask or 6 feet.
Do you believe the numbers?
5G towers are going up. The 5G!
You've been brainwashed.
So I'm just like, I would like to get this vaccine to protect myself, but what is inside of it, and why so fast and why so quick? Why are they testing it out on Africans at first? Because that's what we thought, they're like only rolling it out to Africa first. I'm like, what's going on? So I was just like, at this point, I don't want the vaccine until we're sure of it.
I don't know. I don't believe in that. You see, because there's a lot of conspiracy theories. Some they're still even saying it's a trial. You see, I don't believe there's such.
It was too soon. Who was it tested on? How sure are they?
I think what's important for people to understand is that vaccination or vaccines, they go through certain technologies. So there's been technologies that have been worked on over the last decade or so. One of those called mRNA technology, which actually is much more efficient. The times taken to develop a vaccine, it is shortened.
The technology had been around, the scientists have been working with it, they've been exchanging across various platforms how to use this technology, and now suddenly there was a thing to use it on. And with the ability to share this information across the world very fast and to talk to one another in large groups of people, it became possible to get a vaccine much faster than ever before.
So when a vaccine is then given a green light to be used in South Africa, it's gone through number of stages of safety and effectiveness. So people still think they are being used as guinea pigs. No, the guinea pigs were those who were in phase 1, phase 2, and phase 3.
Simply put, it takes anything from 10 to 20 years to fully develop a vaccine. However, when there's a health emergency or crisis, then it won't be very reasonable to wait that long. Normal procedures for developing vaccines had to be streamlined primarily by running stages in parallel than a linear approach. But what exactly is a vaccine? We have an idea, but maybe a more fleshed out explanation from a qualified person.
So we take a germ, we weaken it, or we kill it, or we take a piece of it. When we give that to you, your body doesn't know that this thing is weak, or it's killed, or it's a piece of it. It goes and mounts a defense such that when you get the real germ, you already have your soldiers waiting to attack it on sight. That's what a vaccine is. It's an artificial means to develop a defense against a germ that you have not yet been exposed to.
Vaccine does not prevent infection, but reduce, like the COVID vaccine, is reduce the severity of the infection. Majority of people, almost 90%, will never end up in hospital. And then you have few people, of course, that having other comorbid problems might end up in hospital but not in ICU or in life support. So the amount of deaths decreases dramatically.
People must look at a vaccine like a safety belt. In South Africa, every car has a safety belt. It is to minimize your chances of getting injured in the event that you get involved in a car accident. It does not prevent you from being injured.
I don't believe in the vaccine. It's just not, it's a scam.
At some point, I thought maybe the government is cooking something against the people, because it has never happened in my life ever.
There's been a bit of a vacuum in terms of dissemination of credible information to address people's fears. And life does not allow for a vacuum. You know, other people will then occupy that vacuum. So anti-vaxxers from across the world, people who just don't like the idea of vaccines, and other people who are into conspiracy theories have then used effectively the social media to create more fear and more confusion. And some of the things that they propose or share, if you are a person who has not studied medicine, you might find it difficult to see that they are lies.
The basis for vaccination is probably owed to one English doctor, Edward Jenner. In 1796, he attempted to neutralize smallpox. He took material from a cowpox sore on Sarah's hand and injected it into James, then exposed James several times to the smallpox virus. But James never developed smallpox. Vaccination became a widely accepted practice for controlling or eliminating diseases. In 1959, the World Health Organization, WHO, started a plan to completely eradicate smallpox. After a few failures in the 60s and 2 centuries later, smallpox was completely eradicated, with the last continent being Africa in 1977. This is considered the biggest achievement in international public health. Now, the success of every vaccination campaign lies in people. The people must be willing to take the vaccine. If some are and some are not, then the virus will keep circulating within our country. There's a level of patriotism in getting vaccinated, I think. Having some members of the community not vaccinated hampers with our most crucial, most important part of this battle, introducing herd immunity.
Herd immunity is that the more people we immunize, the less effective the virus is in the community.
Herd immunity could be our best chance.
Now, to achieve herd immunity,
You've got to chase that target.
Herd immunity is needed to...
The expectation.
Based on current data, South Africa is unlikely to meet its health department target to vaccinate 70% of the adult population against COVID-19 by December.
So we can achieve herd immunity through vaccinating a certain percentage of our community, or just let people get infected naturally.
Herd immunity, by definition, just means when the larger portion of populations are having immunity against the virus. Now, in South Africa, what does that mean? It means we are about 60 million people. At least you needed about 40 million people must be vaccinated or should have COVID-19 infection for us to have herd immunity.
Given that the current R0 of South Africa is 3, i.e. 1 infected person in South Africa will infect 3. To stop or weaken the virus enough to relax restrictions, we must vaccinate 2 of every 3 potential cases. That way, 1 can harm only 1, and we literally suffocate the virus. Simply put, we still have a long way to go, and vaccine hesitancy, anti-vaxxism will not help, but together united, we can get there.
By getting vaccinated, you will be playing your part in ensuring that the country reaches herd immunity. That way, we can all go back to live life in a safe environment. Getting vaccinated means protecting yourself, your family, and the workplace.
All of us would like to return to the life we knew before COVID. And the closest that we may come to that is if the majority of the population vaccinate, inclusive of the employees within local government.
We are all vaccinated against smallpox, measles, and polio. These illnesses have virtually been eradicated in today's society. In my capacity as a shop steward and president of Imati, I meet with Imati members on a daily basis. Even though I've been vaccinated, I'm still very aware of the pandemic. So I still wear my mask, I frequently wash my hands, and I try to keep a safe distance from people.
Bona mina kungcono ukuthi wonke umuntu makavaccinate afollowe ama-procedure nama-protocol wombuso wonke ukuthi kube nama-attendant registers, sifake ama-mask, wonke umuntu ngimgcugcuzela ngimkhuthazele ukuthi maka-vaccinate ukuthi sihlale siphephile.
Ke o mongwe wa bona ba eleng gore ke tlo thoma go tšea lona lemau leo e ke iswerego ke karata yeo e hwetšago ga o fetša go hlaba lemau la rena. Lemau le la ge o le hlabile ke lona e leng gore le go thuša mašole a gago a mmele gore bolwetši jo la ge bo fihla mmeleng wa gago bo seke jo a ba le maatla mo go wena wa kgona go thušega ka ona ga a le go fekeetše godimo ga bolwetši jola bo a fihla jwa seke jo a ba le maatla wena ka wena ge o kgonne go tšea lemau lela ke lona le go thušago go ba le ona maatla ao.
Ek moet sê dit is baie vreesaanjaend omdat jy weet nooit wie kan vir jou 'n probleem veroorsaak in terme van jou gesondheid. Dit wil sê wanneer iemand nie gevaksinneer is nie, het jy ook nie sekerheid wat kan met jou gebeur as jy met hom of haar in aanraking kom. So dit sê vir my is net goed dat 'n mens vir jou gaan vaksineer en dat jy ook alhoewel jy gevaksinneer is, nogtans versigtig moet wees omdat die lewe is nie meer gewaarborg nie.
This fight is not only in South Africa, it's global. The World Health Organization targets that by mid-2022, 70% of the world's population must be vaccinated. We all need to play our part, and maybe, just maybe, this can disappear too, like smallpox. Do the right thing.
Thank you so much. Thank you so much, ladies and gentlemen. At this point in time, there are no questions. So we're gonna just quickly break for lunch and we'll come back at 1:30, please. 13:30, we are coming back for our session so that we catch up on the time lost. Thank you so much.
My name is Tolile George. I'm the Chief Executive Officer of SALGA. We are now turning 25 years as an organization of municipalities. The importance of this cannot be underestimated in the sense that here is an organization whose life is intertwined with the reality of how the democratic life of our country has unfolded since 1994.
By the very nature of the kind of organization SALGA is, it requires that the people that work at SALGA are thought leaders in their own areas of work. They can think ahead of the municipalities.
I am Lance, the surname is Joe. I am the Chief of Operations. And we, from an operations point of view, play a coordination role. There is Team SALGA that finds expression across 10 different offices. Then within Team SALGA, there are teams which I would call functional teams. And those functional teams spread across clusters.
My experience personally of SALGA is that they've never any question I've asked them and they've been unable to respond to or to guide. Whether I'm asking it as a mayor or as a president of SALGA or somebody from another council threw it to me and I said, I'll go and check on it. I know them by heart because
at any given time, whether we're sitting at that PCC, there is a question, you always have them as a backup to make sure that you understand the context, you understand what is the best policy directive that local government needs to take in the country, whether it's Mtobisi, whether it's Lance Jewel, whether it's Homoto, quite knowledgeable people coming from their different areas of fields, expertise, qualified experts in the field of what they're working on.
I am Commercial Litsatsi. I'm the Chief Officer for Municipal Finance, Fiscal Policy, Trading Services, and Economic Development and Trade and Investment Promotion.
My name is Mtobeli Kolisa. I'm the Chief Officer responsible for the IDS cluster, Infrastructure Delivery, Spatial Transformation and Inclusivity.
My name is Kutlwano Chaba. I'm the Chief Digital Officer at SALGA.
I am Riona Luchungu, the Chief Officer for the Municipal Capabilities and Governance Cluster.
I am Tembe Kamtetwa. I am the Chief Financial Officer for SALGA.
We are servicing 257 municipal members that are spread across the length and breadth of the country.
SALGA is celebrating 25 years of local existence. And within that 25 years, over the past 9 years, SALGA has achieved clean audits.
They have been a great institution, 8 clean audits in a row. And they don't brag about it. I mean, I don't get it. Tembe was presenting and she was asking the National Executive to condone 50 rand, just only 50 rand irregular. And I was like, 50 rand, 10, 12, 20, 50. I said, I wish I can take you to many of my municipalities.
Really what takes clean audits is hard work, ethical and professional employees, good leadership, and as well as making sure that we comply with all the regulatory requirements.
You see some great work being done by SALGA during the transition of every new administration of local government, where they do councillor induction, where the councillors are brought in, trained on the various legislation that affect their areas, how local government works, what is expected of them. And yes, the gap that remains is how then we also allow them to be productive in their work. And part of that is teaching them and introducing them to digital technologies that could make their work much easier and much more effective in delivering services to the citizens.
The South African Local Government Association, that's SALGA, has revealed that 62% of municipal councillors do not know how to use a computer. This means they also struggle to pass municipal budgets.
In KwaZulu-Natal now, barely over 300 councillors have passed matric out of nearly 2,000 working in the province.
The essence comes from a study that SALGA has conducted in trying to push for the professionalization of local government. We have met with political parties. I saw one political party announcing its candidates, taking a pledge. And key of their announcement as I was watching was the qualifications of councillors.
Key and fundamental, as a councillor, for you to be effective and efficient, you must read a lot.
When I get into local government, I came with a teaching background. From there, I decided to register myself with the university so that I can study public management admin. So I managed within a short space of 5 years, 3 years, then I was able to graduate with a degree of public admin and management. Then after 3 years, then I registered my master's. As I'm speaking now, I've already completed my master's. So this is part of the things that we have done in local government. Not only here, I'm just citing an example of an individual.
SALGA was able to launch the School of Excellence, which is the school for local government, both for employees and employers.
Let's bring you your business update at the Samoa. Municipal workers have agreed to a 3-year, 3.5% wage deal. The SA Local Government Association says negotiations weren't easy and a mediator had to be brought in.
Over the last couple of years, we have been at the forefront of creating a stable employee relations environment for the sector, and we've done so by successfully negotiating consecutive multi-year agreements for the sector, which have created stability in the sector, in that we have avoided what was historically a challenge for the sector, labor unrest, labor instability that was created by negotiations that would occur every year.
I'd like to wish SALGA a happy 25th anniversary, a great milestone which has seen an association which has grown in leaps and bounds. 8 clean audits in a row, not by small feat. Development of municipalities, it's shaping from the white paper to the 257 walls of municipalities that we have today. I would like to say, continue on the positive strength that you have. Continue advocating for municipalities and continue for ensuring that the welfare of our communities rests in best hands with the advisory that you always give to all of us. Ohole, ohole, SALGA.
My name is Kohlrabi George. I'm the Chief Executive Officer of SALGA. We are now turning 25 years as an organization of municipalities. The importance of this cannot be underestimated, in the sense that here is an organization whose life is intertwined with the reality of how the democratic life of our country has unfolded since 1994.
By the very nature of the kind of organization SALGA is, it requires that the people that work at SALGA are thought leaders in their own areas of work. They can think ahead of the municipalities.
I am Lance, the surname is Joe. I am the Chief of Operations, and we, from an operations point of view, play a coordination role. There is Team SALGA that finds expression across 10 different offices. Then within Team SALGA, there are teams which I would call functional teams. And those functional teams spread across clusters.
My experience personally of SALGA is that they've never any question I've asked them and they've been unable to respond to or to guide. Whether I'm asking it as a mayor or as a president of SALGA or somebody from another council threw it to me and I said, I'll go and check on it. I know them by heart because at any given time, whether we're sitting at that PCC, there is a question, you always have them as a backup to make sure that you understand the context, you understand what is the best policy directive that local government needs to take in the country, whether it's Mtobisi, whether it's Lance Jewel, whether it's Homoto, quite knowledgeable people coming from their different areas of fields, expertise, qualified experts in the field of what they're working on.
I am Kohlrabi. I'm the Chief Officer for Municipal Finance, Fiscal Policy, Trading Services, and Economic Development and Trade and Investment Promotion.
My name is Hba Regulations. I'm the Chief Officer responsible for the IDS cluster, Infrastructure Delivery, Spatial Transformation and Inclusivity.
My name is Untitled Chapter. I'm the Chief Digital Officer at SALGA.
I am Chungu, the Chief Officer for the Municipal Capabilities and Governance Cluster.
I am Hba Regulations. I am the Chief Financial Officer for for SALGA.
We are servicing 257 municipal members that are spread across the length and breadth of the country.
SALGA is celebrating 25 years of local existence. And within that 25 years, over the past 9 years, SALGA has achieved clean audits.
They have been a great institution, 8 clean audits in a row. And they don't brag about it. I mean, I don't get it. Thembeka was presenting and she was asking the National Executive to condone 50 rand, just only 50 rand, irregular. And I was like, 50 rand, 10, 12, 20, 50. I said, I wish I can take you to many of my municipalities.
Really what takes clean audits is hard work, ethical and professional employees, good leadership, and as well as making sure that we comply with all the regulatory requirements.
You see some great work being done by SALGA during the transition of every new administration of local government, where they do councillor induction, where the councillors are brought in, trained on the various legislation that affect their areas, how local government works, what is expected of them. And yes, the gap that remains is how then we also allow them to be productive in their work. And part of that is teaching them and introducing them to digital technologies that could make their work much easier and much more effective in delivering services to the citizens.
The South African Local Government Association, that's SALGA, has revealed that 62% of municipal councillors do not know how to use a computer. This means they also struggle to pass municipal budgets.
In KwaZulu-Natal now, barely over 300 councillors have passed matric out of nearly 2,000 working in the province.
The essence comes from a study that SALGA has conducted in trying to push for the professionalization of local government. We have met with political parties. I saw one political party announcing its candidates, taking a pledge. And key of their announcement as I was watching was the qualifications of councillors.
Key and fundamental. As a councillor, for you to be effective and efficient, you must read a lot.
When I get into local government, I came with a teaching background. From there, I decided to register myself with the university so that I can study public management admin. So I managed within a short space of 5 years, 3 years, then I was able to graduate with a degree of public admin and management. Then after 3 years, then I registered my master's. As I'm speaking now, I've already completed my master's. So this is part of the things that we have done in local government. Not only here, I'm just citing an example of an individual.
SALGA was able to launch the School of Excellence, which is the school for local government, both for employees and employers.
Let's bring you a business update at the Samoa. Municipal workers have agreed to a 3-year, 3.5% wage deal. The SA Local Government Association says negotiations weren't easy and a mediator had to be brought in.
Over the last couple of years, we have been at the forefront of creating a stable employee relations environment for the sector, and we've done so by successfully negotiating consecutive multi-year agreements for the sector, which have created stability in the sector, in that we have avoided what was historically a challenge for the sector, labor unrest, labor instability that was created by negotiations that would occur every year.
I'd like to wish SALGA a happy 25th anniversary. A great milestone, a milestone which has seen an association which has grown in leaps and bounds. 8 clean audits in a row, not by small feat. Development of municipalities, it's shaping from the white paper to the 257 walls of municipalities that we have today. I would like to say continue on the positive strength that you have. Continue advocating for municipalities and continue for ensuring that the welfare of our communities rests in best hands with the advisory that you always give to all of us. Ohole, Salga.
My name is Kohlrabi George. I'm the Chief Executive Officer of SALGA. We are now turning 25 years as an organization of municipalities. The importance of this cannot be underestimated in the sense that here is an organization whose life is intertwined with the reality of how the democratic life of our country has unfolded since 1994.
By the very nature of the kind of organization SALGA is, it requires that the people that work at SALGA are thought leaders in their own areas of work. They can think ahead of the municipalities.
I am Lance, the surname is Joe. I am the Chief of Operations. And we, from an operations point of view, play a coordination role. There is Team SALGA that finds expression across 10 different offices. Then within Team SALGA, there are teams which I would call functional teams. And those functional teams spread across clusters.
My experience personally of SALGA is that they've never any question I've asked them and they've been unable to respond to or to guide. Whether I'm asking it as a mayor or as a president of SALGA or somebody from another council threw it to me and I said, I'll go and check on it. I know them by heart because at any given time, whether we're sitting at that PCC, there is a question, you always have them as a backup to make sure that you understand the context, you understand what is the best policy directive that local government needs to take in the country, whether it's Mtobisi, whether it's Lance Jewel, whether it's Homoto, quite knowledgeable people coming from their different areas of fields, expertise, qualified experts in the field of what they're working on.
I am Commercial Litasi. I'm the Chief Officer for Municipal Finance, Fiscal Policy, Trading Services, and Economic Development and Trade and Investment Promotion.
My name is Hba Regulations. I'm the Chief Officer responsible for the IDS cluster, Infrastructure Delivery, Spatial Transformation and Inclusivity.
My name is Untitled Chapter. I'm the Chief Digital Officer at SALGA.
I am Riona Luchungu, the Chief Officer for the Municipal Capabilities and Governance Cluster.
I am Hba Regulations. I am the Chief Financial Officer for SALGA.
We are servicing 257 municipal members that are spread across the length and breadth of the country.
SALGA is celebrating 25 years of local existence. And within that 25 years, over the past 9 years, SALGA has achieved clean audits.
They have been a great institution, 8 clean audits in a row. And they don't brag about it. I mean, I don't get it. Hba was presenting and she was asking the National Executive to condone 50 rand, just only 50 rand irregular. And I was like, 50 rand, 10, 12, 20, 50. I said, I wish I can take you to many of my municipalities.
Really what takes clean audits is hard work, ethical and professional employees, good leadership, and as well as making sure that we comply with all the regulatory requirements.
You see some great work being done by SALGA during the transition of every new administration of local government, where they do councillor induction, where the councillors are brought in, trained on the various legislation that affect their areas, how local government works, what is expected of them. And yes, the gap that remains is how then we also allow them to be productive in their work. And part of that is teaching them and introducing them to digital technologies that could make their work much easier and much more effective in delivering services to the citizens.
The South African Local Government Association, that's SALGA, has revealed that 62% of municipal councillors do not know how to use a computer. This means they also struggle to pass municipal budgets.
In KwaZulu-Natal now, barely over 300 councillors have passed matric out of nearly 2,000 working in the province.
The essence comes from a study that SALGA has conducted in trying to push for the professionalization of local government. We have met with political parties. I saw one political party announcing its candidates, taking a pledge. And key of their announcement as I was watching was the qualifications of councillors.
Key and fundamental. As a councillor, for you to be effective and efficient, you must read a lot.
When I get into local government, I came with a teaching background. From there, I decided to register myself with the university so that I can study public management admin. So I managed within a short space of 5 years, 3 years, then I was able to graduate with a degree of public admin and management. Then after 3 years, then I registered my master's. As I'm speaking now, I've already completed my master's. So this is part of the things that we have done in local government. Not only here, I'm just citing an example of an individual.
SALGA was able to launch the School of Excellence, which is the school for local government, both for employees and employers.
Let's bring you your business update at the Samoa. Municipal workers have agreed to a 3-year, 3.5% wage deal. The SA Local Government Association says negotiations weren't easy and a mediator had to be brought in.
Over the last couple of years, we have been at the forefront of creating a stable employee relations environment for the sector, and we've done so by successfully negotiating consecutive multi-year agreements for the sector, which have created stability in the sector, in that we have avoided what was historically a challenge for the sector, labor unrest, labor instability that was created by negotiations that would occur every year.
I'd like to wish SALGA a happy 25th anniversary. A great milestone, a milestone which has seen an association which has grown in leaps and bounds. 8 clean audits in a row, not by small feat. Development of municipalities, its shaping from the white paper to the 257 walls of municipalities that we have today. I would like to say, continue on the positive strength that you have. Continue advocating for municipalities and continue for ensuring that the welfare of our communities rests in best hands with the advisory that you always give to all of us. Ohole, ohole, SALGA.
My name is Kohlrabi. I'm the Chief Executive Officer of SALGA. We are now turning 25 years as an organization of municipalities. The importance of this cannot be underestimated in the sense that here is an organization whose life is intertwined with the reality of how the democratic life of our country has unfolded since 1994.
By the very nature of the kind of organization SALGA is, it requires that the people that work at SALGA are thought leaders in their own areas of work. They can think ahead of the municipalities.
I am Lance, the surname is Joe. I am the Chief of Operations. And we, from an operations point of view, play a coordination role. There is Team Salga that finds expression across 10 different offices. Then within Team Salga, there are teams which I would call functional teams. And those functional teams spread across clusters.
My experience personally of Salga is that they've never any question I've asked them and they've been unable to respond to or to guide. Whether I'm asking it as a mayor or as a president of Salga or somebody from another council threw it to me and I said, I'll go and check on it. I know them by heart because at any given time, whether we're sitting at that PCC, there is a question, you always have them as a backup to make sure that you understand the context, you understand what is the best policy directive that local government needs to take in the country, whether it's Mtobisi, whether it's Lance Jewel, whether it's Homoto, quite knowledgeable people coming from their different areas of fields, expertise, qualified experts in the field of what they're working on.
I am Commercial Lutati. I'm the Chief Officer for Municipal Finance, Fiscal Policy, Trading Services, and Economic Development and Trade and Investment Promotion.
My name is Hba Regulations. I'm the Chief Officer responsible for the IDS cluster, Infrastructure Delivery, Spatial Transformation and Inclusivity.
My name is Kohlrabi. I'm the Chief Digital Officer at Salga.
I am Riona Luchungu, the Chief Officer for the Municipal Capabilities and Governance Cluster.
I am Hba Regulations. I am the Chief Financial Officer for Salga.
We are servicing 257 municipal members that are spread across the length and breadth of the country.
Salga is celebrating 25 years of local existence. And within that 25 years, over the past 9 years, Salga has achieved clean audits.
They have been a great institution, 8 clean audits in a row. And they don't brag about it. I mean, I don't get it. Hba was presenting and she was asking the National Executive to condone 50 rand, just only 50 rand irregular. And I was like, 50 rand, 10, 12, 20, 50. I said, I wish I can take you to many of my municipalities.
Really what takes clean audits is hard work, ethical and professional employees, good leadership, and as well as making sure that we comply with all the regulatory requirements.
You see some great work being done by Salga during the transition of every new administration of local government, where they do councillor induction, where the councillors are brought in, trained on the various legislation that affect their areas, how local government works, what is expected of them. And yes, the gap that remains is how then we also allow them to be productive in their work. And part of that is teaching them and introducing them to digital technologies that could make their work much easier and much more effective in delivering services to the citizens.
The South African Local Government Association, that's Salga, has revealed that 62% of municipal councillors do not know how to use a computer. This means they also struggle to pass municipal budgets.
In KwaZulu-Natal now, barely over 300 councillors have passed matric out of nearly 2,000 working in the province.
The essence comes from a study that Salga has conducted in trying to push for the professionalization of local government. We have met with political parties. I saw one political party announcing its candidates, taking a pledge. And key of their announcement as I was watching was the qualifications of councillors.
Key and fundamental. As a councillor, for you to be effective and efficient, you must read a lot.
When I get into local government, I came with a teaching background. From there, I decided to register myself with the university so that I can study public management admin. So I managed within a short space of 5 years, 3 years, then I was able to graduate with a degree of public admin and management. Then after 3 years, then I registered my master's. As I'm speaking now, I've already completed my master's. So this is part of the things that we have done in local government. Not only here, I'm just citing an example of an individual.
SALGA was able to launch the School of Excellence, which is the school for local government, both for employees and employers.
Let's bring you a business update at the Samoa. Municipal workers have agreed to a 3-year, 3.5% wage deal. The SA Local Government Association says negotiations weren't easy and a mediator had to be brought in.
Over the last couple of years, we have been at the forefront of creating a stable employee relations environment for the sector, and we've done so by successfully negotiating consecutive multi-year agreements for the sector, which have created stability in the sector, in that we have avoided what was historically a challenge for the sector, labor unrest, labor instability that was created by negotiations that would occur every year.
I'd like to wish SALGA a happy 25th anniversary. A great milestone, a milestone which has seen an association which has grown in leaps and bounds. 8 clean audits in a row, not by small feat. Development of municipalities, its shaping from the white paper to the 257 walls of municipalities that we have today. I would like to say, continue on the positive strength that you have. Continue advocating for municipalities and continue for ensuring that the welfare of our communities rests in best hands with the advisory that you always give to all of us. Ohole, ohole, SALGA.
My name is Kohlrabi. I'm the Chief Executive Officer of SALGA. We are now turning 25 years as an organization of municipalities. The importance of this cannot be underestimated in the sense that here is an organization whose life is intertwined with the reality of how the democratic life of our country has unfolded since 1994.
By the very nature of the kind of organization SALGA is, it requires that the people that work at SALGA are thought leaders in their own areas of work. They can think ahead of the municipalities.
I am Lance, the surname is Joe. I am the Chief of Operations, and we, from an operations point of view, play a coordination role. There is Team SALGA that finds expression across 10 different offices. Then within Team SALGA, there are teams which I would call functional teams. And those functional teams spread across clusters.
My experience personally of SALGA is that they've never any question I've asked them and they've been unable to respond to or to guide. Whether I'm asking it as a mayor or as a president of SALGA or somebody from another council threw it to me and I said, I'll go and check on it. I know them by heart because at any given time, whether we're sitting at that PCC, there is a question, you always have them as a backup to make sure that you understand the context, you understand what is the best policy directive that local government needs to take in the country, whether it's Mtobisi, whether it's Lance Jewel, whether it's Homoto, quite knowledgeable people coming from their different areas of fields expertise, qualified experts in the field of what they're working on.
I am Kohlrabi. I'm the Chief Officer for Municipal Finance, Fiscal Policy, Trading Services, and Economic Development and Trade and Investment Promotion.
My name is Hba Regulations. I'm the Chief Officer responsible for the IDS cluster, Infrastructure Delivery, Spatial Transformation and Inclusivity.
My name is Hba. I'm the Chief Digital Officer at SALGA.
I am Rionolu Chungu, the Chief Officer for the Municipal Capabilities and Governance Cluster.
I am Hba. I am the Chief Financial Officer for SALGA.
We are servicing 257 municipal members that are spread across the length and breadth of the country.
SALGA is celebrating 25 years of local existence. And within that 25 years, over the past 9 years, SALGA has achieved clean audits.
They have been a great institution, 8 clean audits in a row. And they don't brag about it. I mean, I don't get it. Thembeka was presenting, and she was asking the National Executive to condone 50 rand, just only 50 rand irregular. And I was like, 50 rand, 10, 12, 20, 50. I said, I wish I can take you to many of my municipalities.
Really what takes clean audits is hard work, ethical and professional employees, good leadership, and as well as making sure that we comply with all the regulatory requirements.
You see some great work being done by SALGA during the transition of every new administration of local government, where they do councillor induction, where the councillors are brought in, trained on the various legislation that affect their areas, how local government works, what is expected of them. And yes, the gap that remains is how then we also allow them to be productive in their work. And part of that is teaching them and introducing them to digital technologies that could make their work much easier and much more effective in delivering services to the citizens.
The South African Local Government Association, that's SALGA, has revealed that 62% of municipal councillors do not know how to use a computer. This means they also struggle to pass municipal budgets.
In KwaZulu-Natal now, barely over 300 councillors have passed matric out of nearly 2,000 working in the province.
The essence comes from a study that SALGA has conducted in trying to push for the professionalization of local government. We have met with political parties. I saw one political party announcing its candidates, taking a pledge. And key of their announcement as I was watching was the qualifications of councillors.
Key and fundamental. As a councillor, for you to be effective and efficient, you must read a lot.
When I get into local government, I came with a teaching background. From there, I decided to register myself with the university so that I can study public management admin. So I managed within a short space of 5 years, 3 years, then I was able to graduate with a degree of public admin and management. Then after 3 years, then I registered my master's. As I'm speaking now, I've already completed my master's. So this is part of the things that we have done in local government. Not only here, I'm just citing an example of an individual.
SALGA was able to launch the School of Excellence, which is the school for local government, both for employees and employers.
Let's bring you a business update at the Samoa. Municipal workers have agreed to a 3-year, 3.5% wage deal. The SA Local Government Association says negotiations weren't easy and a mediator had to be brought in.
Over the last couple of years, we have been at the forefront of creating a stable employee relations environment for the sector, and we've done so by successfully negotiating consecutive multi-year agreements for the sector, which have created stability in the sector, in that we have avoided what was historically a challenge for the sector, labor unrest, labor instability that was created by negotiations that would occur every year.
I'd like to wish SALGA a happy 25th anniversary, a great milestone, a milestone which has seen an association which has grown in leaps and bounds. 8 clean audits in a row.
We're good. Kohlrabi. Thank you so much, ladies and gentlemen. Thank you for everyone who's online. Thank you that you took time to wait for us. Sorry for the delay. Right now, please allow me to call upon stage Gerard Greveling, who's coming to assist us to facilitate this particular interaction. Please put our hands together for Gerard, please.
Thank you so much. It's really an honor and a privilege to be asked to facilitate this session. As correctly said, my name is Gerard, surname is Greveling. In local government, because of the long surname, they call me Gigi. So anybody who would like, if you're not sure, Gigi is very easy to do. I will be facilitating. I'm the Senior Advisor, Human Resources, Labour Relations and Collective Bargaining at SALGA KZN. I think you will all find this session quite useful. You would note that we will be dealing with the pertinent issues, first of all, of course, the pension fund restructuring. Many questions have been raised after the conclusion of the collective agreement. We will also deal with effective local labour forums, and then also deal with job evaluation. What value can job evaluation add to a municipality? The way in which we're going to do it is we're going to have short presentations. The first presentation will be by John Morby. He's from the Johannesburg City Council. He will be presenting on the new pension fund dispensation. So that will be a virtual, and then the other colleagues will just follow after John has presented. Our other colleagues are Komotso Twini, and then also Nozipo Shandu. They will be presenting on effective local labour forums, and then also on the remuneration and job evaluation. So I think we can start then with the first presentation. Thank you so much. John, can you possibly just unmute? We can't hear you. So if you could just unmute.
Can you hear me now, Mr. Facilitator? Can you hear me? Thanks, Facilitator. My presentation is going to be, like you said earlier on, very straightforward. It's going to be very short. My presentation is around what we're trying to do in the sector currently, which is to rationalize the pension funds that we are having in the sector. Facilitator, I think what is important is to start with the background. As we all know that in 2001, SALGA has initiated the restructuring project for all pension funds in the sector. The primary objective of that project, Mr. Facilitator and colleagues, was to ensure at least two things: financial sustainability of our pension funds and also cost containment. Following, there were discussions under the auspices of the Bargaining Council, which culminated in the retirement fund agreement, which was, I think, signed into an agreement in 2021. The cornerstone of this agreement, colleagues, are as follows. We are trying to at least get a uniform approach to the provisions of the retirement fund benefits in the sector. We're also trying to get at least equitable access to all employees in the sector to our pension funds. And we're also trying to at least achieve uniform rates of contributions to the retirement funds in the sector. 4, we're also trying to improve the efficiency and governance of our pension funds. And 5, we tried at least to give everybody an opportunity to belong to a fund as long as that fund is agreed by the Bargaining Council. So this, in essence, will translate into freedom of our employees to choose funds they want to belong to, which is not the case currently. Can we then move to the next slide? Mr. Facilitator and colleagues, this agreement shall apply to all employees falling under the register scope of the Bargaining Council. The agreement, however, has got some exclusions. The express exclusion in the agreement, we will exclude city managers and anyone who reports to those municipal managers, or what in terms of Section 56 of the Systems Act, they call managers accountable directly to the city manager. The agreement was signed into effect on the 15th of September 2021, and then we foresee the implementation date as the 1st of July 2022. Next slide, please. Now let's deal with the background. According to Stats SA, there are about 280,000 employees employed in the sector. The sector has got 3 types of pension funds. We have got the DB fund, we have got the DC fund, and we also have an hybrid of both. All the parties to the SLGBC at the time of the signing of the agreement, we all agreed that we need to curtail at least admin costs, and there were also issues of governance that we thought needs to be sorted out. For an example, when it comes to the issues of admin costs, in the city of Johannesburg, we have got at least in the core administration, at least 8 pension funds, whereas in MEs we have got plus or minus 12 pension funds. That in total, if you do your math, will amount to 20 funds. Which funds are all residing in a single employer, and this obviously will have inordinate cost when it comes to admin cost. So all these pension funds have their own rules, and we notwithstanding the fact that the employer is single, and our view is that this is not sustainable in the future, and that's why there is a need for rationalization of this pension fund, so that at least we can curtail not only the cost, also deal with the issue of governance, and also deal with this very sizable number of pension funds, which comes with different rules, and sometimes even when they are falling under the same employer. Can we go to another slide, please? Slide number 4. DB funds, we all know that have been exposed has been exposing municipalities to unnecessary financial strain and owing to the manner in which they are structured. So at some stage, parties to the bargaining council agreed to appoint Chris Todd of Bowman Gilfilans to facilitate at least the engagement between the parties to the council in order to at least try and come with an agreement, which agreement shall at least try and rationalize the then dispensation of pensions. The parties also resolved to appoint Jeremy Andrew, an actuarial scientist, to assist in the assessment of financial consequences of the collective agreement in the event we were to conclude the agreement. Can we go to another slide, please? Here are the critical observations on the governance of our pension funds. The actuarial scientists assessed information from Financial Service Conduct Authority relating to at least 44 pension funds operating in the sector. In case, and this is just a synopsis or a scenario of what the findings were, in case of one fund, an annual investment management fee were found to be to the tune of 165 million. In case of another, admin fees were found to be of the tune of 79 million. And in one case, annual board fees were to be around 6.7 million. In another case, staff expenses were around 30 million, 13 million. And we can all agree, colleagues, that this state of affairs required that parties to the bargaining council rationalize pension funds and at least try and ensure that this abuse of employees' funds is curtailed. Another slide, please. Now, let's talk about the agreement. This agreement is an agreement as envisaged in Section 31 of the Hba Regulations Act. The effects are that it binds all employees employed in the sector, save for the ones that we alluded earlier that will be excluded. New employees in the sector will be required or permitted to join only an accredited defined contribution retirement fund in which their employer participates. Contributions will be made to only, and this is important, only accredited funds. In terms of Section 13 of 13A of the PFA, all contributions will be paid within 7 days from the day or the deduction by the employer. Another slide, please. In terms of the agreement, new employees in the sector will be permitted to join only a fund that is accredited and is also a DC fund in which their employer participates. Within 6 months of the implementation date of this agreement that we're talking about, all existing employees will be given an opportunity to transfer to at least an accredited DC fund. Next slide, please. Accreditation criteria focuses on governance, like I said earlier on, and administrative issues. Those will be the core that will underpin our administrative criteria. Employers in the sector will contribute as participants to only funds that are accredited. Council will then publish a list of accredited funds which will be made available to all employers. Employees may elect to join any fund as long as it's accredited. In all service members may elect to be transferred only into, like I said, a DC accredited fund in which the employer participates. Next slide. The employer will contribute 18% of the pensionable salary into an accredited fund. If the employer paid a higher rate to an accredited fund towards a defined contribution fund, then that employer shall continue to pay such higher rates. But however, there can be exceptions where a new agreement is concluded. In that case, if there is a new collective agreement, that they can go back to the default position that I've earlier stated. Another slide, please. Non-accredited funds will be served with a notice of full or partial termination, but of course this will be subject to the Pension Fund Act. Payment to in-service members of the old fund will cease to exist. Like we said earlier on, that payments going forward will only be allowed to go into funds that have been accredited by the SLGBC and will thereafter be made to ADC fund which is accredited. Pre-1998 tax benefits will be preserved. The employer will assume responsibility for any shortfall in the event of a transfer of members from a non-accredited funds, including funds that might be under liquidation, to a DC accredited fund. Next slide, please. On the issue of implementation, SLGBC through its ESCO will be responsible for the oversight and accreditation process and the implementation of this agreement. However, municipal managers are still held responsible for the implementation of the terms of the agreement. Let's now talk about dispute about application or interpretation of this agreement. Any party to this agreement may refer a dispute to the secretary of the SLGBC. Then your normal dispute resolution procedure will apply, which means that the matter will be referred for conciliation. If conciliation fails and the party elects to refer the matter to arbitration, an arbitrator will then be appointed to deal with that matter as a matter of arbitration. Next slide, please. Now, let's go back to the last slide. We have not dealt with the issue of exemptions. Let's deal with the issue of exemptions. The exemption procedure will be as follows. The application shall be lodged on a prescribed form. That's in terms of the procedure. The application shall be considered, and we're using the word shall, which is peremptory, be considered by a senior panelist. And thirdly, a party can then appeal any decision of the senior panelist to the exemptions appeal tribunal, which will refer to as the tribunal. The agreement binds parties to the agreement as a collective agreement of this bargaining council. Let's go to the next slide. In conclusion, colleagues, we want this conference to note the following. That the accreditation criteria has to be satisfied by all pension funds for them to continue to operate in the sector. And number two, we are saying that as a transitional measure, there might be dual pension fund regime of both DBs and DCs that meet our objective criteria. Number three, we are saying that the moratorium on transfers must be allowed in order to safeguard the interest of all employees. Number four, we are saying good governance must be the key factor that underpins the criteria of accreditation. Number five, we are saying that admin cost must also be considered as a key criteria that one must consider before deciding whether accreditation, one party has met accreditation criteria or not. Number six, we are saying the issue of measures of pension funds must be left to those pension funds individually, and the SLGBC must not get involved. Number seven, we are saying in cases where we have identified irregularities, those irregularities must be then reported to the pension fund adjudicator for the pension fund adjudicator's consideration. And next slide. And then we are saying also that municipalities must at least keep the database funds within their admin, so that at least we are aware of the number of pension funds that have been operating within each and every municipality. Colleagues, I think the rest, it's just academic. You can read the rest for yourself. And I think that will be the end of the short presentation as I promised. Thanks, Facilitator.
Thank you for that, John. If you could also just remain on the platform, so when we do our engagements after the presentations, that you will also be part of it. Thank you so much for the presentation. Thank you so much. So if you could then just come and deal with how do you ensure that we've got effective local labor forums. Komotso is going to deal with that just from, I think you're from the Greater Letaba municipality. He's the manager legal at the municipality. Over to you. Thank you so much.
Thanks very much, Gigi. Let me take this opportunity to greet everyone and also colleagues who are participating in this seminar visually. I think firstly, we should just ask ourselves as to what does it mean by local labor forum. The local labor forum, by definition, is the forum established at the workplace with a representation, equal representation from both the employer and the employee. And that is contemplated in terms of the main collective agreement. I think colleagues will know that our main Bible in local government, that is the main collective agreement. And it's also important to know that the LLF is meant to cater the interest of the employees, but also indicate as to which employees do we classify as the interests which need to be catered on. Employees means all employees employed by the municipality, except those appointed as senior managers, because they are not form part. They do not form part of the bargaining employees. So it means to cater all employees except senior managers. What is the main aim of local labor forum? Its main objective, among others, will be to enhance efficiency in the workplace, to be consulted with the employer with the view of reaching consensus, and also created as a platform for employees to form part of decision-making within the workplace. But we all know that in most cases, either party with ulterior motive will try to use the platform to deviate from its main objective and establishment. There are challenges. There are challenges pertaining to the local functionality of the local labor forum. Among others, which is common within municipalities, is the issue of power struggle between the employees and the employer. Parties to the local labor forum decide to deviate from the main objective, which is meant to be created, to be utilized as a platform to deal with the issues which cannot be referred to the council or bargaining council for mediation. Among other things which need to be addressed, or which could be addressed at that level, is the issue of parties need to deliberate on issues which affect the merger of municipalities in the event municipality A is merged with municipality B due to reasons which could have been advanced. That issue obviously need to be discussed at the local labor forum between the labor and management to see how best can they reach consensus in terms of the issues and the smooth transfer or merger if there is any. There is also the issue of job grading. Obviously, that has been the thorny issue in terms of local government issues currently. That particular issue also forms part of the issue which could be discussed at that level. The local labor forum need also to be consulted on issues which are affecting the restructuring due to technological issues. We know that we are heading at the 4IR. Obviously, there'll be some issues which will also affect employees which need to be discussed at that particular level. There is also the issue of the skills and training, which also very much important in terms of issues which need to be deliberated at that level. So based on what I've already indicated shortly, it's for local labor forum to be fully functional, there need to be that understanding between the employer party and the organized labor, which are the unions, IMATU and SAMU, as to why are we having that kind of platform? For what good reasons do we need to have that particular platform, and what the other thing which need to be addressed there, I've alluded on the issue of the challenges which might be there, but the other challenge which need to be addressed, which is very much important, is the issue of bringing employees on decision making. Obviously, from the management side, they will feel that their authority as management will be bled by involvement of employees. Obviously, they will need to make inputs, and on the other side of the management or on the employer, they will feel that their space has been tempered. So it's all very much important that the parties to the local labor forum need to understand what is required of them, and what is it that the behavior which will assist in the smooth running of the institutions, and also enhancing the efficiency of the municipalities, which at the end of the day won't tamper with service delivery and the full functioning of the municipality. So lastly, I will say that it's very much important, I've been emphasizing the fact that it's very much important that parties need to understand their role in local labor forum, and also refrain from utilizing it as a power struggle, where the organized labor, for instance, will be saying, but without our permission, this cannot be done. On the other side, the employer will be saying, but we are in charge here. We need to do things the way we want them to do. So it's very much important that these parties need to create a common space and understanding as to what is it good for the development and full functioning of the municipality. But critically, the last issue is the issue of what does we mean by consensus. In other instances, organized labor will think that when we say there should be consensus and joint decision makings, it's like they take it as if without them there can't be any move on a particular subject. It shouldn't be taken in that literal meaning. It simply create a platform to say, before management engage or embark on any particular activity like the ones which we have indicated, the skills training, measures, and so forth, they need to have sit around the table in this forum, and at least source inputs from the organized labor as well, which will be representing employees to say, what inputs can you make, but at the end of the day, this is what need to be happening. So briefly, that is my story in relations to the functionality and effectiveness of the local labor forum.
Thank you for that, Komotso. Our last presenter is on what value add is there for our municipalities to have job evaluation. Nozipu Shandu from eThekwini, who's a senior grading and remuneration specialist from eThekwini, will just do a very short presentation, and then we will go into some sort of discussion. Thank you so much.
Thank you, Gerard. I'd like to greet all the colleagues who are physically present and our esteemed guests that are also joining us online. I think first and foremost, it is important to emphasize that when you look at the national policy on task, under the key principles on point 4.3, it states that no post in the local government sector shall be filled without having been subjected to the task job evaluation process. So if as municipalities, we are able to grasp that point to ensure that we do not advertise or fill any positions without having been subjected to this process, then we'll be moving into the right direction. Because when you undertake job evaluation, you ensure that the correct value is attached on that particular position, and that you are able to attract the skills or talent that you want to attract in the municipality. So what value then does job evaluation add in municipalities? Firstly, job evaluation enables accurate budgeting and forecasting. When you've evaluated all your positions and you've allocated all your task grade levels, then you know that when you sit and budget, you know that this is what you're budgeting for, this is how much you are budgeting for, and that leads to good governance and also ensure that you monitor the wage bill. And secondly, you are able to create uniformity and fairness in regard to jobs of equal value. If posts are on the same position in different metros, obviously, naturally, they should be at the same grade level because they're performing functions that are similar and the job is of equal value. And also with job evaluation, it also underpins the performance management systems and provides for the achievement of the IDP and the SDIP mandates for the municipality. As we know that as municipality, we are service delivery driven, and that if we ensure that our employees are treated fairly, they are encouraged, or they also perform at a maximum level in order for us to reach our mandate. It also ensures that duplication within roles are eliminated. See, when you undertake a JE process, you are able to compare jobs within the same structure, and you are able to identify if there is a repetition of a particular function. So when you are undertaking the job evaluation process, then immediately when there's a red flag, you know that you cannot credit two positions for the same functions in the same structure. You are able to identify, you can also source the services of the organizational development department to conduct a work study in that particular department to say that, hang on, I've identified that in this department, there are two positions or four positions performing exactly the same duties, and maybe it is not required. Sometimes you find that maybe in the structure, there's a position that is vacant on top, and then what happens is that the people at the bottom, they end up taking additional functions which they are not supposed to take. But then when you find that, when you have filled that position, then that duplication will be eliminated. And then through the work study process, then they would be able to tell you that no, this is what is required. That position is not required to perform that function. It also allows for the meaningful movement of employees between municipalities, as we all know that you are able to be transferred to another municipality in order to assist with the national service deliveries. And you can only be able to attain that if you have a stable a job evaluation process which you have attained the great outcomes for that municipality. And also the people that you are going to be transferring, obviously they're going to be key specialist positions that you would require to add value in that particular municipality. Job evaluation then also creates a stable workforce. And the fact that in the local government sector, there's labor participation in the JE process, even if it's on an observer status, observers are able to identify that this process is moving into the direction that it's supposed to, or there are red flags which they need to speak up about, and then those would be rectified accordingly. Hence, then it would lead to a stable workforce, and you will not have any challenges in terms of the job evaluation process. You are also then able to attract and retain the required talents and skills that you require in your municipality. You also, the JE process allows for benchmarking of job roles against the national market. We like to compare ourselves into the national market and try and see what is the national market paying for particular positions. And as municipality, we also want to be competitive and become an employer of choice. Hence, then, we are able to compare ourselves in the national market. You also get to adhere to the code of good practice, that is equal pay for work of equal value. So if your job evaluation system is stable, you know that employees undertaking equal work, they get paid or remunerated equally. The JE process then, it also aids in the development of an equitable salary structure. It is important to have an equitable salary structure, as we know that we've got our different salary structures for the different categories of municipalities, and all of them are 2.4%. There's a 2.4% difference between the different notches on the salary scales. Also, with this process, you are able to establish model grades. For example, if a post is a professional nurse, you know that there's a particular grade that is attached to that position, and you know that all professional nurses in municipalities are graded on a particular grade. Then you also have an external body which is established by SALGA, which is called the Provincial Audit Committee, where in the JEUs, after grading the positions, because when they grade, the posts that are graded up are regarded as provisional up until they are submitted to the different provincial audit committees to confirm those grade outcomes. That body then has an overarching role to see and establish that the positions have been graded accordingly. And then when employees see that that is happening, then they are able to trust the system, because the JE process is not only confined at the local level, there is still that step of that external body, which is called the PAC. And then there's also another mechanism of a review application, that when the PAC has audited the grade outcomes and have published the final outcomes report, then employees are then given a chance or 30 days to appeal an outcome to say that maybe I'm performing, I'm in a particular designation. There's another post in the same municipality with the same designation. However, their task grade is higher than mine. So in that review application, then you get to prove that the task system maybe has been applied inconsistently, whereas your grade is lower than the other person. So it is important then to have that, and it's added so much value in terms of stabilizing job evaluation processes in municipalities. And this has led to very, very minimal disputes relating to the job evaluation process because of that kind of interaction with the employees. Before we even embarked on the job evaluation process, we had numerous workshops where we explained to employees what was going to happen, what do they expect to see, and so we brought them in as role players in the process of job evaluation. Then when you have a job evaluation that is stable and adding value in the municipality, you are able then to introduce what is called job specification guidelines, where similar jobs have the same qualifications. When you advertise, you are able to develop the same qualifications, the same number of experience for those jobs, the same jobs. And then employees feel that you recognize additional work, because in the policy it states that if a person has been performing additional duties for a minimum period of 6 months, then they are able to apply for a regrade. So when you have that kind of process, employees, they feel that if they are given additional work which will enhance their work, they are able to do the work because there's this mechanism which will be able to identify the additional work that is performed. So in conclusion, I would like to say that it's important to ensure that job evaluation is implemented effectively in municipalities so that we can reap the rewards of it adding value in the municipality. Thank you.
Whoa, quite a number of questions. Is it possible for me to sit there, or should I stand here? It's better for me to facilitate from here? Better here. Okay, sure. Before I deal with these questions that are on the platform, I think I just want to first of all deal with the first presentation on the pension fund. And the question that I would like to raise is with John is there's an allegation, or some people are complaining that the space for pension funds is not for it. Basically saying that the South African Local Government Bargaining Council shouldn't interfere in the pension fund dispensation. There's legislation and there's an adjudicator. What would your response be to that? Is it necessary for the local government to have come up with this collective agreement on pension funds? And possibly also aligned to that, some employees, of course, fear that they're going to lose their pensions. I think it's that as a result of the collective agreement. If you could also just respond in your own submission, if you looked and analyzed the position at your municipality, is there such a danger that employees will lose their pension funds if pension fund accumulation in what they have accrued? And is there further liability on the employer as a result of that? So if you, John, just from that point, before I get to the question, just on the pension, if you could possibly respond. Need for us to be involved?
Thanks, facilitator. Thanks, facilitator. Thanks, facilitator, for that question. And I think that question was answered in one of the slides that I shared with the colleagues. I think it was slide 9, where we very clear in terms of the agreement that if the employer paid a higher rate to a fund, that was a DC fund, then the employer shall continue paying that rate, notwithstanding the fact that there is a collective agreement in that sector that purports that the employer's contribution should be 18%, which is standard. So rest assured, facilitator, there will be personal holders where employers were paying higher rates to pension funds. And I think it's also one of what we said that the Labour Law Conference must note. We said, amongst things, the Labour Law Conference must note that as a transitional measure, there will be dual possible pension fund regimes, in which, even notwithstanding the fact that we do not necessarily support the DB fund, there might be a situation in the transition and in the interim where DB and DC fund that meet our criteria, our very objective criteria, will then be accredited. So rest assured, we are not here to lower the rates that employers have been paying towards employees' pension funds. What we are doing, we are just trying to rationalize. And let me tell you why I am saying that at this stage it appears to us that rationalization is the correct thing to do. If you look, for example, in the public sector, there is only one pension fund. You look at many bargaining councils like MIPCO, MEIBC, and other bargaining councils or sectors. There is only one pension fund. Here we are not even saying that we will take the right to choice. We're not saying that. We're simply saying we are of the view that most pension funds have abused our employees. They have forsaken the interest of the employees, and they are channeling these funds to other things other than employees' interest. And we are of the view now, with organized labor, of course, that we need to now start and rationalizing these pension funds by first at least creating an accreditation, which is a very objective platform in which one will have to meet those standards that we have said. If you meet the standards, and we have already indicated that we will look into two things. We'll look into the first thing that will underpin our standard will be the issue of governance, and the second issue that we will look into will be the issue of administration. If you do meet those two criteria that we have said, and other criteria as encapsulated in the circular from SLGBC, Circular 10 of 2021, which was released, I think, the 7th of December last year. If you meet all those requirements, you don't have to worry. It will simply mean that you're ticking all the boxes, and from where we sit at, you are not only pursuing your interest as the pension fund, but you're also taking into account the interest of our employees. You then asked about the employees having insecurities insofar as whether at some stage we are going to tamper with what they've already contributed to pension funds. Remember Section 200 of the Labour Relations Act facilitator do say to us that employees can also be represented by unions. And you may also take into account that this collective agreement, the collective agreement which was concluded under the auspices of the bargaining council, or in the bargaining council simply put, which is a Section 31 collective agreement, which means that it will bind any employee who's participating or partaking or working in our sector. And immediately, what comes to mind is what would ordinarily happen to your MEs and other entities of that nature, which are not represented in the bargaining council. Obviously, there is Section 32 of the Labour Relations Act, which will enjoin us to at least through a ministerial extend the collective agreement to them. But that is a topic for another day. From where we are seated, this agreement best will pursue the interest of employees. And at the best, this agreement, I think it's premised on two things. It's premised on good governance and also premised on ensuring that resources of employees are not being abused by pension funds. So what we're trying to do is just to make sure that resources are used for what they are intended for, and nothing more and nothing less. Facilitation. Thanks, facilitation.
Thank you for that. I think there was also another question on the chat box about the pension fund. So whilst you're on it, John, I think you should also just have municipalities been consulted on the conclusion of the collective agreement and possible cost implications. I can respond to that from a SALGA point of view, but I want to ask is, from a municipal perspective, this is the question that have been posed. So I will respond from a SALGA perspective. So I don't know if you're in a position at this stage to respond to that.
Yes, facilitator. I don't want you to descend to the arena. Facilitator, remember before the conclusion of any agreement as SALGA, there are consultation processes, mandating processes that one goes through. And I know, as the City of Johannesburg, that at some stage we were properly consulted and we voted as the City of Johannesburg for this rationalization because it made sense to us. And I think the same has happened across the entire country. And consultation was very extensive, I know. Like I said earlier on, this is a process that was started by SALGA in 2001. And you can imagine 21 years later, 20 years later, we have a product. It will only suggest one thing, a facilitator, that consultation was very extensive. Thanks for the presentation.
I think I'll also just say that from a SALGA perspective, formal processes, as was confirmed, was followed in terms of the conclusion of this pension fund collective agreement. So there were sessions in each province where the proposed agreement was presented and then accepted by municipalities at those sessions. So I think it's important that is noted. Just lastly, there's a question which John will not be able to respond to, the accreditation of the pension funds. That process is currently underway in the Bargaining Council. I think I talk under correction, but I think there's 17 funds that have applied for accreditation. It covers plus minus 160,000 employees of the 50,000 employees that we have in the sector. So and the accreditation committee is currently sitting to accredit those pension funds. So by the time that municipalities will have to make a choice, it will be in place well in time for proper consultation so that municipalities can make a proper decision, or employees, on the funds to be applicable. John, thank you for that. I think I need to come to my colleagues. Just in the question here was just on the LLF and the role of job evaluation in terms of the LLF, because it was mentioned that the LLF plays a role. So, Komocho, if you could just clarify, because generally I think it's for reporting purposes, but you can just possibly just attend to that. I think the rest of the questions I've covered. I just want to Nozipo as well, just ask, how do you still ensure, you are the first municipality, eThekwini, to implement task job evaluation? You were the first. And as a result of that, how do you remain credible with the employees? Isn't there pressures placed, because normally in a practical sense, pressures placed on the job evaluation committee to increase certain levels of employees? So if we could just, those two questions. So the first one is just on the role of the LLF in job evaluation, and then the second one to Nozipo. Is there some more questions?
I can respond to this.
Okay, so must they come and respond here?
Thank you very much. LLF vis-a-vis job evaluation. I think in my presentation I've indicated that among other issues which need to be discussed by the LLF is the issue of job grading. And that is where both the employer and the employee will have to agree on certain issues, like your job descriptions of the employees of this municipality, and also the levels. But in terms of other due processes, I think throughout I'll speak from the province which I'm coming from. Beside issues being deliberated at municipal level, there is a task team which has been composed by municipalities. I believe Salga is there as well as the Coxstar at the provincial level, where the process unfold or is taken forward in terms of the job grading itself. But of important is that at municipal level, that's where organized labor and the management need to agree on issues which affect the employees at the local level. But in terms of processes going forward, it's something which has been done by other platforms, and I don't want to tap into that space. Thanks.
Thank you. So how do we ensure that job evaluation still remains credible? Okay, yes, it is true that eThekwini was the first municipality to implement task. However, being the first to implement task, you still have new employees joining the organization. So what happens is that we still have constant interaction or workshops with the employees. We invite all the role players being management, the labor component, and then we workshop the job evaluation process so that each and every employee understand what the process is, what unfolds in the job evaluation process. And what helps us is that in those workshops we've ensured that we will conduct them in the language of choice so that the message is clear and it's understood by everyone, even at the most grassroots level. So we also had different committees that provide the explanations to staff members, where we also train our labor component, because they go back to their constituencies and they explain as well the process, the scientific process, although you can't go into detail with someone who is not trained in the task system, but you can broadly explain the concept of knowledge, the pressure, influence, and complexity. So that is what we've done, and that has worked for us over the years.
Oh, sorry. Gerard, whilst Nozipo is on stage, there's another question for you that I think requires your response. It's from a Mr. Sifiso Malo, and he wants clarity whether the municipality can continue filling the vacant position without job evaluation report. On top of that, there is an award from the bargaining council that indicates that the municipality should not fill any vacant position without job evaluation report. There was a lot of questions around that specific item.
Okay, thanks for the question. I think in the beginning I answered, and there is a response as well in that question, where if you look at your national task policy, as I said, you go to the key principles there. It's under point number 4.3. It's clear there that no post in the local government sector shall be filled without having been subjected to the task job evaluation process. So if it is happening, it's not supposed to be happening, because it is going to cause a lot of problems and a lot of challenges, because when you advertise, what salary range are you going to attach in the advert of the post? Thank you.
Yeah, I think that that is also very, very relevant. I think I must also just on job evaluation, possibly just clarify. Of course, job evaluation is regulated by a policy, which makes provision, of course, how job descriptions, etc., should be completed. It also deals with the structures of job evaluation. So I think that is also very important. So there's specific structures established, job evaluation committees, and then, of course, the provincial audit committees. And then you can basically appeal, as well, as Nozipo has said. So there's a specific process in regard to job evaluation. I just wanted to, on the functioning and the effective functioning of the LLF, I think it was mentioned this morning by Imatu, and I also believe, having trained quite a bit on local labor forums, that the difficulty is not that municipalities do not understand the content of what is expected. It is really this issue of relationship that sometimes break down between the employer and the employee. I just want to check from Komotso, is there specific attention being given to that at, for example, at your municipality? Would you have sessions? How do you improve relationship at a municipal level? Also, you sometimes have the allegation from managers, which basically says that the LLF is used as a platform to come and discipline them. So what happens is the councillor do not support the management representative in the forum, basically agrees with the propositions that are being put by Labour. Have you had such experiences? Because surely that can be addressed if there's that kind of challenges within the local Labour forum. So just on relationship, how do you address that to ensure that, you know, the local Labour forums are functioning effectively? So if you could possibly just address that in your response, please, Komotso.
Thanks very much, Gigi. I think it's very much important that there should be a healthy relationship between employer and organized labor at the work environment before we tap into the LLF platform. Because if the relationship is not healthy, obviously it's going to affect the functionality thereof of the LLF. So it's very much important for the employer to have this healthy relationship with organized labor. But like you are rightfully indicating, it's very much difficult, especially in local municipalities, to have a situation whereby there is this healthy relationship between organized labor and management. Obviously, that will be because of one or two reasons. Remember, in municipalities we have got policies which are in place, which govern the employer-employee relationship. And in most cases, you'll find that from the employer side, there is deviation in terms of compliance. And that automatically sours the relationship with organized labor. You may find that in other instances, that deviation from applicable policies is being done deliberately to achieve a particular objective. And on the other side, the organized labor on the other side will be saying, but the employer, your policies are saying we should take this route if you want to reach at destination A. That's where the relationship becomes sour between the employer and organized labor. And if the relationship is not healthy from that level, obviously it's going to rub off during or at the local labor forum. So, but it's very much important that as and when we are at that particular forum, the local labor forum, we need to have that understanding to say, are the issues placed on the table for deliberations, are they to the benefit of both parties, both the employer and the employee? If the answer is affirmative, I don't see any reason why there should be any polluted relationship. But if the other party, or if the other party feels that or they are taking their own personal interest into the issue itself, there cannot be any soured relationship. That's why in most cases, and I think it's something which is happening, because it's rare to find the relationship between the employer and the employee being solid and sound or healthy. That is because of non-compliance in applicable policies. I think if all parties can comply with the applicable policies, I think that will be a halfway won battle against a contaminated work relationship.
I think we can be, I think these kind of topics we can run for another 3 hours plus. But I really want to thank our panelists today. John, thank you so much for as you dealt with the pension fund. Komotso as well on the local labor forums, and then Nozipo on job evaluation. I can just say that if there's certain clarities that you need as municipalities, especially in terms of the pension fund collective agreement, I do believe that there's a lot of misinformation that is also being presented. And yes, lastly, there is a labor court application. Forgot to respond to that question. There is a labor court application being launched against the implementation of the collective agreement. However, the processes in the bargaining council continues. There's not been an interdict that stops the processes. So our appeal would be for municipalities to engage, especially if your pension fund in your municipality has not applied for accreditation. Because comes the 1st of July, the collective agreement will be implemented, and one cannot then contribute to a pension fund that is not recognized in the local government sector. So one would really appeal to our municipalities to ensure that those pension funds, even at this late stage, apply for accreditation. On the local labor forums, we will be conducting formal training from a SALGA perspective. So municipalities can look forward to that training. It will be specifically for the employer and the employer component, management and council. So that will also be rolled out by SALGA, and we're looking forward to engage municipalities. On job evaluation, our processes continue. All our committees are in place. Our provincial audit committees are functioning well. And thank you for responding, Nozipo, because that is one of the challenges that sometimes we get told that posts are advertised without being formally job evaluated. I think bring that to our notice and attention, and we would like to address that at the municipal level. But thank you so much for your participation. I think we've had a number of questions raised, and I think we can give a big hand to our presenters this afternoon. Thank you. We can go.
Can we please give them another applause? Thank you so much. What an eye-opening session. At this point in time, ladies and gentlemen, please allow us to go through the mentee session. Karen will be assisting us.
I was just checking to see if I'm audible.
You are.
We'll be there shortly. Colleagues, for those of you who don't know how Menti works, there's a link that's being posted in the chat. And you need to click on that link. We'll do a very short Menti poll to just extract some of the issues around the local labor forums. And I see some of you are already at it. The very first question, just to give those other colleagues some time, it says, are you a member of your municipality's local labor forum? So we need a lot more responses. We are 249 participants in the room. I would like to encourage you to click and make your choice there. Thank you. We're at 23 now, 24. We're going to allow a few more seconds. Oh, I see there now it's picking up. Okay. So it looks like we've got a lot of people in the room who are indeed a member of the local labor forum in their municipality. I'm going to move on to the next question. Oh, there are still responses coming. We're at 37 now. I think that's adequate, and it gives us a good indication of the view in the room. The second one, has an LLF been re-established in your municipality since the constitution of new municipal councils post the 2021 local government elections? And there are three options, either yes, no, or I don't know, or you don't know. Please indicate to us what the case is in your municipality and in your environment. It's picking up nicely. I hope that we can get to at least 40 responses. There we go. We are at 35, and you can see the results on the screen, colleagues. And majority of yes responses reflecting there. Let's move on to the next question. Okay. Have local labor forum meetings been convened in your municipality during the last 3 months? And remember, it's anonymous, so we can't see who responded what, so feel free. We're at 29, few more. Okay, we've got 34, 35 responses. And you can see what the results look like on the screen. 37. Thank you, colleagues. 38. Okay, we're going to move on. We don't have many questions left. The next one, out of the employee representatives in the local labor forum, are they first-time councillors? So remember, you don't have to be a first-time councillor to answer this question, but you will know whether there are first-time councillors in that forum. Very nice to see those responses. Thirty-one responses. I think we can move ahead. This is the second last question. Are you aware of the Labour Relations technical team? And I see that we don't have an I don't know option here, but okay, we're sitting at 30. Let's get a few more. The Labour Relations technical team. Are you aware of the existence of such a forum, I would say? Colleagues, yes, I must just indicate that this is a SALGA forum. Okay, I think we are fine on that one. And then for those of you who've just answered, are you a member of that Labour Relations technical team? It's obviously an initiative that we would like to expand on. So we'd really like to just test how it's been received up to now. Okay, a lot of potential. Thank you. That's the end of the Menti, colleagues. Thank you very much for your participation. Much appreciated. Thank you.
Thank you so much, Karen. At this point in time, ladies and gentlemen, allow us to move to the repurposed municipality labor framework advocated by SALGA. We should be having someone to be doing it, but there's been challenges, so allow me to call our Chief Officer, Hba Regulations, please. Round of applause, please.
Am I going to do that thing? It's the type of pants I'm wearing. Or do you want it this side? Okay, bring it this side. The type of pants I'm wearing, I don't allow wig. Sorry about that. I forgot. No, it's not such a bad thing to be heard whispering. It shows that I'm human after all. Yes. Let me take off your mic with your permission, Program Director, and put it in the best possible place. If I may just check with the technical team, is the presentation up and ready? If I may just ask the delegates to indulge me just for a moment or so. Thank you very much, Program Director. And once more, greetings to the delegates. Can I just check from the technical team, gentlemen and the lady, if I make small movements, I won't be out of shot. Am I right? Come again?
Do you need me to stay in a static position or can I move a bit? Oh, okay, it's fine. That looks better. I wanted to do it the Apple way, when Apple is launching a phone. The podium is too authoritative. I think once more, let me pass my greetings to the delegates who are connected virtually. And perhaps for starters, let me set for the record that I am not Mr. Duzile Matubanya, so that I don't find myself trending for the wrong reasons. I am an official of SALGA, and for those that are not aware who I am, my name is Rio Noluchungu. I'm one of the executives at SALGA. I think allow me to also indicate to you that the reason I am making the presentation has partly to do with what we are saying in this slide, and that is the body of work that I'm going to introduce and present today went through a process that was commissioned through a consulting company and was project managed through SALGA project management, governance, and related protocols. And the reason why I am making the presentation instead of the person who has been allocated in the program to do so is because the person concerned got ill overnight, and her state of illness has aggravated over the course of the night, and more so from the time we started the session today. So I've taken the liberty, in the interest of the seminar and its objectives, to obviously stand in, because I'm familiar with the issues and I'm also the project sponsor. And lastly, even though this has been work that has been outsourced to a service provider, now that it has been completed, it is now vested with SALGA. It is intellectual property. We will take you through the presentation. Some slides are FYI, for your information. Some slides are going to require a bit of time in order to unpack and make simple what this model represents and what it looks like. So at a basic level, the model is supposed to say, how can SALGA, as both an employer body as well as an association that does its work purely for the benefit of municipalities and members, how can SALGA take the environment of labor relations management, and out of all the problems that SALGA always experiences on a day-to-day basis, how can SALGA create an institutional mechanism of support for municipalities to overcome those problems and get into a level of improved maturity to be able to deal with those labor relations problems on their own? So that we build the capacity on the one hand, we transfer knowledge, and we hopefully achieve a state of resilience at the level of municipality. So this is not a support framework that's talking about SALGA's work that is done in its capacity as an employer body in the bargaining council. This talks to the work of labor relations inside a particular municipality. And when this assignment was undertaken through the consulting company, these were some of the things that SALGA asked the company to look at. Look at SALGA's role as an employer in its current form, and what is the landscape of labor relations looking like. Develop an approach to dissect the information at your disposal and be able to create a story or a pattern of labor relations practice in the sector. Because when you know that, when you know the context, you will be in a better position to curate a support model or framework that would be relevant and that would be custom built for the sector. and look at what SALGA is doing now, so that if what SALGA is doing now is inadequate to fulfill the requirements of this support framework, create an environment where SALGA can do many things that it does now, like a municipality say, please, can you give me advice now? My municipal manager's contract has come to an end today. What must we do? Can he work the following day as a municipal manager, or must he? Those kinds of generic advices will still be undertaken in that way. When we're talking about labor relations support framework, we are talking to all those institutional challenges that have taken root and embedded themselves in the DNA of a municipality's labor relations environment. And obviously, as the consultant was given this work, they were also given a responsibility to farm out experiences in the broader market through a comparative benchmarking exercise and see who does what out there in the market comparably close to what SALGA does. And we're talking about employers' organizations out there, and clean out those experiences that may serve as important contributions in framing this support framework. And at the end, develop products that are in the form of frameworks, policy, practice, as well as that will allow us, when we implement the support, we can implement it in a uniform way, in a directed way, in an intentional way, but in a way that allows us to gather data, that allows us to provide the support through many dimensions or instruments of support, but that will also allow us to get reports back and be able to look at patterns and reporting matrix and be able to tell a story whether there's real benefits and impact out of the support that are given. And hopefully, municipality would have improved over time as a result of going through those experiences of support. So from a project scoping point of view, this is what the consultant was asked to do. And the consultant set out to do their project over 5 phases, which I've given you there in a screenshot manner. I think they're fairly familiar in terms of the way they've been summarized, so I won't go through all of them. So where did we start? We started by doing almost as an as-is exercise, assess the environment, and we've had to rely on data sources to do so. What are those data sources? Obviously, they belong in different domains of data collection and curation. And one of those domains is looking at documents that talk about reports, looking at literature out there that talks to labor market trends and what must be done, what should not be done. We've also done workshops, mind mapping, trying to discuss issues, but that conversation has primarily been within a SALGA environment. And on the outside, looking in, we've looked at many reports, some statutory, some have been commissioned by SALGA before, Department of Employment, Labor, Industrial Action reports, which they do on an annual basis. We've looked at the case management system of the bargaining council. What is the pattern of cases? How long do they endure? Do they get resolved? In what areas of disputes are there many more cases compared to others? Is it unfair labor practice? Or is it different kinds of cases? We've looked also at the CCMA to its case management system as well as its case law monitor. And we've also looked at labor court judgments because often labor courts make judgments which have an impact on the work that we're doing, either in some instances by advising us, in some instances they tell us what is it that is wrong with what we're doing. We've also looked at the outcomes of the survey results, different surveys result. One was done in 2020 when COVID visited us. We asked municipalities a number of questions, and the information we got, we felt is representative enough to allow us to form a view, a picture of what's happened, especially in relation to COVID-19 experiences that have a labor relations impact. We've obviously looked at a survey of the local labor forums establishment and functioning way back, perhaps in 2019, 2020, and there are indications from that survey that have told us what the shape of the environment is from a point of view of labor, local labor relations forum functionality, efficacies, and what are the things that are not so going well after all. And obviously, lastly, the labor relations feedback, which was embedded in this project as a SNAP survey. So we went out there, someone went back, went to their back office and looked at this information, and then before that happened, the service provider says, please give me your go-ahead as SALGA, that I administer or approach this exercise of interrogation by applying this model. This model is very common in labor law and labor relations practice, so much so that it is a valuable reference resource for people that do research in that area and even practitioners. It was formulated by a person who's called Cecilia Bingham. Sorry, I've never met her in person, so don't ask me about her, where to find her. But that research is available in that publication that was released in 2016 through SAGE. And the author presented what she says are the intersecting factors that are at play in any environment that has labor relations practice, especially where there's an interplay between unions and employers. And she called that the model of workplace relations. So if you look at the model and look at it dipstick, and you look at a municipality, you will find at a generic level so many factors that can be linked to what is happening in a municipality. Educational trends, it's the level of education that you see in that institution, whether you see it through its leadership or whether you see it through its HR or labor relations managers, or whether you see it through the practitioners, and even at the level of the profile of employees, and in some instances it could even talk to the levels of educations of the union leadership and members. Labor market trends, we get from labor market trends. Where are the wage settlements sitting? We get from labor market trends. Where is CPI? We get from labor market trends some approaches and practices that are technology relevant. Balance of power. In certain institutions, I think I've been long enough in the municipal sector. If you take my experience when I was in a municipality and put it together with the time I spent at SALGA, to know that a strong union in a municipality can overpower management in the balance of forces and power around labor relations management. We've seen those examples. It's not ours today to point them out because that's not the focus of the discussion now. But balance of power and forces is a very important intermediary and consideration in labor relations in any organization. And of course, there are other things. Fashion, what is fashionable to do? Maybe what is fashionable to do in labor relations, colleagues sometimes, is if you don't agree with the employer, what do? You walk out. Am I wrong? It's fashionable. It's your way of saying, I don't agree, and you create the symbolism of the walk up. There are many other instances of what that fashion could be, and sometimes it might be fashion that's on the good side of things, ethical, and sometimes it might be fashion on the bad side of things, intimidation, damaging property, you name it. Or even go slow if your ammunition towards gravitating labor relations in your favor may be that kind of instrument or model. So we felt that this model would work for what we want to do, and then we move forward to interrogate what the data says on the back of that model. And here is what the results said to us out of the representative sample of 142 municipalities. And we look at them just from a provincial screening process. And the summary results that can be gleaned from those responses that we asked is that municipalities first gave us a low response, so we didn't get to all of them, 257. And out of those results, we saw that interest in labor relations matters that are dealt with by SALGA shows different levels of percentages. And maybe it's got something to do with the fact that in Northern Cape there may be fewer municipalities, maybe that number was dragged down by that. Maybe the number of KZN is on the upside because of the number of municipalities. So this is what we got out of the feedback. But we were happy that this is a representative sample. And the reason we're showing it now It's just to demonstrate that we've made the assumption from that representative base without necessarily attributing any wrongfulness or right or wrong to who may have responded and who may have not responded. So we feel this is a representative sample. In terms of the responses around surveys, this is what the breakdown gave us, and we used a model that's called the Municipal Infrastructure Investment Framework, where we categorize municipalities not in the 3 categories of metro, district, and local. We broke them down from metro, secondary cities, so that we could have a finite view of every size of a municipality up until a granular level. That's what we've done. So we've used the symbolism of those categories. That's why we respect to C1 district municipalities, C2 districts, districts in urban areas, districts in rural areas, local municipalities who are small towns, local municipalities with many rurals inside of them, local municipalities that are more in larger towns, significantly larger towns who are not necessarily metros, as well as metros. That's the breakdown we use when we look at the sample. And out of that, we came up with some interesting patterns. And those patterns are in front of you. And one of the things that has emerged from the survey is that almost half of the respondents are saying the LLFs are just not working. And they've so for a number of reasons. If you look at them to the left side, which would be my left side, I'm not sure whether on the screen is on the right of the delegate, those are the reasons that were given. From lack of meetings just do not happen, or they are perennially postponed, lack of training, or people don't understand what the LLF is about, resolutions not implemented, there's agreement, there's no follow-through, poor management in terms of the attendance of meetings, and you break this down between councillors and officials, labor sometimes not taken seriously when they put matters on the table. So it already tells you that as people were responding, they were not always taking the cap of the employer in their hands. Some of them were taking a broader view, and they were even making their observations from a labor standpoint. Some of them says we're dealing with things that are not with their scopes. It's a confrontational environment. We don't even go to caucuses. We just go for meetings without preparing. Labor in some instances is disruptive, and there is no adherence to agendas, and even reports and the agendas are sometimes problematic. So that already tells you, if almost 50% of the respondents have said this thing, that there is something wrong. And it's not our business now to try and understand the gravity of this problem to a granular level. Ours is to do something about it. And there's also, thematically speaking, a range of challenges that have been presented. And I will speak on them without necessarily giving you the examples. There's a breakdown of trust between municipalities and their employees. And please hear me out. We are talking here about a municipality as an employer. We are talking about an employee as an employee of a municipality. We are not yet talking about the relationship between labor as well as the employer representatives. Even when we look at disputes, we also are seeing a familiar pattern of less than satisfactory performance. The industrial action that we've seen in various provinces, and the numbers speak for themselves. You would have heard Tumsan in the morning saying, there's no day that I go to the office and there's no strike. So Tumsan didn't see this survey result, but it confirms to a large extent what he said, and he said it from a union perspective. So there's a lot that is going not so right at the local level. So even if we are proud about what we're doing nationally, we will be irresponsible in our duties if we would shirk the responsibility of trying to create the kind of change that we want to see at a local level. The interface between governance and labor relations is also a challenge, because the role that leadership must play in this space is also from the observation of the people that participated in the survey. They are saying, we are seeing a lot of poor leadership and management in municipalities. And one of the interesting, and I'm not going to the report down to the detail, one of the interesting examples they use is a municipality knows that it will not pay salaries on the 25th. Am I right? And the month starts. The month rolls. First week, second week, third week, and the municipality will only tell employees on the morning of the salary payment or the night before that, sorry, we are trying to resolve this problem, and this problem will be resolved in maybe a day or two or in a week's time. And I also agree with employees when they say that that is a mark of poor leadership. There is just no way managing an organization have the benefit of daily cash flows that you cannot know that you will not have the ability to pay come end of the month. After all, and I'm drawing from my experience when I was in the municipality, you only know already around the 15th when you are closing your payroll run that you've got the cash flow to pay or not. Unless you are constantly relying on an overdraft facility from the bank to be able to pay salaries. So it's one of the things that have loomed large in the views that people have, or rather, the survey participants have given us back. And likewise, you've got an interesting scenario about the level of satisfaction with SALGA's role and contribution in the labor relations space. And sometimes you have a skewed picture where we in the Eastern Cape, maybe the Eastern Cape is a bad example. Oh my God. Okay, maybe it's because I come from there. Maybe let me say it matter-of-factly. You'll get this picture in the Western Cape where there's relative satisfaction about labor relations support. You get that picture again skewing in that direction in KZN. But the moment you go to Free State, you go to Northern Cape, you go to Eastern Cape, you go to Gauteng, and I'm saying it as these guys, it's not me that says so, then the numbers look south. So it means even SALGA, as a unitary organization that it claims to be, is not able to provide municipalities across 9 provinces with a similar level of satisfaction from a point of view of support. So there is also feedback that also doesn't talk about what's happening on the ground. It's talking about what is it that we should be doing for all the credits that we give ourselves product direct. They're saying, look at yourself. Of course, there may be a halo effect in the responses. Let's qualify that. The halo effect is that the person who's responding might not be giving a representative picture of a municipality. They might be giving you a blindsided view of the way they think they should respond. But I think it's still useful as a point of departure in terms of telling what us to do. And the numbers, I think, are straightforward. Where municipalities agreed more, obviously that was the yellow bar. Where they strongly disagree, where they strongly agree, it's more the bar that's on the pink, and where they were strongly disagreeing, it's more on the gray shade. So you also have a mixed bag there, if you look at the pie chart as a whole. So, but everyone is recognizing that SALGA is still relevant in the space of labor relations. No one is suggesting that we must get out of the space or be, what's the right English word, when a municipality is failing? Section? No one is saying, can SALGA please be placed under administration itself, Section 139, whatever act would apply to SALGA. But we are being told that we need to look at this area quite more sharply. And obviously, there's also issues around matters of compliance. SALGA sometimes say, do this as a municipality, don't do this, stay away from danger allowance. stay away from not doing what you are doing because it's in line with the disciplinary procedure, and the respondents have said, whenever we get a SALGA directive, we comply. And they've indicated those areas of compliance. Top of it is disciplinary. When we have to discipline someone, we listen to SALGA. When employees must not be paid, when there's strike action, most of us listen, but some of us, you know what, we say, it's none of your business, SALGA. When it comes to danger allowance, and this was more in the middle of COVID, we're just not agreeing with SALGA there. Because, you know, our view of the pandemic is that there must be something that's paid. But then again, it depends who was answering the survey. Are they in management? Are they in the position of authority? Are they affected? We don't have that intelligence. And this is a picture out of 107 municipalities that responded. So overall, this is the picture of recommendations that has emerged. We must communicate more. We must do visits. We must improve. We must be proactive, all the good things. We must share information. We must establish forums. Fortunately, you will agree, Program Director, this forum would be one of those intentions. The technical working group or team think emerged from this survey as well. You had us talk about it as we are serving. And the one that always comes time and time again, please build our capacity. Don't get tired of giving us capacity. We need it. Sometimes I ask myself, when municipalities are saying SALGA must build its capacity, how sure are they, municipalities, that the people at SALGA have the capacity to begin with? But I guess it's an irrelevant question when one of SALGA's mandates is capacity building. But I mean, if someone would deep in that question and say, do SALGA people actually have capacity across the board? It would be interesting what the results would be. But notwithstanding that, the call for capacity building still remains. So that's the picture. We see it in the support framework. It's presented to us. We accept that picture. We don't contest it. And we say we'll run with it as a baseline for developing the framework. And I assume, colleagues, you understand the logic of first dealing with data and affirming the status quo before introducing something that's new. I hope you can relate to that, so that it's not all pie in the sky. So what did we emerge with there? I mean, I won't talk to the many things that we have agreed upon. And we've emerged with what we call a set of products that will drive this support. So it's almost like the blueprint of this support is effectively configured in these products. One, we have what is called a catalog of labor relations challenges. So whenever we see a problem in a municipality, we picture it through the catalog, unless that problem is not yet known by us. And when we see that picture, obviously we must adopt action and be structured to resolve that problem. And then we've got guidelines that tell us what kind of conversations, what kind of process must happen to give effect to that support. What are the general principles? Where must this support not be confused with something else? And The general guideline document says that. And when we are administering the support, so that we administer it uniformly in the same way, regardless of whether the support is given in Joburg, Tsanin, whether it's given in Mhlonhlo in the Eastern Cape, or City of Mhlatuza, it might be administered in the same way in terms of operating templates. There we've got a prototype agreement for that support. That is a subject of discussion between the municipality and the person deployed by SALGA to provide the support. Whether that person is one person or whether that person is a team that's deployed, drawn from SALGA officials and the technical team, and there's an operations procedure framework that must underpin by support. So you might be asking, what is a catalog of labor relations challenge? It is a pre-purposed matrix. It is a table whose aim was to take labor relations challenges and problems and identify them at the level of problem diagnosis. So in the matrix, there could be a current problem, There could be a historic problem that's endemic, or there may be an emerging problem that we didn't know of. So problems, in our view, will fall in that general categorization. So once you've identified that problem and where it belongs to, then you fashion probable solutions to that problem. Then you resource the plan and you get colleagues to provide the necessary support. So in total, the catalog of the matrix chairperson has got 33 generally accepted labor relations problems in local government. 33 in total. You may argue they're not enough. You might argue that there's a lot more, but we are not here now. What we're here for is that our starting point is 33 problems. So every problem we are imagining in a municipality, we think must be in that master list of 33. If it's not in that 33, of course we'll discover it. We might add it to the master list, or we might reconceptualize the master list. I'm going to give you 2 problems out of that master list so that you don't go through the list as a total. And the one that we've chosen to focus on is a problem that we refer to as a dysfunctional LLF or dysfunctional LLFs. And whenever we deal with support, we must always understand the genesis of the problem. So is a dysfunctional LLF a cultural problem, a systemic problem, or a practice problem? And practice is related to culture. From where we're sitting, we think it is in the main a systemic problem. Why systemic? Because it presents itself in the problem in such a way it affects the organization as a whole. It doesn't affect an individual, like someone who's dismissed. Do you understand what I'm trying to say? And therefore, where does it take its recognition from when you apply the model I gave earlier? It takes off from a part of the model that's called organization culture. And what are the typical solutions for that kind of problem? We think sometimes it's dysfunctional because there's conflict, so manage conflict. Sometimes it's dysfunctional because it doesn't have a clear way of operation. Sometimes it's dysfunctional because people do not know what to do, they do not have capacity. Or sometimes there may not be protocols for code of conduct. You see the proposed solutions that we've suggested. How many are they? 5, am I right? Yeah. In that column. Yeah. And we are calling them proposed solutions because they may not end with those solutions. And when we support, what must be the gateway of support for that problem? It must be a solution that is framed within a domain of intervention that we call advisory support. So understand what it is, advise, because the solution of the problems ultimately lies with the players in the LLF and not with SALGA sitting in a provincial office or nationally. Or sometimes it might lie in just helping the LLF operate on a very stable footing, helping it develop terms of reference, helping it develop rules of the game, and monitoring how they operate, and maybe you can, in the main, resolve the dysfunctionality, just by way of recommendation. And let's jump to number 1 and go to number 14 as a second example. What is a problem with the LLF? This LLF is not functioning, not because the employer has done anything, but the unions are busy fighting outside. Can you identify with that problem? It has nothing to do with the employer, but it's a problem because that dysfunctionality or conflict is conspiring to make this LLF not work. And obviously, what kind of a problem is that? We think it's a structural problem. Structural, why? Because it has to do with a problem that's far away from our resolution. Does it mean we cannot assist to resolve that problem? Our guesstimate as SALGA is that we should be able to support without necessarily trying to make ourselves the managers of the unions. And there are many mechanisms of doing so. As you see in the proposed solutions, dispute resolution, chairperson, mediation, relationship building, there may be a package of interventions, there may be one interventions. And I think one of the things that will help this problem, not okay in the municipality, is when we have governance charters for LLFs, so that those governance charters tell us what to do when the unions are busy fighting outside and that fight is affecting the functionality of the unions. Or the unions may say, employer, we understand this is our problem, but for the premium we place on labor relations efficiency and efficacy, can you help us get an outside mediator to help us resolve the problem without you stepping in and providing the mediation services yourself? And obviously it's a strategic choice whether that mediation can come at the price of a municipality or at the price of SALGA or at the price maybe of a dispute resolution agency such as the CCMA of the Bargaining Council. Okay, I'm almost there. Yeah. So what are these areas, broadly speaking, where we should provide support? We've categorized them as 5, and I've been told here I'm about 4 or 5 minutes almost to my end of talking time. We've categorized them in terms of labor, local labor forum functionality, collective bargaining and compliance, because there is a role for collective bargaining at a local level. It's not limited to national. Others are in the domain of dispute prevention and management. Others are just on-demand value-add service, something that we want to do in a municipality to contribute to building our labor relations environment. We just don't have the expertise, the means, nor do we have the infrastructure to do it. For example, relationship building between employer and employer parties. The employer is also one of the parties, and therefore it can't be at the forefront of undertaking that kind of exercise. And obviously the most recent addition to the list is labor relation innovation practice, which has been influenced by our experiences during COVID and what those experiences are saying to us. We must respond in terms of those things. You heard in the morning, vaccination policies fall within that category. Which route do we go as municipalities around mandatory vaccination? Because there's a range of choices to take there. Can we do disciplinary hearings, colleagues, online? Can we? Can we? Can we do disciplinary hearing online? Should we set policy for that and procedures? Can we respond to health and safety matters for an employee who's working from home? Can we? Should we? Do we know how to do it? Those are the things that are coming in the innovation practice, and I won't go through the list. And obviously, out of these things that have been done, there have been recommendations that we've been given to get this kind of work, this body of work known by the sector, take it broadly to the market. But the recommendation was that we must first, Program Director, launch this conversation at this forum before we get into the domain of on-the-ground mobilization and getting the constituency to buy into that idea and getting the constitution to adopt the implementation of this model. Because only when municipalities would adopt it will they want to participate in a system or framework of the nature suggested in this unit design. So out of all the recommendations that have been made, only 2 have been implemented now, which is to take the frameworks and package them as SALGA policy documents. We're doing that work. We are activating it. We have not concluded. We are going to go into the market to launch them. And we're going to do so preferably through our provincial offices. We've obviously placed the matter for discussion here as I speak today. It's part of that recommendation. The mobilization for the adoption is yet to get off the ground. Some policy documents of SALGA would need to be adjusted to accommodate the introduction of these important support instruments. So I will do this program director. I don't see the program director. Maybe he took a rest break. This is how the catalog looks. It again confirms the areas of support. I did say so. The roles and responsibility document, the guideline. It talks about the principles. It talks about what each party must fulfill as a role. What is the role of a municipality in a support framework? What is the role of SALGA? What is the role of other parties? How do we contract into this support regime? And obviously implementation-related issues. On top of the guideline document, then there's a plan or an SLA. So the LSLA regulates how we provide the support and do the work, because this is work that's institutionalized. We must make sure we are managing the way we do it. We must make sure we meet all the responsibilities of governance and implementation compliance that are required. And these are some of the sections of that SLA, including how to set up a structure in a municipality comprised typically of a head of HR, working with the technical team from SALGA, being seized with these responsibilities coming from the support framework, and what each and everyone's role, what is each and everyone's role in that dispensation of support. And I've just pulled out the subheadings that come out of the guideline document. When we are doing the first line assessment of the problem, this is the document that we administer. You will see at the top, it reflects the province, which one is that municipality, what type of it, how are we engaging? Are we engaging through a meeting? Are we engaging through an exercise of researching something? Are we engaging in a different way? Have we diagnosed this problem, or we're shooting our head from the sky to say what the problem is? And obviously, if the answer is say, it will indicate who did that diagnosis and how it was done. The designated official in the municipality for that will sign off and be indicated, so will be the designated official of SALGA who's responsible for leading the support. So the person who is at the front of the support at SALGA is the support lead official. And that person reports to a line manager within SALGA, whether that line manager is situated at the national office of SALGA or in a province. And obviously there's a choice. The document gives you the choice of what is it that we are helping you with as a municipality, as a priority. We do not have the infrastructure to help you resolve all your problems. What are your most critical problems, and we will take it. So will be the choice or bouquet of services of support that we'll need. And they are all listed there in the standard operating framework. For those people that are doing the support and they receive this matrix with Linda Ntuli's name as an MM and Temba Ngumalo's name as a SALGA official, they obviously need to understand where will they start from in providing the support. And the process has cultivated 10 areas of broad description that inform the process you must go through if supporting a municipality. So if you're supporting a municipality with skills development, let's just say an LLF training program for employer representatives. You get what I mean? It must follow a particular discernible process in doing so. If SALGA is providing just general advisory support in solving the problem, there's a description that you must follow. If SALGA is resolving a conflict and is enlisting the services of third-party facilitator like a mediator, a relationship builder, or a conflict resolution, there's a process that is set out in respect of third party, so that we are not all over the show about what we're doing. And as we implement the support, we are busy auditing our processes as we walk like this, until we get to the end of the support and we can talk a picture of how that support experience has been lived, what has it taught us, and what has been the outcomes. And then from there, we look at what to monitor to build that environment of employee relations management, efficacy, and resilience over time, which is what the project is all about. On that note, thank you.
Thank you so much. I don't know. Do you want to?
I don't know. We can check that out.
I'm looking at the time.
And maybe we can assess from the yeah.
Program Director, there are no questions in the chat at this point in time.
Okay.
All right. Let's just say, maybe for a moment, the seminar today represents our first tangible attempt at introducing the product. And because the product is new, it needs investment in time, resources, and effort to take to the ground and allow for more, shall we say, invested discussions about the modalities of implementing the model. So perhaps it's maybe cold now, because it's something that's new to us, but the objective really for this seminar was to introduce it with the desire to go on the ground and dive into those conversations, which are partly about buy-in. They are about repurposing if we have to adjust certain things. They are also about adoption so that implementation is geared accordingly. Thank you, Chairperson.
Thank you so much. Let's give a round of applause to Rio, please. Thank you so much. We are now going to be moving into our last session, which is case law update and reflections. Delegates have the option to participate in different discussions, and set out below in breakaways. There's room 2A, which is this one, and then there's breakaway room 2B, which is the next room. These breakaway rooms will be held in different rooms in terms of Zoom, and the delegates must select the breakaway that they will like to be part of. So I think Sihle is assisting me now in terms of having the two. So we'll have the lead facilitator, Johan van Zyl, for this particular breakaway room, which is 2A. And then we'll have a lead facilitator as Temba Ngumalo for the next room. So please, let's do that. Please make sure that you choose the room that you'll be joining. There'll be pop-up screens that will be coming up, and let's do that. Thank you so much. The room is virtual, yes.
Do I have a clicker? Yeah.
I think we just need to allow a bit more time.
Delegates, just to give a clear indication to you, the two rooms, there will be Mr. Zawadi Dlamini from Bowmans. He's an associate from Bowmans. He will deal with three cases. It's the Constitutional Court judgment grappling with reinstatement as a remedy, where the employer and employee have both admitted to a strained relationship. He will also deal with a case, the Labour Appeal Court judgment dealing with the reinstatement orders and revival of employment contracts, as well as the Labour Appeal Court judgment dealing with the dismissal of the 148 employees pursuant to assaulting a senior manager. That will be in the breakaway room 1, those three cases. Then in the breakaway room 2, there you will have Mr. Sibusiso Dube, who's also a partner at Bowmans, who will be dealing with the Labour Court judgment dealing with an unprotected strike, where the union and employees deny the existence and continuation of the strike, as well as the Labour Court judgment dealing with the automatically unfair dismissal claim in the instance where the employer disguised the true reason for the dismissal, which took place pursuant to the employee making a protected disclosure, as well as the case in the Western Cape High Court judgment dealing with the selection panels for senior managers and the applicability of the regulations. So those 3 cases will be dealt with by the 2 different rooms. So if you are interested in specific cases, that's how you can decide to join whatever room. Thank you. I think in this room then, Mr. Dlamini, you will be on the podium.
Thank you very much. Good afternoon, everybody. How are we today? Where's the camera? Are we there? Okay, fantastic. No, it's fine. Before I start, I just want to say thank you to everybody that's come out today. Thank you to the remote audience. And a special thank you to Salga. You know, I'm from Bowman's, and I just want to say it is an honor for us to be a part of this, to be invited to the seminar. It's not something we take lightly. I also want to thank the organizers, Palesa Zwe and the team. They were on my neck last week asking for presentations, but we're here today, we've got the presentations, and we're good to go. So thank you so much. My name is Zawadi Dlamini, and I'm an associate at Bowman's. Essentially, at Bowman's, we'd like to think that we are specialists in employment law and all things labor law related. We're specialists. If you ask my wife, I am a specialist at whatever she says I must do. But for the purposes of my profession, we are specialists in employment law. I also have a background in sports law. Of course, it's something we also provide at Bowman's. But today, the purpose is to engage in employment and labor law issues. And I just want to, encourage everybody in the room, obviously to the remote audience, that really, we're going to be discussing cases, and the value that you sort of get out of cases is if we engage and we both struggle through the issues. So I know if you have any questions to the live audience, give me a go, and we'll struggle through it. We'll answer the questions, and we'll see what we can do. And also to the guys remotely, just type in your questions in the comment section, and we'll also try and answer them as we go. So essentially, I was reminded that I'm speaking for 105 minutes. And those of you who are sports fanatics will understand that that is an entire soccer match plus extra time. There you go. So, look, the point is we're going to be here a while. Guys, just relax. I know there's water, there's refreshments, so the idea is for us to relax and stay engaged as much as possible. I don't know if we have opportunities to maybe take a 2-minute breather in between the cases, but we'll take it as we go. But really, let's try and enjoy the session. So essentially, the theme for the seminar is sustaining stable and sound municipal labor relations today and post-19 pandemic, or COVID-19 pandemic. And the significance of this theme, right, and how it really relates to the cases that I'm going to be discussing, is that as the municipality, you are an employer, right? So you want to be aware of labor law, how you are implicated. We have a very, very comprehensive jurisprudence in our labor law. Obviously, the primary act is the Labor Relations Act, and it has several implications for an employer. So if you want to be an effective employer, you want to be an effective municipality, you want to be aware of the laws that essentially govern your employment relationship with your employees. But another important thing about the case we'll be discussing is that they are not only unique to COVID-19 pandemic, right, but they're also unique to any circumstances. In essence, they're objective. Whether we're in the pandemic or not, these principles will generally apply. Now, throughout this seminar, or I should say throughout the session, we'll be identifying 3 topics. And at the end of the seminar, at least I would like for us to be able to answer all these questions, right? Because these are significant questions for an employer. These are significant cases in the labor law relations context. And essentially, the three topics are this. The first one we'll be discussing is, will courts order reinstatement where there's a strained relationship? And again, the context and background of this question is, when an employee is dismissed, right, the primary remedy is reinstatement. Now, the question we want to ask is, if the employment relationship is strained, can a court order reinstatement? And again, we've got a case that's going to deal with that, and we'll discuss it shortly. The second topic is, when does an employment contract revive once a court has ordered reinstatement? And again, the significance of this question is, a lot of the times as an employer, right, you dismiss an employee, right, and the labor court will then reinstate that employee. The question then becomes, is that employment contract revived by the mere reinstatement order? And that question, depending on the answer, right, has several implications, which we will discuss shortly as well. And the third topic is, can employees be dismissed if they are found to have a common purpose? And really, this topic is more, unique to instances when employees are striking, right? So a lot of times you'll see employees come together, they strike, and, there's misconduct. But in most cases, you have 200, 300 plus employees, and, you can probably identify 5 of them. The question is, can you dismiss the 5, but also including the entire group because they have conducted themselves through common purpose? Right, so the first case we're going to deal with is a constitutional court case, and it's going to help us answer the first topic, which is, will courts order reinstatement where there's a strained relationship? And the case that we're dealing with is Boy versus Amatola District Municipality. Now, the facts of this case are this, right? You have the employee in this case. They're employed as a senior manager at the municipality, right? And essentially, they've been charged with misconduct. And the misconduct included gross dishonesty, gross negligence, and of course, insubordination. At the disciplinary hearing, right, following all these charges, the chairperson assessed the evidence against the employee and found that he was guilty for all the charges, and he was dismissed, right? Now, aggrieved by the dismissal, as most employees are, he then referred the matter to the bargaining council. Now, the bargaining council interestingly said that the dismissal was procedurally and substantively fair. And what we mean by that, and again, I understand most people are aware of these topics or this jargon, but when we talk about procedural unfairness, we're talking about, of course, the procedure that the employee or the employer followed in disciplining the employee. So an unfair procedure, for example, will be where the employee wasn't taken to a disciplinary hearing but was found guilty. But in this case, it related to substantive unfairness. And the substantive unfairness relates to the reason you are dismissing an employee. In this case, the bargaining council found that the employee was innocent of all the charges that were preferred against them. Now, the bargaining council determining what remedy to give the employee in the circumstances where they're innocent looked at reinstatement. And as I said previously, reinstatement is the primary remedy. So if an employee approaches the CCMA, the bargaining council, and the dismissal is substantively unfair, the primary remedy that arbitrator can give is reinstatement and back pay. And this is what the bargaining council considered. But there are limitations to this primary remedy, and they're found in section 193, subsection 2 of the Labor Relations Act. And essentially, an arbitrator or the labor court can't reinstate an employee, right, if the employment relationship is intolerable, okay? That's one example. And the other example is where if it is impractical to reinstate that employee, right? And if those things exist, The other remedy that can be available to the employee is compensation. But again, most employees don't want compensation because compensation is capped to 12 months depending on the dismissal. It's either capped to 12 months or 24 months. But if you can get reinstatement, normally you get reinstatement from the date of your dismissal to the date of the order, which again means you can recover more money in the case of an employee. So that's really what an employee would want in these situations. But the Bargaining Council found that it was substantively unfair and ordered reinstatement. Right. Now this is very interesting because both parties, the employer and the employee, admitted that the relationship was strained. Right. But in the light of this evidence, or notwithstanding this evidence, right, the Bargaining Council still reinstated the employee. Now, at the Labour Court, the municipality reviewed the Arbitration Award. And essentially, the grounds of reviewing the award, the municipality submitted that the arbitrator misconceived the entire inquiry. Right? They also submitted that the arbitrator misconstrued the evidence before them. But most importantly, right, and for our purposes, what the municipality submitted was that the employment relationship was irretrievably broken down. And in those circumstances, in terms of the Labour Relations Act, an arbitrator cannot reinstate the employee. Now, of course, naturally, the employee opposed the grounds of review and maintained that, notwithstanding the strained nature of the relationship, they could still go back and work with the employer. Put differently, the employment relationship had not irretrievably broken down. Now, at the Labour Court, the court found that the arbitrator's finding in regards to the merits was reasonable, and the merits being the fact that the employee was innocent of all the charges. That wasn't in dispute, right? However, the Labour Court said it had a problem with the reinstatement award because it was clear, right, from the facts before the arbitrator, it was clear that there was a strained relationship between the employer and the employee. And again, right, as dictated or illustrated by the Labour Relations Act, you can't reinstate an employee when there's a strained or intolerable relationship. So the court said that the reinstatement order was unreasonable, right, and instead replaced that reinstatement order with compensation. Now, where we are now is the Labour Court has now handed down an order saying that the dismissal, right, is substantively unfair, right? But the remedy available to the employee is compensation. Now, the employee appeals this, right? And again, the application for leave to appeal was late, and he had to be accompanied by a condonation application. But what was interesting about the employee's leave to appeal is that they didn't appeal the Labour Court judgment. What they did is they actually tried to enforce the judgment, and the circumstances of the employee's situation might put things in context. So the employee was effectively unrepresented, right? Didn't have legal advice. And instead of appealing the Labour Court judgment, what he did is he tried to enforce it. He basically went to the Labour Court and Labour Appeal Court and said, I want to enforce this judgment, I want to get compensation, right? As opposed to, I don't agree with the compensation order, I should actually have been reinstated. Now, this was a big thing for the employee's case, because essentially what the Labour Court said that is, well, if you're not challenging the Labour Court judgment, you're essentially abiding by the decision of the Labour Court judgment. And in law, we call this the doctrine of preemption. And the doctrine of preemption essentially says no person can be allowed to take up two positions inconsistent with one another. You've got to choose one. So you're either appealing this judgment, right, because you disagree with it, or you're enforcing it. And then in circumstances, the employee had enforced the judgment, and the court said that it would not firstly ground it wouldn't grant condonation, and also it refused leave to appeal based on the prospects. Now, the employee then petitioned the Labour Appeal Court, right? Again, this petition was late, and the grounds of the petition were this. The employee submitted that the Labour Court misdirected itself, right? The employee submitted that the Labour Court did not afford the employee an opportunity to present evidence or to answer the question of intolerable relationship. And further, the employee submitted that as a layperson, they did not have any knowledge of the doctrine of preemption. And again, I suppose in the circumstances, you can kind of have a bit of sympathy or be sympathetic for an employee in that situation. These are legal principles that one wouldn't ordinarily understand. And this is basically what they were putting forward at the Labour Appeal Court. Now, the Labour Appeal Court granted condonation. As I said initially, the petition was late, but dismissed the appeal because it lacked prospects. The employee, now having exercised, I imagine in their mind, was every possible resource, then finally sought relief at the Constitutional Court. But before we get to the Constitutional Court, perhaps we can pause and just, think about where we are, right? We have a situation where parties have admitted that the employment relationship is strained, right? And we have the Labour Relations Act that tells us that you cannot grant reinstatement when the relationship is intolerable. Is there any indication, or perhaps anyone in this room can probably take a jab of what the Constitutional Court perhaps said, right? So the Constitutional Court is faced with an issue here. It says, okay, well, the employee is innocent of all the charges against them. They didn't commit any misconduct, right? But the parties have submitted that they have a difficult relationship. Do you think the Constitutional Court can order reinstatement in those circumstances? It can? Even when the relationship is sour? So you're an employer, right? You've just fired somebody. You've charged them with misconduct. They lied to you. They were negligent. They can't do their job. They're gone, right? And they come back, and the arbitrator says they must work for you, even though you don't like them and the relationship is sour. Are you saying yes? They can? Well, let's see. Well, the Constitutional Court had to deal with this matter, and essentially, the employee submissions were this. Again, right, his application to the Constitutional Court was late, 213 days late. He justified the lateness of the referral on the fact that he was unrepresented. It was during lockdown. Obviously, COVID suspended a lot of things, and essentially there was no legal assistance. But he also had to establish jurisdiction for the Constitutional Court. As you know, you can't just refer anything to the Constitutional Court. And how he tried to establish jurisdiction is by raising the fact that his matter raised important constitutional principles. And the constitutional principles were the right to employment, right, or employment security, or security of employment. And again, this right is codified in Section 23 of the Constitution, which provides people or employees with the right to fair labor practices. The employee's biggest submission was this. He said that, look, I was charged with misconduct and I was found innocent. Right? I was found innocent. And if I'm found innocent, there cannot be an irretrievable breakdown of the relationship. If I was found guilty, however, then we can talk about the fact that maybe we don't like each other, maybe there's an issue in this relationship. But because I was innocent, there cannot be an irretrievable breakdown in the relationship. Another thing that he raised, employee, was that the employer did not plead in their papers anything about the state of their relationship and that it was intolerable. So it wasn't for the labor court to actually go into the relationship of the parties. Again, he considered that the relationship and the state of the relationship was based on the outcome of the guilt. In the circumstances, he was innocent, right? Lastly, he also said that he did not understand the doctrine of peremption, and he did not preempt his right to appeal, right? And even if he did, the interests of justice dictate and demand the Constitutional Court to put that aside and hear the matter, because he did not know, essentially, the implications of enforcing the labor court judgment. Now, the municipality submissions were this, right? They said that, look, employee preempted the rights to appeal. There was no prospect of a viable relationship. There was no prospect of a viable relationship. The relationship was intolerable from the employer's perspective. And the labor court did not raise this on its own accord. This was actually before the labor court, as part of the record, the arbitration record. And even if the labor court did raise it on its own accord, the relationship and analyzing the state of the relationship is important to actually determine whether reinstatement can be granted in the circumstances. So there's nothing wrong that the labor court did in the circumstances. Right. Now, the Constitutional Court's findings. Essentially, the Constitutional Court said, look, we have jurisdiction in terms of Section 23, subsection 1. There's a right to fair labor practices, right? And this essentially goes to the heart of the fair labor practice, right? And the right to security of employment. So we do have jurisdiction. They granted condonation, again, because he was a lay person and there were good prospects of success. Now, the court said that in terms of the doctrine of peremption, right, which I think, there we go, yes, number 3 there, the doctrine of peremption. It said that, look, even though the employee tried to enforce a labor court judgment and should have actually appealed it, right, the employee was a lay person. Right? They were a lay person and in the circumstances did not know what they were doing. So the interests of justice and policy considerations require the court to overlook the shortfall. The court went further to say that the labor court did not raise intolerability or the status of the relationship by its own accord. In fact, this was before the court in the arbitration record, but also it was important for the court to look at the status of the relationship in order to determine whether reinstatement is viable. The court held that even when an employee is innocent of all their charges, right, it's still important to look at the status of the relationship. So the status of a relationship is not always tied to the employee's innocence, right? It's a separate question that you need to answer, and it's a separate analysis that one needs to go through. However, where the employee is innocent, right, the threshold is very high to show that the relationship has irretrievably broken down. So you can have a irretrievably broken down relationship, but the threshold is extremely high, and an employer has to show that the relationship has actually indeed suffered. What serves as a defense or a mitigating factor on the part of the employee is the fact that he was innocent. Now, the assessment of whether a relationship has broken down irretrievably is an objective one, right? So you can't take the say-so of an employer or the say-so of the employee. You must actually look at the relationship in totality and ask yourself, look, can these people continue to work together, right, or can they not? And a very important thing to understand about this case is that it drew a distinction between a difficult relationship, right, so a difficult or strained relationship, and an intolerable relationship. Now, in the employment workspace, right, I can imagine we don't get along with everybody, right? And you will always have a difficult relationship with somebody, but doesn't mean you can't work with them. Doesn't mean it's intolerable or it's irretrievably broken down. In this case, it was difficult, it was strained, but the parties could work together. And again, the fact that the employee was innocent of all the charges, right, was his saving grace. And it further strengthened the argument that, in fact, there wasn't nothing material to make a court not reinstate the employee in the circumstances. So the court basically ordered reinstatement and back pay, right? But the back pay was limited to two things, right? The first thing was this. The court looked at the fact that it was a municipality and it didn't want to unnecessarily pressure the public purse by granting a significant or exorbitant back pay. So they had to limit it in accordance or in proportion to the delay. So you would have noted that after the labor court process, there were significant delays, right, in the hearing. And these delays were attributable to the conduct of the employee. So the employee cannot benefit from those delays, right? So they essentially said, okay, look, we will reinstate you and you'll get back pay, but the back pay is calculated from the date of your dismissal to the date of the labor court judgment. Anything after that, you can't get because of the delays which are accountable on your behavior. And again, the back pay was also limited to the amounts the employee had already received in terms of compensation from the labor court judgment. Right, so what are the lessons, right? If there's anything you can take away, if you just woke up now, this is something you want to listen to, okay? The lessons we can take away is this, right? Reinstatement is a primary remedy, right? That's what employees want, and the Labor Relations Act actually provides for that. If an employee is innocent, right, of the charges preferred against them, that will count in their favor in showing that the relationship isn't irretrievably broken down. It doesn't mean it's not, right? But it will definitely count in their favor. And as an employer, you need to lead significant evidence to show actually the relationship has irretrievably broken down. It's also very important to be aware that a court will not take the say-so of the employer only. So just because you say that the relationship is broken down doesn't mean it is an objective assessment. And essentially, that concludes our case. Before I go to the next one, I don't know if there's any questions, anything we want to discuss. Anybody? Yes?
Should I have a mic?
I can hear you, but I don't know if the guys remotely can.
There's a principle that I just want to, not so much test,
yes,
but just to get a confirmation on. And that is the test for the relationship breakdown is much higher when the outcome is that you are not guilty. And the test is lower when the outcome is that you're guilty.
Yes. So, yeah, carry on, sorry.
Okay. And contextually, I know the principle that every case must be heard on its own merits still applies generally.
Yes.
So there's no middle ground. Is the middle ground the substantive fairness, or is it both the substantive and the procedural? So can the court go further once it has inquired on that threshold and also inquire as to whether, on top of having on top of claiming that there's a relationship breakdown, when an employee is innocent, did you actually follow the procedure? Or is it relied upon that because the employee hasn't mentioned that and therefore that aspect becomes obsolete?
Sure, all right. So, yeah, thanks for the question, by the way, it's a good question. So, essentially when an employee is dismissed, right, there's two things, as you've correctly identified. There's the procedural fairness and the substantive fairness, right? So the procedural fairness goes to the procedure, right? The example that I made is following the correct procedure disciplinary process. If you dismiss somebody, and they might have done the worst things imaginable, maybe they're dead guilty, right? So there's good reasons for dismissing them, but you didn't follow correct procedure, that dismissal is still unfair. And we call it an unfair, procedurally unfair dismissal, right? And then the substantive fairness goes to the reason, right? So the charges in this example, right? So the person is, the charges against them is insubordination, misconduct, whatever it is, right? And if you can't prove those charges, right, but you still dismiss that person, then we call that a substantive unfair dismissal, okay? It's only when it's a substantive unfair dismissal when you can order reinstatement. So if it's a procedurally unfair dismissal, right, but it's substantively fair, the only remedy for an employer, the only remedy for an employee, right, is compensation, right? That's still, yes. So it's a separate test, right? The compensation is a separate test, and then the substantive fairness is a different test. And now if we're looking at whether we want to reinstate them again, right, we look at the relationship. And if we can't, you'll see I said section, I think it was 193, it talks about the exceptions of when you can't reinstate an employee, right? And those exceptions would be when the relationship has suffered, okay? And in that case, you do compensation, right, because you can't do a reinstatement. Yes?
Isn't it that perhaps one of the key problems that the municipality had here is that even at arbitration level, the applicant had conceded to the strained relationship, that the relationship was sour, and perhaps the fact that then the labor court sought to interfere with the arbitration award, was on the basis of the evidence that was before the court. And hence the court had said, you can't then order a reinstatement where even the parties themselves, agree that our relationship is bad. This relationship is actually almost at the point, the municipality argues that it's intolerable. The employee says it's a very strained relationship, it's sour. And I'm taking this from the point that on the other hand, where it is the employee that argues the intolerability of the relationship and therefore claims constructive dismissal. You get me? The courts have always actually leaned on the side of the employee, because as the employer would always go and say, but you just resigned out of your own accord. But then if the employee claims intolerability of or the irretrievable breakdown of the relationship and then claims constructive dismissal, in most instances, as the employers, we find ourselves in the back foot and end up getting more, having to pay all sorts of monies. Now, that's why I've got a slight problem with the manner in which the Constitutional Court then approached the matter. I see now that it becomes the new law, that all of a sudden, the fact that both parties have agreed to the difficulty of the relationship does not make it intolerable. What is it that then an arbitrator or even the labor court must then do to get to the point of saying that you've met the threshold? When the parties, in the evidence that is before the court, it says that they both agree that there is a strained relationship, and therefore, why can't I as the employer then simply say, no, but you can't reinstate? What is this threshold that I must now meet when even you have agreed that there's a problem with the relationship? I have a serious problem with how the court then gets to the point of saying, set a threshold, but that does not actually stipulate what are these requirements of that threshold.
Yeah, so look, that's a good point. And just to let you know that you're not alone, the labor court essentially, said what you were saying. But one of the things, that I think directed the Constitutional Court to its finding is distinguishing the difference between a strained relationship and an irretrievably broken down relationship. And naturally, you can make a difference, right? So the municipality said it's irretrievably broken down. The employee said, look, it's difficult, it's strained, but I'm willing to go back. Now, that argument, coupled with the fact that they were innocent, makes it look like, you know what, this relationship isn't as bad as the employer is saying. Right? So that's basically, you know, the perspective the court took.
Zawadi, the tendency is for labor relations practitioners to, when they are closing their cases, pick on this issue of strained relationship as a reason why an employee cannot be reinstated or re-employed. Now, at what stage should that test be canvassed? Is it at the level of leading the evidence, or is it at the level of closing the case for that a particular argument to have weight for consideration and validity when it is tested?
So that's a fantastic question, right? And this is something we face a lot of times. So essentially it's a strategic call, right? And what we do normally is we lead it as evidence. And in fact, you should lead evidence. So you're not only leading evidence to say this person's guilty of the charges, but you're also saying the relationship is broken down, right? So if it's a disciplinary hearing, right, if it's an arbitration, wherever it is, you want your witnesses to come through and say, this is what's happened, right? This is what the employee has done to contribute to the strained relationship, and as an employer, there's no way we can accept them coming back. So you want to lead it during evidence and also during your closing arguments, right? So that's what we would do, yeah. Yeah, fantastic. Anything else? Nobody online? We good? All right, perfect. Okay, so now we're going to go to the next topic, right, which is also quite topical, right, and it's something that I imagine as an employer, as a municipality, you will definitely deal with during the course of your business. The question we'll be considering is, when does an employment contract revive once a court has ordered reinstatement? And the case that's going to be dealing with this is the Labour Appeal Court decision of Hba and others versus NIDA Transport. Just to briefly set out the context here, the facts of the case are this. So NIDA Transport operate in the logistics industry, and the employees were employed as their drivers. And in about 2008, the employees were dismissed for misconduct, which included participating in a unprotected strike and also for speeding, which I imagine is quite material if you are a driver. Now, the Labour Court held that following this dismissal, the Labour Court held that the dismissal, right, was substantively and procedurally unfair, right? And the Labour Court then ordered reinstatement and back pay. But how the Labour Court did it, in their judgment, they said that the reinstatement will occur from the date that the employees were dismissed, right, to the date they were required to report for work. And in the Labour Court judgment, the court said that you are required to return to work within 14 days of the judgment. So the judgment was very clear when the reinstatement should take place. Now, of course, as an employer, right, you would be aggrieved by a decision like this to reinstate your employees after you've dismissed them. So the employer applied for leave to appeal, which was refused. They petitioned the Labour Appeal Court, which was also refused. At the same time, they petitioned the Supreme Court of Appeal, which was refused. And finally, they petitioned or rather they applied to the Constitutional Court for leave to appeal. And this was refused on 18 November 2014. So, right, in a nutshell, the appeal process, right, was finished as of 18 November 2014. The appeal process has lapsed now, and the Labour Court judgment, which granted reinstatement, could now be enforced. Right? And simply put, because you can't appeal this judgment, the appeal process has lapsed. Now, in about 2017, the employees tried to tender their services, they tried to report to work, they also tried to claim their back pay or arrear wages, and the employer did not essentially give them the back pay. So what they did is they instituted proceedings at the labor court, and their claim was essentially under Section 77, subsection 3 of the Basic Conditions of Employment Act. And the claim, or the Basic Conditions of Employment Act, basically says that the labor court has jurisdiction to hear any matter concerning a contract of employment. Right. So what the employees were doing is that they were enforcing the employment contract, right, to reinstate themselves, number one, but also to claim back pay. Now, at the labor court, the employees argued that they were entitled to back pay and arrear wages, right? And again, because the appeal process ended on 18 November 2014, that's when the labor court judgment, which effectively reinstated them, was now effectively in force. Now, following the initial labor court order, which ordered reinstatement, some of the employees, as I said initially, tried to tender their services, right? They tried to return back to work. The employer disputed which those employees were, right? But what was clear is some of them tried to return to work, right? But the employer refused to accept their services, right? And in doing so, they tried to appeal the labor court judgment, as we said, which was unsuccessful. So the labor court judgment was suspended during that appeal process, even when the employees were trying to get reinstatement. Now, the quantum in this matter is quite significant, right? Essentially, what the employees were entitled to for back pay was approximately 19 million rand. Well, close to 20 million, actually. And notwithstanding this, right, notwithstanding the quantum and what was due to the employees, right, the labor court dismissed the referral in terms of Section 77(3) of the Basic Conditions of Employment Act. And the simple reason for dismissing this was that the employees said, or rather the labor court said, the employees followed the wrong legal process. The court said that their claim to back pay and reinstatement was not a contractual claim and essentially was founded on the labor court judgment, right? Back pay can only arise, right, when the employment contract is revived, right? And the reinstatement order doesn't revive the employment contract. What is required in addition to the reinstatement order is the employees must tender their services, right? In other words, they must report for duty, and the employer must accept that work. If those things don't happen, there cannot be a revival of the employment contract. The judgment itself does not revive the employment contract. Now, the court said that the correct process, right, if your claim is not contractual, and in essence the employment contract doesn't exist, the correct process is instituting contempt of court proceedings against the employer, right? And that's the only way, right, you can try and get reinstatement. That was the labor court's judgment. Now the judgment, essentially providing reinstatement, is only directing the parties to perform in terms of the employment contract. It doesn't revive it. So it directs the employees to report to work, as I said. It directs the employer to accept that work, right? And once those things happen, only then can the employment contract revive. Now, notwithstanding several arguments on the employee side, saying that the labor court judgment restored their contract, and that they tried to tender their services, right? And even when they tendered their services, the employer refused it. Notwithstanding those arguments, the court said, well, look, if the employer doesn't accept your services, there cannot be an employment contract. The employment contract terminated when you're dismissed. The judgment doesn't or cannot revive something that the parties don't revive themselves. The employees, aggrieved by this, appealed the Labour Court judgment, which dismissed their referral in terms of Section 77(3). Now, at the Labour Appeal Court, the court was faced with two issues. Right? The first issue was, does the employee's claim depend on restoration of their contracts? And when were the contracts of employment restored, if at all? Now, the employer's arguments, and I'm sure you can imagine, were very consistent to what the Labour Court initially said. They basically said that the reinstatement order does not revive the employment contract. The employment contract can only be revived by the party's performance. And the employer relied on a constitutional court judgment. The court in NUMSA versus Hendo Mining essentially said that employment contracts only revive when services are tendered by employees, right, and those services are accepted by the employer, right. The order itself does not reinstate the employment contract. It just directs the parties to perform in terms of the contract. It directs the employee to tender, it directs the employer to accept. If none of that happens, there's no employment contract. And the court, again, Labour Appeal Court, essentially amplified the fact that the order does not restore the contract. Now, the court highlighted that if the employee or if the employer fails to accept your tendering of services, the only thing an employee can do in the circumstances is institute contempt of court proceedings. And essentially, there is no claim in contract because the contract doesn't exist. Now, the reasoning of the Labour Appeal Court was this, and this is how they basically justified their stance. It said that essentially what you're doing is you're giving the employee an election, right? An employee must elect what to do. Just because we reinstate you and we say you must go back to work doesn't mean you have to. Doesn't mean you must, right? You must exercise that election in accordance with the judgment, and you can't rely on the judgment to revive your employment contract. Perhaps we can just take a moment or two to consider where we are, right? We have a situation, and I'm sure you're going to come across as an employer, where you've dismissed an employee, right? It looks like you know what I'm talking about. You've dismissed an employee, right? And the court has ordered reinstatement. Now, the court says that the reinstatement order doesn't revive the employment contract. So an employee cannot exercise their claim in contract. They can only institute contempt of court proceedings. Now, the problem about this approach, or at least what I found was problematic, was if this is the approach that we're taking, essentially there's no relief for an employee. And I'll tell you what I mean by that. If the only relief is to approach the Labour Court and institute contempt of court proceedings, we need to understand essentially what that process entails. If as an employer, I refuse to obey a court order, right, I'm essentially in contempt. And an employee can take me to Labour Court and institute contempt of court proceedings. But in those proceedings, the court can do one of two things, right? Either does imprisonment, right, so the directors of the company go to prison, or you get a fine. And that's it. So there's no relief essentially for an employee, right? Because the claim is not in contract. And in this circumstance, if you're an employer and you're trying to escape a 20 million rand back pay order, 20 million rand back pay order, you might just want to take that risk. You might want to take the risk, and it's likely that the fine that will be imposed against you will be significantly lower than the back pay which you're required to pay. So that's essentially what we're dealing with here. Right, the lessons we can take away, right, from this court and the judgment is number one. Reinstatement does not revive an employment contract, okay? It does not revive an employment contract. An employer, it looks like it, doesn't have to accept an employee who tenders their services, but of course, if you do that, you risk contempt of court proceedings. And in this situation, you might want to throw the dice, take a risk, don't know, it's up to you, but legally, you can refuse, and if you refuse, there's no revival of an employment contract. And the important thing again is the claim is not based on contract, it's based on the judgment itself. Yeah. Any thoughts, concerns, queries?
There's something I'm missing.
Yes.
And please help me close the gap.
Sure.
If the Constitutional Court's decision is that the order does not revive the employment contract.
It's a labor appeal court.
Okay, yes.
Yes, sorry, yes.
So is the likelihood that that finding may in fact over time be considered in light of what you've said, the problematic nature of the consequences, unintended or otherwise, that it may trigger? Is that likely to happen? That's my first question, and I'm not saying I'm not asking a definite question, but I'm really trying to think, because if it was made by the Labor Appeal Court, there's possible grounds that it may be taken, maybe not for purpose of this matter, to the Constitutional Court, with the view, obviously, that kind of ruling is found wanting at that level of decision making. That's the first question I want to canvass with you. The second one, probably not a question, a comment. If the order does not revive the Constitution, the contract, what is implied? Is it implied that before the employee tenders his or her services and the employer accepts the tendering of these services, is the implication that there is no relationship in that gap? Because I assume that the tendering of services is in fact a process in itself. It is not something that happens in real time, because tendering your services means you receive the order, you advise what it means, then you make yourself available to report to work. Is that a very proper way of interpreting what it could also conceivably mean? If it sounds like on the order itself, effectively you've got nothing until there's been tender and accepted.
Yeah. So thank you. Those are very, very good questions. Okay. So the first one, what makes this problematic? So actually, you were right. So this is a Labor Appeal Court judgment, right? But the Labor Appeal Court relied on the Constitutional Court, right, to arrive at this judgment. So this has been heard at the Constitutional Court. What hasn't been heard, all right, or been advanced, is the problematic effects or implications of the judgment, right? And again, this is because we're brainstorming, right? We were thinking out the box, this is creating problems. At the time, the judgment or the judge never really considered these things. I'm pretty sure, right, that this will be a problem, and as it stands, it's more than anything something that an employer can now use in their ammunition, right? Not so great for employees. Not so great for employees. But to answer your question, it's possible. Someone would probably take it to Constitutional Court, challenge it. I'm pretty sure it won't be an employer though. It'll probably be an employee. And just your second question, what does a judgment mean, right? Again, it's not clear what it means, because if we take it step by step, right, the person is dismissed, okay, no contract, okay? Effectively, there's no contract, right? It's over. So there's no, there's no contract because it's been terminated, right? It's, as I understand it, it's once the court says, or how it should be in my understanding, is why it says that, you know what, this dismissal was unfair. Once it says that, that should revive the employment contract. But the court, it doesn't. It says they need to perform. They need to perform.
I must thank you for this one. I must thank you for this one because, I mean, traditionally, once we've got an order that says reinstate, as employers, we've always taken that we are therefore legally bound to reinstate, you know, unless you appeal and appeal and appeal, you know, and you tell the person that you can't come back until I've exhausted all my legal recourses. But once we've accepted that, you know what, there is an order, and the order says reinstate. You say, yeah, well, we've lost. The person tenders their service when we've always accepted it. You know, we've never really actually considered this. But it is problematic. It is problematic because it means that as an institution, there's no finality to the issue, you know. Because even if indeed, I mean, an institution like Kohlrabi would be jailed. It will be the city manager that will be jailed if indeed it gets to a jailing situation. And in most instances, the city manager is not even directly involved in these determinations. If there is a contempt of court application, the second respondent is always the city manager, you know, not the head of HR, not the director of labor relations, who are the people that actually sign that you get out of here, you know. But also even in contempt proceedings, you know, what if now there's a defense that I submit as an employer, and I'm like, no, but I'm not in willful default, deliberate and willful default of the order. I've got problems with the order. I can't implement it, you know. Then boom, I raise that issue that we've just discussed now. That the relationship between me and this person is non-existent, you know. That I simply can't take him back. You know, taking him back will create a massive problem in terms of the institutional integrity. You know, this guy has done 1, 2, 3, and beyond the charges. Because sometimes, and I'm thinking of my own situation, because I've got a gentle person, you know, I won't say man or woman. I've got a gentle person whom we dismissed, you know, and then upon the dismissal, as we were busy with the arbitration proceedings, this guy committed other acts of misconduct, even though I was no longer my employee. You know, he convenes all sorts of meetings. I mean, I'm a broad municipality, convenes all sorts of things and talks about everybody in all sorts of language. And we've got it on video. Now all of a sudden, even if I was to get an order that says reinstate him, because the charges that I dismissed him for have not been proven, I'm trying to link the two cases, you know, but still I can't reinstate him. And I show to the court in a contempt of court application that, but the relationship with this person can never exist. Fine, I'm not in willful and deliberate default of the order itself, but there's an impossibility that I raise as a defense in the contempt proceedings, which has nothing to do with the misconduct proceedings at this particular stage. You know, you see now it makes this thing even more complicated. And he loses, this applicant or this employee loses the contempt application, you know, because and I've faced quite a number of contempt applications. Again, the threshold for the applicant is much higher than people think. This is not the Zuma case, you know. So what then? You know, am I now having a free rein as an employer to simply say a guy whose award says reinstate? I simply don't accept it. Let's fight it. Let's fight it on. And what happens to this poor fellow? No, because I can drag it for another 10 years.
Yeah, so I mean, thank you for that. I mean, that's the problem. The problem is there actually isn't recourse for the individual, the employee themselves, right? It's only punishing the employer. But just to go back to your point, so if you raise an impossibility of performance, so in this case, I think you were saying that, look, the relationship is irretrievably broken down, I can't reinstate that person. As I understand it, that won't actually help you get away from it, because that's something you would have raised at the labor court, right? That's something essentially you should have raised at the appeal process, not to defend contempt of court proceedings. I think one of the defenses in contempt of court proceedings is to say, I'm actually not in willful default because I have complied, right? Or I am complying, or whatever it is. So I don't know 100%, I don't think it'll help you to say that, look, I just disagree with the court order, because essentially you're appealing it and you should have done a different process. So what's most likely going to happen is in the contempt of court proceedings, you're probably going to have to take it and say, look, okay, I'm in willful default. Okay, let me take my punishment. It's the fine or imprisonment. And who knows, courts might get a bit smart. They might be like, okay, look, employers are taking this approach. They might now amend, the rules in the Labor Relations Act regarding contempt of court proceedings, and might even fine you more significantly than the actual back pay. But my concern again, it doesn't give recourse to the employee. That's the problem. But yeah, anything else from anybody? Okay, perfect. Right, so we've got one more case. We should be done. We should be done in 10 minutes. Yeah, one more case. This is actually quite a juicy case from a facts perspective. So I think I saved the best for last. So the question we're going to answer is, can employees be dismissed if they are found to have common purpose? And the court that dealt with this question was NUMSA versus Mali Pipe Systems, and this is a labor appeal court decision. So the employer in this case is in the plastic industry, right, and falls under the Engineering Industry Bargaining Council. In and around 2017, the employer proposed a wage increase of about 7.5%. The employees were, of course, dissatisfied by this. They wanted a greater raise. So what they did is they engaged in a work stoppage, which is also known as a strike. So now you've got these striking employees who are basically, you can almost paint this picture in your head already. You've got striking employees at the employer going around, demanding. They've got placards. The crowd is growing, getting aggressive. And basically, they made so many demands, and one of the demands that they were making is that they wanted to get rid of the head of HR. And the head of HR was a man named Ferdy Stefans. And during the strike, the head of HR heard the employee striking, and he left his office, and he wanted to engage with them and just, obviously discuss the issue. The employees weren't having it. What they did is they just began assaulting him, started beating him up. It got pretty bad. They threw him out of a glass window. They threw rocks at him while he was lying on the floor. They continually kicked him. And you can imagine, this is about 148 people surrounding one man, beating him up. And it got to a point where non-striking employees had to come through and try and help him. And he was immediately rushed to the hospital to get medical attention. So naturally, you can understand these employees were disciplined, all 148 of them. They were dismissed for engaging in unprotected strike and also for acting in common purpose in the assault. So there were 12 employees, which is very important now. There were 12 employees who were identified as a protagonist, so the main guys, right? And the remaining employees were basically found to have common purpose, and they all disciplined them because they had common purpose. Now, at the labor courts, the employees denied that there was actually an unprotected strike, and also denied that they took part in the assault. The employee opposed this, and what they did instead is they filed a counterclaim in terms of Section 68, subsection 1, subsection B, and that basically says that if you as an employer have sustained damages or losses during a strike, right, you can claim just and equitable compensation. And essentially the court, and that's the labor court, found that the employees rather, had acted in common purpose and in the assault of the HR manager. It labeled it as a mob attack, and that's how the court found in that regard. The court found that the employees had failed to distance themselves, right? And essentially it awarded the employer 800,000 rand in damages and losses incurred during the strike. The employees appealed this, right? Interestingly enough, it wasn't disputed that the strike was unprotected, so it was accepted that the strike was unprotected, but they disputed that they assaulted the HR manager. They said that there were only 12 protagonists, right? These 12 main people, right? And plus another 95 who had been identified through photos and video, right? So only those guys are the ones that should be dismissed. Now, it left 41 other employees who said they were bystanders, right? People who were just watching. And that wasn't disputed, whether they were acting in common purpose. Again, those 41 employees argued that there was no evidence linking them to the actual assault. The arguments that were provided by the employer were that the 41 employees, although weren't actually at the scene, they were placed at the scene through biometric systems. So I'm sure you guys have the same thing. People clock in, clock out, so you can tell where people are. They were also at the same time, when the assault was happening, they were absent from the workstations, and there was video footage that showed them participating, right, with the crowd, right, just before the assault took place. There's video footage of them participating with the crowd, and there's video footage of them participating after the assault as well. And because of this, they acted in common purpose. And now the labor court basically analyzed, right, the requirements for common purpose. The court said that you can take part in misconduct either directly or indirectly, so you don't have to actually be the person throwing the punch, right? Bystander can also act in common purpose, right? However, being part of the group is not sufficient. So there are circumstances where you're genuinely just standing there and you cannot be said to have common purpose just by being part of the group. What is required is that the person must have been aware of the assault. They must have intention to have acted in common purpose. That intention must be manifested through their actions, right, and their acts of association with the people around them. Again, the intention is inferred through people's conduct. Right, another thing that you also have to be aware of is that prior and subsequent knowledge of the misconduct is required, right? So in instances where the person isn't actually present, right, they're not present, they need to have the requisite intention and knowledge, right? If they're present, it's straightforward, right? They need common purpose, right? But if they're not present, they must have requisite intention and knowledge, and you can attribute common purpose to them in those situations. Now, the court found that it was very clear on the facts of the case that the 41 employees associated themselves with the group. In fact, they did nothing to intervene. The man was lying on the floor, being beaten, thrown out of a window. They did absolutely nothing. Although they called themselves bystanders, or even in the case of one employee who arrived just after the assault happened, they couldn't rely on that to negate liability because they celebrated the assault right afterwards. So in those situations, it was very clear that they had participated in the assault of the HR director, or manager rather. The court found that the employees could have foreseen, right, what was happening. You have this big crowd, people rioting, people, these demands, it's growing, there's aggression, there's violence, going towards an HR director, which nobody likes. You can foresee what can happen there, and nobody did anything to intervene, including those 41 employees. And this was sufficient for them to have common purpose. Right, so very quickly, the lessons again, if we're right on time. Lessons, right, to take away. If there's nothing you heard, take this away. Okay. The first one is, yes, employees can be dismissed for common purpose, right? There are requirements for common purpose. Common purpose generally unique to strike situations, right? But even in other situations of employees not necessarily striking, but the commit misconduct, you can attribute common purpose to them if they do it in a group. What's very important is you must prove knowledge and intention on the part of the employees, even if they're not at the scene. If you can prove knowledge, association, intention, you can attribute common purpose to them. And something that's also very important for employers is that if you do suffer any damages during a strike, you can receive just and equitable compensation from the employees jointly and severally. Right, just a quick recap from the beginning. Will courts order reinstatement when there's a strained relationship? Yes, very important to note that there's a difference between irretrievable breakdown and a strained relationship, right? Second question was, when does an employment contract revive after reinstatement? The order doesn't revive the employment contract. Parties must still perform to revive it. And lastly, can employees be dismissed if they are found to have common purpose? And the answer to that question is yes. And that concludes today. Thank you so much, everybody. Appreciate that. Nothing on the chat?
Can I just check with any of the other colleagues? I don't see any questions or comments in the chat. No, there's just I was actually worried that there might be and I'm not seeing them, but I do. There's just one comment from Hba Regulations. This was fruitful and good. There are no other questions. At this point.
Perfect.
I've invited participants to post questions and comments.
Okay.
If you could just, Mr. Dlamini,
Yes.
Yes, just go a slide back.
Of course. Sorry.
Pretty much the one where you are summarizing. This one the one that was affirming common purpose.
Affirming
and those requirements.
Sure.
Knowledge and I think intention. Just the one before your last one.
Which one is this
Is
one?
it coming up on the main feed?
Is it coming up?
I think it's coming up there. I think
number 6.
I think this. Yes, is this the last one?
Yes.
This judgment has got far-reaching implications for local government.
Okay.
Because we are a sector where the concept of collective action and doing things in mobilization is, for lack of a better word, a safe haven for employees. In other words, employees take a view that when they convene in unity and there's more numbers and there's local footage, that environment cushions them from any possible liability or severe consequences of their action. And I think this judgment, I think needs a lot of interrogation by practitioners on the ground, especially if such action results in incidents of the nature where you see an employee not wanting to go on strike being intimidated and possibly being assaulted, or where you see violence happening during the course of the strike action, even if that strike action may in itself be protected, and in some instances to damage of property. I think for me it's very significant in many ways, and I would hope that with the benefit of having received this important input from you in this seminar, I think we need to go back to the drawing board and refine the messaging and communication accordingly. So, especially when you say over and above that, there's also a remedy available in terms of just and equitable compensation. Yeah, it's very significant. For me, out of the judgments you've pointed out today, for me, it looms larger even the one that deals with reviving
The employment
Yes,
contract.
because we are not a firing sector.
Sure.
Yes, we fire, but we're not a firing sector, so to speak. Like
Fire shots. Yeah.
exactly. You understand my yeah. I think it's a very interesting development, and maybe a tongue-in-cheek comment for me would be. I'm reading a lot coming from the jurisprudence pipeline. When you look at vaccination, the cases that have been decided, that the court system is tightening the grip on conduct of employees. The judgments that are coming in now are a lot firmer. They are a lot more limiting in the exercise of discretion, especially the domain of discretion where you think you can do as you wish, and they've historically been escape avenues for incurring liability. I think it's quite interesting.
No, thank you for that. Thank you.
Just to add on what Rio has just raised, Mr. Dlamini, I think this matter, NUMSA, fortunately, we once had Rio, the matter that involved the dismissal of the Samoa 7 in Ekurhuleni, and we argued common purpose before Eddie Tlotlalimaj. He's now a judge in the Labour Court. He was a bargaining council senior commissioner at the time. And one of the things that we raised, and perhaps for me it's important that the Labour Appeal Court now has clarified the requirements of common purpose, especially in the Labour context. Because totally much out of the 7 people that were dismissed, reinstated 2. They were present.
At the strike?
No, it was not a strike. It
I'm
was a disciplinary
sorry.
inquiry.
Yes, okay.
It was a disciplinary inquiry that was held where we had charged 7 shop stewards of Samoa. And then during the course of the disciplinary inquiry, there was an assault on the presiding officer.
Okay.
You know, there were 2 individuals who physically manhandled the presiding officer. There's an individual who went to block the door so that no one gets out and no one gets in, you know, to prevent the assault. There were 2 individuals who incited Mshai, and as a result, those 5 individuals, Tlotla Maja said they actively participated, you know, and the other 2 individuals who were the then regional chairperson and deputy regional chairperson, and the actual leaders of the union at that time, you know, were found not to have actively participated, even though they were there.
Oh, they were present.
They were present during the assault. And they did nothing to actually come to the rescue of the presiding officer. Now I get what the LEC now is saying, that if indeed we are present, we are there, we had prior knowledge, and the fact that even if you had arrived post and you didn't actually come to any form of rescue or any action that so shows that you are distancing yourself from the common purpose of the others, then you are part of it. You know, it changes. You know, because quite a number of instances, like Rio is indicating, you would have a situation wherein people simply say, you know what, yes, they did it, but I was not part of it. I was there, but I was not part of it. You know, we are faced with the dismissal that we effected just before COVID started of about 51 individuals where they had attacked trucks of service providers because they were claiming that the municipality is outsourcing, you know. This would highly assist us, because one of the things that has been raised there is to say, as much as we have evidence that our trucks were in the vicinity of where the attack occurred, you know, and we don't have direct evidence of actual individuals, but the service provider says it's your trucks. People that emerged from the trucks of the municipality were actively involved in the assault of the trucks of the service provider, you know, and we dismissed everyone. All the crews that were in those trucks, we dismissed them. Fortunately, we're still in arbitration. Thank you. Yeah. We've got no Numsalve on behalf of Dludlu.
No, yeah, you've got this case now.
Yeah, thanks a lot.
No,
At least
no,
these
thank you.
principles
No, of course,
are
of
very
course.
sound for us, and indeed, like Rio says, we have to, as labor relations practitioners in this sector, because our sector, when it comes to strikes, is perhaps one of the most violent striking sectors in the country. And we have to educate our employees that if you act like this, we will deal with you, and your union that actually arranges the strike.
Of course. And just to add on to that, I think NUMSA was ordered to pay also the compensation, the just and equitable compensation, because it was against all the applicants, and of course they are representing them. So that's something you can also use, yeah. All right. Thank you so much, everybody. Thank you. And, yeah, have a good afternoon. All right, thanks, sir.
Thank you so much, ladies and gentlemen. I think we've dealt with the questions, the Q&A. So I wanted to close with something, but it's fine. I'll open with it tomorrow. So I think that's it. Chief, we are done for the day.
Yes, I think let's say goodbye to delegates properly and just affirm the start time.
Awesome.
For any other discussion, we can be off record.
They're still on the other side.
Well, what is the protocol? Are they going back into the common platform? Okay. Maybe let's keep the platform open so that we are closing properly when.
Yeah.
When they're
Okay. Awesome.
Maybe you can just give that indication.
Sure. To all of us who are joining on virtual, please, at this point in time, we're just waiting for the other breakaway room to finish. As soon as they finish, we'll come and close nicely. Thank you.
Just give us maybe a couple of minutes.
Just a couple of minutes, please. We'll come back and close properly. I see you don't want, eh? You don't. You don't want, eh? Don't want us to close, do you? You don't want us to close. You really want.
There's only one lady.
I'm able to see what's
You start very slow. Where is the media? 10 seconds they're done as well.
Yeah, they will automatically be moved. They are done, they will close.
Okay.
5 seconds.
Okay.
How much time is allocated?
What time are we starting tomorrow? What time are we starting tomorrow? 9.
Okay, they are open.
We want to see everyone.
Are we all back? Thank you so much. Ladies and gentlemen, we are closing today's day, and it was a great success. So tomorrow we will start exactly at 8 o'clock, and please let us be all back here tomorrow, and we are closing the seminar tomorrow. Thank you so much for taking all the time to be in this seminar for day one. Thank you. Have a great one. See you tomorrow. Thank you.